So then 3 weeks later, the Israelis announced myocarditis. So I went back and they said, you know, 6 months to a year, and I've had patients, and I take an EKG, I see it, but it's pretty much down to about 85%. You know, nobody knows what my original cardiac output is, so I'm going totally here. But I can tell you I'm at 85% of what I was in terms of climbing. I know that whole thing.
Rob, when I'm ready for slides, I will say yes, that's perfect. Perfect.
It's just going to go right. I did. It's nearly, I mean, once in a great while, absolutely had to get some petered out. It might have been COVID in January. I just stayed away from it. I didn't get tested. I just got sure.
Okay, good morning, everybody. My name is Max Melman. I'm a professor of law here at Case Western Reserve University, co-director of our Law Medicine Center, and we're going to begin with remarks from our dean, Jessica Berg.
All right, good morning. Actually, I'm really doing the introduction to hand it back over to Max, who is phenomenal, as you know. This is our annual Law Medicine Symposium. Max is one of our co-directors of our Law Medicine Center, and usually plans some really phenomenal topics. His research and his work is always something that's very cutting edge, and this is really no exception. I know there are a number of people who have joined us remotely. I appreciate all of you who are in person. We get to do so little of this in person that it's always a pleasure when we can see people. I also know that you'll have a number of panels throughout the day. I'm going to pop in and out as I can. It is our admitted students day today, so to the extent that you want to avoid the prospective students, stay on this floor. They are all upstairs, and all of their events are going to be upstairs. But I'm going to be popping back and forth between different things. If you have questions about anything or any issues, please feel free to let me know. But otherwise, be prepared for a really phenomenal day of speakers and discussions.
Thank you, Dean Berg. So I would like to thank a number of the people who have made this possible, beginning with Dr. Robert Batanti, who, together with me, really put this together. Dr. Batanti will tell you more about himself because he will be giving the first formal presentation. But he is a student of mine, actually. He's pursuing a Doctor of Juridical Science, which is the PhD equivalent for lawyers. And he is working on this topic for his thesis. And so it was from that collaboration that this conference emerged. I'd also like to thank Sher from the Cooperative of American Physicians, who has co-sponsored the conference and will be making a formal presentation later today. I would like to thank, but I'm not going to do so individually, our so-called audience experts, a number of whom are here in person. Additional experts are participating virtually, and they will be responding as they see fit, but not making formal presentations. And I'd like to also thank Patty Harbold, who is our Director of Academic Centers. You may have met her outside if you're here in person, helping with registration. All of the logistics that go well are due to her. All of the logistics that don't are due to me. So she's phenomenal. My colleague, Catherine Van Tassel, is a professor of law here, and she will be helping with questions from the participants who are participating virtually, of which I understand there are quite a few. In addition, Rebecca Smith is there. She is a postdoctoral fellow in our health law program, and she will be also assisting with logistics and taking notes. And one of the goals of this project is today actually is to produce a report, if you will, a kind of a white paper. Hopefully we will come up with some good suggestions for how to move forward. And Rebecca will be helping to write that report with me. We also have our AV person, Rob Combs, who's done a great job of putting together the technical the technical requirements. In the afternoon, my colleague, Professor Laura McNally-Levine, will be substituting for Professor Van Tassel and taking over her role this afternoon. I want to go over the agenda just briefly. So what will happen is that we will have formal presentations. If you have access to the agenda, you can see them. We've left quite a bit of time for Q&A, for discussion afterwards. After each of the formal presentations, we have some breaks, you'll be glad to hear. And then we will also have discussion at the end of today and then tomorrow morning about what have we learned, where do we go from here. I have to make a formal declaration, as do all of the speakers, that I have not had any relevant financial relationships with ineligible companies. I'm not sure what an ineligible company is, but maybe the Russians. So if you have questions, if you are a remote participant, you can go to Q&A, right, and you can type in a question. And Professor Van Tassel will be monitoring the questions from remote participants, and to the extent possible, we will bring your questions to the speaker. But forgive us if there are too many questions and we run out of time. I apologize in advance. Those of you who are in the room, if you have a question, please simply raise your hand. Okay. Any questions about logistics? Okay. If you could bring up my slides, Rob. How many of you have read my 2015 article, Can Law Save Medicine? Okay. For those of you who haven't, let me give you a little background. Wait, let's get the slides up. Hold on. Okay. And I think I can do this, right? Yes. Oh, wait, can you do full screen for us, Rob? There we go. In 1847, 250 physicians, all of them men as it happens, gathered at the Academy of Natural Sciences in Philadelphia. And the purpose of their gathering was to transform the practice of medicine. Prior to that time, there were some people who called themselves physicians. They were largely attached to universities. Their patients were largely the aristocracy and the well-to-do. But aside from those providers, medicine, healthcare was provided by a variety of healers. There were herbalists, there were apothecaries, there were midwives, there were clerics. Religious people did a lot of provision of medicine. There were barber surgeons. There were folk healers. And they were, dedicated to their to the benefit of their patients to an extent, but they were also not particularly knowledgeable about the science behind medicine. For example, there was Samuel Hahnemann. You may have heard of him. He believed in what is called, or he promoted what is called homeopathy. The idea behind homeopathy is that like cures like. So, for example, if you have a patient with a fever, what you do is you give that patient something that will create a small fever. And the idea is that the body will sort of switch its focus from the big fever to the little fever. The big fever will dissipate and the patient will get better. We still have sort of vestiges of this today, right, Dr. Letterman? I mean, immunization is arguably a kind of like homeopathy in that sense.
It's a terrible argument.
Terrible argument, yes. We had Samuel Thompson, who was a New England person who believed that all ailments stemmed from imbalances in air, water, fire, and earth, and that you could be a physician if you followed his tenets and gave him a $25 franchise fee. The so-called orthodox or mainstream practitioners were also rather interesting. Here's one of the leading ones, Benjamin Rush, a physician who was a signer of the Declaration of Independence. Rush's primarily used three treatments. He used bleeding, purging, and blistering. Bleeding, as we know, largely just weakens the patient. Purging, which was done with a calomel of mercury, tended to just poison them. And blistering, of course, just inflicts pain. So that was orthodox mainstream medicine pretty much up until this meeting in 1847. And what those physicians in Philadelphia decided to do was, first of all, to restore the system of medical licensure. So interestingly, we had medical licensure in, I think, all of the colonies and all of the original states of the country, but those licensure laws were repealed as at the behest of the Thomsonians, but also the followers of Andrew Jackson, who was, if you remember, his movement was a populist movement, similar to some of the populist movements we see around here today. And they were convinced that we shouldn't have that kind of limitation on who can practice the healing arts, medicine in particular, and therefore those laws were repealed. And so the folks who gathered in Philadelphia vowed to restore, to get the states to reinstitute a requirement that in order to practice medicine, you needed to have a license. In order to get a license, they also agreed, you had to have a diploma from an accredited medical school. You couldn't just hold yourself out as a physician and get a license. And there had to be a system for accrediting medical schools. And in order to be an accredited medical school, the school had to teach scientific medicine. And at that time, one of the great advances in medicine was the recognition of the role of germs in disease and so forth. So the schools, in order to be accredited, had to teach that type of curriculum. And so to make these changes take place, accredit medical schools, lobby state legislatures to reinstitute licensure, this group of individuals in Philadelphia created an organization called the American Medical Association. But they did something else in Philadelphia, something really quite extraordinary. They adopted the first modern code of medical ethics. And what was most extraordinary about this code is how it began. And this was the very beginning of that code. Physicians should minister to the sick with due impressions of the importance of their office, reflecting that the ease, the health, and the lives of those committed to their charge depend on their skill, their attention, and fidelity. And the important point in this declaration was the idea that physicians owed a duty of fidelity to their patients. And that was new. That hadn't been recognized before, with the exception of some of the statements by Hippocrates and others long before. But this was very important. And it continues to be important because it is embodied in Principle 7 of the current Code of Medical Ethics. Principle 8. A physician shall, while caring for a patient, regard responsibility to the patient as paramount, and an elaboration of this principle by the Council on Ethical and Judicial Affairs, Ethics Opinion E803, says, under no circumstances may physicians place their own financial interests above the welfare of their patients. If a conflict develops between the physician's financial interest and the physician's responsibility to the patient, the conflict must be resolved to the patient's benefit. And it took the rest of the century for the American Medical Association and its associates to achieve the changes that they set out to achieve in 1847. They sort of ended, this effort ended with the Flexner Report in 1910, which was an effort to control the sort of unaccredited medical schools that had blossomed. And as a result of this report, 66 of the 148 medical schools in the country were closed. Actually, unfortunately, 5 of the 7 schools with African American students, that specifically African American students. But in accomplishing these changes, which started at that meeting in Philadelphia, what happened was the transformation of the practice of medicine from essentially a trade or a collection of trades into a profession. And if you understand the principles of professionalism that sociologists and sociologists of medicine have proclaimed, in order to be a profession, you have to have specialized knowledge that can only be obtained after a great deal of study. You have a great deal of self-regulation. So, for example, the state medical boards that just gave licenses and examinations, and you had to have a dedication to someone other than your own self-interest, in particular to the interests of your patients. So with these transformations, with these efforts, medicine transformed itself into a profession. And as a result, doctors by and large regarded the health of the people in their communities as their responsibility. If patients couldn't pay cash for their care, well, then they could pay in kind. A bushel of potatoes, a suckling pig, and so forth. And if that was not possible, most physicians at this time would treat them anyway and say, pay me when you can. Economically, as a result, most physicians fell into the lower class or lower middle class. The lower class or the lower middle class in terms of their economic status, okay? But in terms of their social status, they enjoyed enormous social status. They were leaders of their communities. They were venerated, I should say, by their patients. And this is Norman Rockwell's depiction of kind of how physicians were viewed. These are all with children, but also by adults. The doctor in the lower picture, who's holding the thermometer, was my doctor in high school. That's Doc Campbell from Stockbridge, Mass. I went to school near Stockbridge, and he was, which is where Norman Rockwell lived. So that is. Pardon? No, I was in high school. He's a little younger. So, what has happened? All this has changed. All this has changed. And the change began, most people agree, in 1965 with the passage of Medicare and Medicaid. Because what that did was to inject enormous amounts of federal money and state money into the practice of medicine. And that kind of capital had not been there before. I don't know if you've heard this story, but Lyndon Johnson was president at the time, and his aides were so appalled at how much money was going to be devoted to these new healthcare programs that they came to him to complain. And Johnson said to them, "Well, I guess I have to call my brother." And the aides didn't know what he was referring to. And he said, well, he explained that there was once this fellow who was studying to be a railroad switchman, and he was taking his final test. And one of the questions on the test they asked him was, well, imagine that there's a train coming towards you on the track at 60 miles an hour, and there's another train coming in the other direction on the same track at 40 miles an hour. What do you do? And he thought for a minute, and he said, well, I'd call my brother. And they said, why would you call your brother? And he said, well, he hasn't seen a train wreck. So that was Johnson's response to the enormous amounts of money that were introduced. This is a little unseemly, but the chief architect in Congress of Medicare and Medicaid was Wilbur Mills, who was the chair of the House Ways and Means Committee. Anybody know what happened to Wilbur Mills? You know what happened to him? Yeah, he was arrested intoxicated near the Washington Monument very early one morning after having an altercation with his girlfriend, who is shown here, Fannie Fox, who was a renowned Washington, D.C. exotic dancer. She thereafter went swimming in the tidal basin, and that was pretty much the end of Wilbur Mills' career in Congress. Very sad. But in addition to the demise of Wilbur Mills, what happened was that business interests and others began to sense the availability of enormous amounts of profit. And so business experts began to become more involved with the delivery of healthcare and indeed with delivery of medical care by physicians. The drug industry became lucrative starting around this time. And this, if you can see this, this is the profit margins. My last data are from 2016. These are the most profitable industries in the United States. You'll notice that banking is way down. Savings banks are way down. And you'll see that drug companies are way up, right under tobacco and investment managers, but generic pharmaceutical manufacturers have the highest profit margin of any corporate type of corporation in the country. And this started, again, around with the influx of capital in the mid-60s. Just by the way, here's their profit margins. This, again, was a few years ago. I'm not sure how this has been readjusted with COVID. 62.7%. I wish I could get that. And this is the compensation for 8 of the CEOs of those drug companies, which is not shabby. In addition, hospitals recognize the possibility of profit, even if they were not for profit. They just don't call it that. They call it net revenue. And these are some of the building projects of one of our great hospital centers here, the Cleveland Clinic. And more recently, as you know, hospitals have begun to purchase physician practices and operate them as part of the hospital proper, and also to employ their physicians in an employer-employee relationship. As a result of the influx of all of this money, physician income soared. They were no longer, most of them, in the lower in the lower middle class or the upper lower class. And this is just a comparison of the average income of American physicians compared to the average income of physicians in other advanced countries, well, other countries. Now, of course, it's important to note that not all physicians make that kind of average income. There are some specialties that are much less reimbursed than others, but nevertheless, this was a dramatic change from what had been there previously. In short, I think it's fair to say medicine, the delivery of medicine, including by physicians, became no longer really a profession and more of a business. And this, I think, has significant costs for us. This transformation or retransformation has significant costs. It has significant costs for patients. This is a report that found that out of 29 industrialized countries, the United States came in 24th in a survey in which respondents were asked if they felt they could trust their physicians. So we were 24th out of 29 countries of people saying they could trust their physicians. It imposes the loss of trust or the questioning of the ability to trust imposes financial costs on patients. So they, for example, feel they should get second and third opinions, and those cost money. They protect themselves in other ways. I'm going to bring my brother, who's a physician, to my meeting with my doctor just because my brother can make sure they're doing the right thing. And so resources are spent on protecting themselves rather than on purchasing the health care that they need. And then, of course, there are the emotional costs. And imagine how these emotional costs affect patients who are seriously ill and in pain and distressed already. And then on top of that, they have this sort of doubt in their minds. This loss of professionalism also imposes significant costs on society in terms of economic efficiency. The problem is that, again, as I said, people are spending resources on monitoring and protecting themselves, monitoring their physicians and protecting themselves, rather than on purchasing care. And this is arguably inefficient, or at least it's costly. And of course, there are costs for physicians. So one of the things which Sher will talk about is the increase of malpractice risk. And I'm not going to say much more about this, but we know that patients who feel who have a good relationship with their physician are much less inclined to sue them for medical malpractice, even where the physician makes an actual error and the patient discovers that. It also it has a demoralizing effect on physicians. This is a 2018 survey of American physicians. It was the last one performed before COVID. And it found that 62% of physicians are pessimistic about the future of medicine. 55% describe their morale as somewhat or very negative. And this is what I find most interesting. 49% would not recommend medicine as a career for their children. Ultimately, if this continues, or as this is continuing, patients and physicians may feel that they're no longer in a patient-physician professional type relationship. Instead, they are in a business relationship. And and they may begin to think of their physicians, and this is, I hope, an exaggeration, as kind of the proverbial used car salesman. We have a foretaste of this sort of transition, a foretaste of this business, this notion that it's a business relationship rather than a patient-professional-physician relationship, with the call for consumer-driven healthcare, which we've heard for many years, particularly from some of the Republicans. And patients should consider themselves not to be so much patients as consumers. And here's another example, which is arguably patient-friendly: the empowered patient, right? How to buy the cheapest drugs, beat your insurance company, get the right diagnosis. So basically, patients, don't expect your physician to do the right thing by you any more than you would expect somebody who's selling you a car to do the right thing by you. Look out for yourself. The ultimate, legal version of that is caveat emptor, buyer beware. So that's why we're having this conference. Most people, or I shouldn't say that, many people think that it is simply too late, that the horse has left the barn. The transformation of the practice of medicine has gone too far in this direction. To try to bring back the professionalism, and particularly that key aspect of professionalism, which is fidelity to the patient, is a lost cause. The horse has left the barn. Those of us who will be presenting today and will be contributing are hopeful that that is not true, that it is not too late, that there are things that can be done, although it may not be easy to do them, that can restore this aspect of professionalism to the practice of medicine. And that's why we're having this conference. Okay? So, anything that any of our speakers would like to add or subtract? Any of our experts? Let me mention, by the way, to our virtual participants, we have a number of people who've been invited to not give formal presentations, but to be in the audience as experts. Some of them are with us here in person. Some of them are participating virtually. So if any of you have any questions or comments, please just raise your hand. Do you? Yeah.
Yes, Dr. Hahnemann, thank you so much for that presentation. Just a quick question on the impact of COVID and the halo effect on the analysis and the presentation that you provided, as far as the perception of patients and the trust in the medical practice.
What does it tell us about the halo effect?
The halo effect, the patient's perception of physicians, healthcare providers as being community during a pandemic.
Oh, so like the angels, I see. Does anybody have data on that? Anybody familiar with data on whether the pandemic has substantially changed this trajectory that I described? Dr. Kurtz, yeah, do you have a microphone?
I think it's right.
Oh, no, okay.
Oh, I'm sorry. No.
I thought you all had individual microphones, sorry.
Well, we're dealing with something called MICRA in California. Could potentially be assaults on the limits on caps that will be occurring, but there's a lot of polling going on, some of it internal among some of the groups that we're involved in, and doctors are polling in the high 70s and high 80s in terms of approval. So I think there is some evidence that doctors showing up to shifts, dying, taking care of COVID patients, working in their offices, doing things for free, doing things online, has really reflected well upon upon the profession. And I think that I can't give you a study, but some of that polling that's done is for political purposes, because there is a ballot measure in California has borne out that physicians do have some sort of halo effect, and the nurses and other allied professionals.
And if I understand what you're saying, the reason for that is, if you will, the fact that physicians are practicing more like the professionals that I talked about earlier. In other words, basically sacrificing their own interests for the needs of patients and so on. But it'll be but we also know that there's a lot of distrust of medicine, and I don't know to what extent that extends to physicians as opposed to vaccine manufacturers and so on. And we also know that the level of trust differs depending on the population that you're looking at, right? There's some populations that are particularly and historically mistrustful of medicine, and that I think includes the practitioners. So it'd be interesting and to learn more about that phenomenon. Other questions or comments?
Let me generalize this just a little bit more, Max, because I think it's an issue anytime there's an agency relationship. In economics, we spend a lot of time thinking about the two parties involved in whatever the transaction is. And when there's somebody else in the middle who acts as your agent, that creates a problem that potentially has an agency cost. If you don't make the same decision that the person would want to have, then there's a cost involved in doing that. I think the way you've described the history is there was very low agency cost. There was no issue at all. Now the question is there might be, but I would argue it's not just the physician. When you have an insurance business that has various agents involved in it, brokers is my favorite people to throw rocks at, but maybe even, shall I say, lawyers, perhaps even. When there are multiple agents involved, there's always the danger of an agency problem. And I think that, so the bigger picture is, can we get it to work right? And are there mechanisms to hold that down somehow or another?
And I'll come back later this afternoon, and I'll talk more about what Professor Silvers refers to as the agency problem and how the law has responded to that in the case of medicine. But I want to underscore the fact that we're not just talking. This conference is focused on physicians, but this is really an issue for all healthcare professionals, all healthcare providers, right? This conference is focusing on physicians. But for example, we can think about the implications for advanced practice registered nurses, particularly in states that are extending them what's called a full scope of practice in primary care. And an interesting question which I've raised with the former dean of our nursing school, Joyce Fitzpatrick, is to what extent should nurses, do advanced practice registered nurses, feel the same professional duties of fidelity to their patients. And in their code of ethics, there is a statement comparable to the principle in the AMA code of ethics. But so far as I know, there isn't a lot of sort of effort within nursing, at least advanced practice nursing, to work on that or to even perceive whether there is a real problem there. Interesting question. How do patients feel in terms of trust towards people who are providing care but who aren't physicians? And this is also important because of the movement, I should say, towards team care. So the idea that patients should think of themselves as being cared for by a team of professionals, not just a physician, although some physician interests are insisting that the teams be led by physicians. But that raises a question of, on a team, whom should they trust? And I'll come back to that possibly later,,,,,,,,,,, as, well, with some thoughts. Anything else? 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 Anyth
The older I
Dr.
get,
Frizov.
the older I get, the more interested I am in history, and I am really appreciated your introductory comments this morning. And I'm also struck at how much younger physicians, including physician activists who have been good friends of mine, don't really understand or even know this history. And so my question is, are you a total outlier in saying this, or is this in fact being taught on a regular and important basis in modern medical education and medical school and beyond?
Well, it's interesting. I have a course that I teach for law and medical students and also other health professional students, but it was started many, many years ago for law and medical students. It fulfilled a medical school elective requirement in our medical school. I'm teaching that course now, and I asked the students at the beginning of our course this semester, what do you learn in medical school about this history and about these issues of fidelity? And to my surprise, they said very little. A number of these students will be joining us later this day to present their recommendations on how to restore professionalism to the practice of medicine, and I'm very much looking forward to their insights. But one of their suggestions was indeed to increase the attention that's paid to this in medical education. All right. Well, if there's nothing else, I'd like to thank you for.
I'd like to say something if I
yes.
could.
Yeah, and introduce yourself, please.
This is Daniel Wolfson from the ABIM Foundation. We've done a lot of thinking about trust in physicians and trust in other organizations. Trust in physicians has, in our data, has remained steady throughout time. I know it might not be as high as other countries, but the level of trust in physicians is quite high. What has taken a bigger hit in trust is institutions, healthcare systems, and the government. So there is, of course, higher trust with nurses, which is an interesting phenomenon. The pandemic actually raised trust in physicians, according to some data that we have from NRC that we sponsored. So we don't think it took a hit. It took a little bit of a hit in physicians trusting other physicians, but not significantly. So I've been to a lot of conferences that have taken issue with health plans, and I was in the health plans for many years, but it's refreshing now to see physicians getting bashed for lack of trust. So this is a new flavor that I'm enjoying, but I don't think the facts weigh out the notion that the public thinks that there's high distrust in physicians. In fact, I think it's been pretty steady over a long period of time. So the facts speak differently.
Well, there was that survey, which is done annually, and I think you're right that consistently the respondents rate American physicians very low compared to physicians in other countries. So you're right, it's consistent, but is it consistently high? Professor Hall, and then I know we have a comment from one of our experts.
Danny, I'm glad you spoke up, because I was about to say earlier, if you want to know about trust in physicians, contact. I didn't realize you were online, but Daniel Wolfson's leading a project, or helping to lead a project on looking at various aspects of trust and trustworthiness. And so I think a code to his comment is that actual measured trust may have been sustainably high, but the question is whether physicians are continuing to merit the level of trust that they receive, which is trustworthiness.
Yeah, so interestingly, that same survey that I referred to, the respondents, while ranking, sort of in the abstract physicians in terms of whether you can trust them, consistently said they could trust their own physicians. And what's interesting is, that's not really surprising, because what choice do they have? Right? I mean, and again, imagine if you sort of abandoned that notion of trust, and you're sick. I mean, what a predicament. So I think psychologically, that's very difficult for people when push comes to shove to sort of accept. Can we turn off the chats, by the way, in terms of having them show up on screen? I know that, but can you turn off the chat function? Because I think if you have a comment or question, please do that in the Q&A so that we can get you to be part of our conversation. There was a very good point, I think, that one of our experts, Mary Lou Smith, who is a leader in patient advocacy and research advocacy for research participants, made about the importance of focusing on diverse populations and how, as I mentioned, how they view these problems. Was there anything else from the Q&A?
So what we've got is, we've got from Fred Hafferty.
Yes, another one of our experts.
Important distinction, trust in physicians versus trust in medicine versus trust in science. And then Mary Lou says these distinctions are seen as important. And then Fred counters good point regarding diverse populations. And the question here is,
can Max's data on physicians not recommending medicine as a career be viewed from a trust perspective?
Well, that's kind of the implication that I'm sort of suggesting, but you know, there are certainly other interpretations that are possible. All right. Well, I've exceeded my time, so I would like to turn over the conference to my co-conspirator, if you will, Dr. Robert Batanti, and he will be doing the next presentation. So thank you very much.
Thank you, Max. And I'm going to read my disclaimer as well. No planner, faculty, or staff of this educational program has any relevant financial relationships with ineligible companies. Well, thank you. And before I make any comments of substance, I want to thank all of the attendees. The ones that are here in Cleveland, there's plenty of other things you could be doing besides coming to a conference. I could think of being over in the Little Italy section, having a cannoli right now with some espresso, getting ready to go to the Rock and Roll Hall of Fame or going to the gardens across the street later on. And for those that are remote attendees, especially those that we have out in California, they had to get up before the sun came up today to visit this live. And so I'd like to thank everybody for attending. This conference wouldn't be the same without each and every one of you attending because you bring what you bring your energy, you bring your inquisitiveness, and you bring your concerns. And I want to thank you for that. At the end of the conference, I hope each and every one of the participants feels they could not have spent their time any better than with spending it with us today. Conference like this just doesn't spring out of the ground organically. There's 1,000 moving parts, and it takes a lot of people to put it together, assemble it, and lubricate it. And I want to thank Patty Harbold here at the school and any helpers here for doing an excellent job. I'd like to thank my own personal assistants, Michelle Gutierrez and Victoria Lawler for their help to me personally. And I'd like to thank the speakers. All the speakers here are in big demand and could be a dozen other places and yet have decided to spend their time with us, and I need to thank them personally. And then finally, no production like this gets put together on the cheap. These are expensive ordeals, and they always require some substantial financial assistance and help. And I'd like to thank one of our speakers, Sher and her company, the Cooperative of American Physicians, for their generous and unrestricted educational grant that in part made this all possible. Big thank you. Also at the outset, before I make my comments, I'd like to recognize this is an interdisciplinary conference. We have the public attended and invited. We have lawyers. We have physicians. They all bring their different concerns and expertise. And I think we, because of that, all can recognize that we all become patients at some point in time. So this is relevant to all of us, no matter what our points of view is. I've tried to make my comments more general than specific, so that not a physician point of view, not a lawyer point of view, not a public point of view takes a dominance or prominence and gives everybody a chance to participate. Well, there's how I started off, American medicine on the square question mark. And you know, that really is the issue. Is it a question mark or is it a statement? Is it on the square or is it not? Well, this is my personally my second most anticipated trip to Cleveland, which begs the question, well, what was the first one? Your most anticipated trip to Cleveland. And I was born and raised in Youngstown, Ohio, about 50 miles east of here, and proud of it. Well, in 61, Mantle & Maris was coming to town, and I'm a Yankee fan. My dad was a Yankee fan. My sister's a Yankee fan. And if you didn't want to see Mantle & Maris in 61, you weren't a baseball fan. But I couldn't drive at that point yet. So I went to my dad. I said, you know, Dad, we ought to go to Cleveland. Mantle & Maris are coming. And his comment to me was, what are we going to go see those guys for? DiMaggio's not playing. Rizzuto's not playing. Vic Raschi's not pitching. What are we going there for? I said, come on. It's Mantle & Maris. He said, well, yeah, we go see Mantle and watch him strike out 3 times. But we came, and the truth of the matter was, Mantle homered in the first inning, Maris homered in the 3rd inning, and it was everything that I wanted to see, Mantle & Maris. That was the most anticipated. Now, this is my second most anticipated trip. What starts it? It was the article, Can Law Save Medicine, that Max talked about. I must have read it 3-4 times before I could really grasp the thrust of it. Apparently medicine was not doing a very good job of saving itself from exact things that Max was talking about, and law hadn't helped it very much either. So, could it save medicine? Well, in the article, Max went over it pretty much. He talked about the self-proclaimed practitioners. You didn't have to have a degree. You just, start practicing. It was interesting that in the 18th century, many of the practitioners were trained in Scotland and England. They were, pretty much real practitioners. But by the time the 19th century came, it was a free-for-all. In particular, the patent medicine salesman and unfettered claims. These are some of my favorites. For hay fever, you could get some cocaine tablets. That'll certainly fix any hay fever. And cocaine toothache drops, which you could get in the mail if you wanted to buy them. And if you didn't want to take pills, you could put an electric belt on, and that cured nervousness, chronic diseases without medicines. Interesting thing is, how many of you seen the copper things on TV that are being hawked now? We're having a rerun of the electricity fixing things. And then Coca-Cola had cocaine in it as well. And it was made by a pharmacist in Atlanta. It's kind of a little hard to read this one, but this is the United States Medicine Company. There's like 6 products down below. All of them have a doctor's name in front of it, with the implication that a doctor made it and that it has some merit. Can law save medicine? Professor Melman talked about the fidelity issue. And he talked about going from an occupation to a profession. When I first read it, I hadn't really thought about it that much. But an occupation requires knowledge and skill, and the profession is self-regulating, and it was stated that the reason you get to regulate yourself is because the extraordinary trustworthiness of its members. And if you want to think about it, the difference, auto technicians have knowledge and skill as well. Physicians have knowledge and skill as well. Do you believe your auto technician has your best interest at heart? And that's why they remain occupations and not professions. Well, we talked about a little bit about the rise of prestige. It rose from third in 1925 to first in 1933 and remained there until 1976, and never regained first place from 77 to 2012. It was, when you go through some of the findings, if you go through the polls themselves, I felt bad, medicine had fallen down 3-4 spots, but then I looked at lawyers, which were almost at the dead bottom too, so it was, not quite as bad as it seemed at first. Okay, so we're currently in a retransformation. So what's that exactly mean? Well, physicians are trying to serve patient interests and self-interest. Institutions, entities, payors are trying to serve patients' interests and self-interest. Is that possible? Matthew in the Bible says, no one can serve two masters. If you go in the dictionary, what is serving two masters? To give equal support to two different causes or groups. Is that possible? I don't know. Loss of trust in physicians, sometimes dramatically. It's been written about in literature, and we have two experts right here today. Professor Melman's article, Professor Hall has spoken about it and written about it extensively. David Mechanic has written about it. This has been written about and discussed quite extensively. I wanted to make one comment. I forgot to say it, but I'm going to say it now. We talked about, I came here to watch the Yankees in '61, and it was a great thrill. Well, when you're up on a panel like this with Professor Hall, Professor Melman, Sher, and later on some other speakers, this is like being on the Yankees in health law, and I appreciate playing with them because I know if I muff it, they'll pick it up and still throw the guy out. Well, what happens when you're going through a retransformation and you're going the other direction? Promotional efforts and advertising has escalated markedly. 2016, $30 billion was spent on marketing. It's pervasive. You see it on TV. You cannot watch a TV show without seeing something about selling you some kind of health care, something. Direct mail. You go to any ballpark in America, you see some healthcare advertising. You see billboards, radio, physician lab coats. Used to be you had your name, maybe your department. Now you got your name, your department, a big banner of the institution you're working for. And Professor Hall wrote about this years ago, that the reputation can go back and forth between institution and individual physician, and we're starting to see one trying to live off each other's reputations. But here's where I think we're starting to really go in the retransformation. We have two dermatologists up at the top. What's it say there? Partnering with entrepreneurs to deliver breakthrough skincare solutions and substantial income potential. This is an advertisement. Of course, we have Dr. Courtney, a plastic surgeon. That's maybe a little different deal. These are mailings I've personally received. What is this supposed to tell me? Is this to tell me if I buy that, I'm going to be relaxed and can play with models or do whatever? What is that telling me? How about this? These all came to me personally. So the one on the left, if I buy a healthcare from this group, am I going to get dates and walk through the forest? How about the other one? A strong team is hard to beat. What's that tell me? So really the question is, what is everybody promising or obligated to promise and perform? I'm going to give you some of my bias now. If I can't talk about my hometown here and nowhere else on earth, can I do it? I was born in Youngstown, raised in Youngstown, proud of it. We're a steel city, just like Pittsburgh and Cleveland. We had 40,000 steel workers at one time in Youngstown. I was born into two steel worker families. They had 90 years combined service in the hot, dirty, dangerous steel mills. They were examples of reliability, dependability, and appreciative of opportunity. I'm going to take a little bit from that and once again say I appreciate being here today. But the most important person in my life was, of course, my dad. And if you can't miss him because he's right in the middle there, and we all look alike. Now, it's okay if you say you guys all look alike, because I don't take that as pejorative, because it's the truth. Anyway, when I was growing up, you hear things as a kid. You think, whoa, that's pretty clever. I would take it back to my dad. I'd run it by him. He wasn't one of those to say, well, where'd you hear that? What do you think about that? No. What crackpot told you that? Right from the get-go. And in the end, the lesson was always the same. You only have your reputation, and that's all you'll ever have to work with. You have to deliver on your obligations, even at personal cost, inconvenience. If you do that, you're going to be known as on the square. If you don't do that, you're going to be not on the square, and you can't run from it. If you were subjected to somebody who was not on the square with you, you were gagged. And if you did it to somebody, you gagged them. And then finally, if you delivered but not quite what you said, you were a chiseler. If I heard it once, I heard it 1,000 times. Well, this is a picture of Youngstown, really. This is Youngstown's face. This is Youngstown people, straightforward, working class people who had common sense. Now, everybody's going to say, oh my God, you're listening to those people in Youngstown? For God's sake, you know about those people. Well, that all starts really with an article in the Post in 1963. They were talking, if you look right at the bottom, it says Crime Town, USA, and they put Youngstown in there. So, everybody in town reads it. What do they talk about? They talk about, let me go back up just for a second. They talk about the bug the bug, pick 3 numbers, and then the next day you look in the newspaper to see if it matched up with an identified 3 numbers. If you won, you hit the bug. It talked about dice games, gambling. They talked about sports betting, and they said it corrupted the city of Youngstown. Do those guys look corrupted? That's the backbone of America. So what's the state of affairs today? Every state but 5 has a lottery. That's the numbers. That's the bug. 22 states have in-person gambling, casino games, video games, fantasy leagues, and they have, that's basically bookmaking. So, and the average credit card rate's 16.22%. That's loan sharking, I think. In Ohio, since 1974, the lottery has collected I'm sorry, I missed the slide, but I want to come back to it in just a second. In Ohio, since 74, the Ohio lotteries collected $26 billion. I'm going to go back to this. This is really where the rubber hits the road. Carmen Policy, he built the 49ers, he brought the Browns back to Cleveland. He said this is a working class area and gambling is not considered a vice. In Pittsburgh, in fact, the numbers were regarded as quasi-legislative business. That was in a book written about the Pittsburgh industry. We talked about the lottery, and in California, the lottery makes $7 billion a year. It only contributes 1% to education. So what's the point of all that? The point of all that, it appears that working class people can make a decision about what is important to them, including health care. Maybe we should ask them, what do they want out of the American healthcare system? And when I make my comment, I'm going to give you my Youngstown, Ohio bias about what the average working guy would like to see in American healthcare. So what's everybody promising? We talked about what's everybody promising. Well, what's the law says everybody has to promise? What's the promise that you have as a physician or a health plan or anybody else? Well, it's pretty clear that the physicians are obligated to do the standard of care for medical specialists as outlined in jury instructions. That's the law. So it says that whatever specialist jars negligent if he fails to use the level of skill, knowledge, or care in the diagnosis and treatment that other reasonably careful surgeons or specialists would use in similar circumstances. This level of skill, knowledge, and care is referred to as the standard of care. That's his promise. He's going to deliver that every time. How about the payors, the plans? What's their promise? It says, for services rendered after 2001, healthcare service plan or managed care entity shall have a duty of ordinary care to arrange for the provision of medically necessary healthcare service to its subscribers and enrollees where the healthcare service is a benefit provided under the plan and shall be liable for any harm and all harm legally caused by its failure to exercise that ordinary care. They have to provide medically necessary care. Now, there's some additional restraints in California. Medical decisions have to be rendered by qualified providers unhindered by physical and administrative management. Only a healthcare provider who is competent to evaluate the specific clinical issues involved in the healthcare service requested may deny a request for care based on medical necessity. some additional restraints on hospitals, HMOs, and healthcare institutions. The sharing of profits generated from treatment reductions, and this may violate a federal statute, may constitute promised fee splitting. Professor Hall, who is going to speak later on, has written extensively about that. I learned a ton reading his materials, and if it was relevant then, it's very relevant now. There are so many inducements to go any way that the organization wants that it's hard to really keep up with it. One question I'm going to ask Professor Hall, I'll ask it now, and he can think about it for a little bit. I got a notice that I was enrolled in an ACO. And ACO is they share cost savings. First of all, I never said I wanted to be in an ACO, and to me, that is fee splitting. And I want to know how in the world can somebody put me in an ACO and split fees on the savings they're going to get on me? All right, so, you know, we know that they have to provide medically necessary care. We know the doctor has to provide the standard of care. So, but what's the definition of medical necessity? Well, if you want to see a quagmire, look at the definitions of medical necessity. There's definitions galore. Look at any health plan, their definitions. Everyone's got their own. Government's got their own. Everybody's got one. But in California, we have a little bit of clarity. Two cases, one a Supreme Court case, one of appellate case, helped clarify the definition of medical necessity. They both say the same language, that with doubts respecting coverage resolved in favor of the subscriber, there will be few cases in which the physician's judgment is so plainly unreasonable or contrary to good medical practice that coverage will be refused. Doesn't that sound incredibly similar to the obligation that the physician has to do? He has to be reasonable and comport with the standard of care. It seems pretty reasonable. If the doctor provides a reasonable and recommendation that comports with the standard of care, it looks like coverage can't be refused. Okay, so where am I going? I mean, I started with the Yankees. I was in Youngstown. We talked about the doctors. We talked about the insurance carriers. Where the heck do you go with this? And that really was the question that I've been struggling with for years, studying with Professor Melman. Where do you go with it? And so I took a little help from Professor Hall. He wrote an article one time that says healthcare law is a mess, and we need an organizing principle. I thought I need an organizing principle, and so I'm going to try to create one, my personal organizing principle. And so here it is. And I think this incorporates, my personal slant, and I think incorporates that common working man who's paying the premiums. What would he expect? And so this is my organizing principle, and everything that I recommend or propose goes to this: that medically necessary care, every time, on time, by the appropriate provider, and adequate reimbursement made to the provider to assure his or her available to the next patient. And that's for me, for you, my mom, your kids. Every time, on time, by the appropriate provider, period. Well, okay, you said it, now what? How are you going to get there? I put shared risk to the far left. That's not in my organizing principle because shared risk, is pooled risk. But what's the impediments to every step that I laid out? There are impediments at every juncture to get that done. Shared risk, well, the coverage is so expensive I can't buy it, so you can't get it. So you can't get in the shared risk pool. How about medically necessary care? Remember, we're delivering medically necessary care. Well, suppose there's no providers available. How about there's no physician advocacy? They're not advocating for what's medically necessary. For what reason? Maybe they're getting, shared savings, and they're not advocating for everything that is required or should be required. How about inducements to delay, deny care? How about the lengthy pre-authorization process? How about that? Isn't that an impediment to medically necessary care? How much information? I need to know more before I can authorize it. How about just straight up care denied? I deny that recommended care. Those are all impediments. Every time. Remember, medically necessary care every time. Well, what's an impediment? Ineffective advocacy. You advocate, but you didn't do it good enough to pull it off. Or you didn't do it loud enough because you're afraid something's going to happen to you. How about no willing provider? How about, once again, the lengthy pre-authorization process? People drop out seeking care. They get fed up, and the doctors don't do it. The patients get fed up. Doesn't happen. How about on time? What good is treatment or when it's way past when it would have done any good? Again, persistent requests for authorization and no willing provider. Recently, we had a $55 million judgment against a health plan in California that was providing care to the indigent population, and there is no way they could have provided the care necessary for the money that they're given to run the program. You cannot pay ridiculous amounts of money and expect people to perform. Well, you can make an impact. I'm sorry. Yeah, we talked about willing providers. Okay, where do you start? Well, the truth is you can start anywhere in the process and try to make an impact. I want to talk about what I'd like to talk about first, which is the WIC line versus the state of California. It's an old case. At one time, Professor Hall called it the most important malpractice case to date. I don't know if he still feels that way, but it's the only case I can tell you I personally lived at least 1,000 times, maybe more. It's regarding a payor and physician liability, physician obligations, and concurrent authorizations. You're going to say, well, how'd you live that 1,000 times? Well, I'm going to tell you in a minute. But let's talk about the case. Mrs. Wickline, she was about 40 years old. She had a peripheral vascular disease. It required pre-authorization to get into the hospital. She was admitted on January 6, 1977 for a 10-day stay. On January 7th, she had a graft put in her right lower extremity. January 7th, she went back to the operating room to be re-explored for a clot. January 12th, she went back to the operating room for a sympathectomy. She wasn't doing well, and now they're groping at straws to try to save her leg. On the 16th, she was due for discharge, and the surgeon was uncomfortable with the discharge. Again, to keep her in the hospital required another authorization, and these are the requirements for the authorization. It had to be timely, complete and indicates medical necessity. At this time, I'm serving the indigent population in South Central Los Angeles. I faced this 1,000 times. Your report is not complete. I'm asking them, well, what do you want me to tell you? Well, we want to know what's wrong. I said, if I knew it was wrong, I would tell you. I don't know what's wrong. I'm 30 years old, and I'm scared to death to let this person go home. This is somebody's mother. Sorry, she's going. Well, on the 21st, the surgeon and the family physician discharged her with their own pen. The 24th of 77, she's got pain in her right lower extremity. She doesn't see her doctor at that point in time. This is all testimony. She was readmitted to the hospital on the 30th. They tried to salvage her leg via non-surgical care. It didn't work. On the 8th, her leg is amputated below the knee. On the 17th, she has an amputation above the knee. So the court's looking at this and, obviously something went wrong here. Is anybody negligent? No, the state's not negligent because it was the doctor who signed the discharge summary. I want to tell you, I'm going to testify to this right now. I did my rounds at night, 8, 9, 10 o'clock. There would be an administrator waiting for me to tell me, your patient is going home tomorrow. I said, well, I don't think she should go. Going home. Thank you. And that's the intimidation that was going on that nobody speaks about in this case. The judge recognized that they were probably intimidated, but that's as far as it went. Court did say also, physicians have a duty to speak up. A duty, affirmative duty to speak up. There's other mandates, other authorities that say physicians have a duty to speak up as well. Here's the Medical Board of California. Open communication, advocacy are vital. The relationship cannot be constrained by any considerations other than what is best for the patient. Here's the part I like. Any act or failure to act by a physician that violates this trust and jeopardizes this relationship places the physician at risk of being found in the violation of the Medical Practice Act. Prior authorization has become a major burden for physicians. In 2017, they did 29 a week. In 2020, 40 authorizations a week. Physicians spend $82,000 a year interacting with payors. Physician staff spend 2 days a week doing authorization. 40% of physicians have staff that work exclusively on prior authorization. It's become an important impact on patient care. 94% report treatment delays to patients. 30% report that authorization has led to serious adverse events, and 18% have reported that prior authorizations led to life-threatening event. This is a duty that's economically crippling, and at some point you just can't do it. So I'm going to reiterate, and then I'm going to make my point, and then I'm going to step down. Physicians have a duty to advocate for medically necessary care. WICLINE says it, Medical Board says it. Payers have a duty to only pay for medically necessary care. We appreciate that. Nobody wants to pay for something that's not necessary. But payers have a paid corps of claims clerks, administrators, auditors, form processors, peer reviewers, medical consultants and medical directors to do their part of the job. My proposal: to encourage physician advocacy in an economically non-disadvantaged position, I recommend a CPT code for individual patient advocacy. This will encourage physicians to advocate at every juncture, and they'll have no excuse not to do it. And it will also limit the amount of questioning that payers may ask, because they're going to have to pay for the information to get it. Thank you.
Thank you very much, Dr. Batanti. We have a few minutes right now for questions and comments. We'll have more time later today. We can come back to this. Anybody? Dr. Letterman?
So I heard earlier today that nurses were more trusted than physicians. And when you spoke of advocacy, Dr. Batanti, I was impressed in my career that as a hospital-based physician, I found the nurses were often patient advocates, and it was something that we counted on. And I was wondering, when you mentioned that docs are no longer number one in respect, who is number one? Is it nurses or is it someone else, and who would they be?
Nurses and pharmacists.
Other? Yes.
Bob brought up a case before the Wickline case where the court assumed that what the physician said were correct. So I felt back in the 80s when that case was heard and found that even the courts put their trust in physicians, and it's right there in the statement. So we do have that history. Things have evolved certainly over the last 40 years, and things are changing for better or worse, as you may believe. But the physicians still are trusted. When you walk in to see a physician and you sit down with that physician, there is no one else in the world that is going to advocate for you at that time when you're sitting there together. And there is no other profession where you put your body, your health, your life on the line and speaking with somebody other maybe than in an airline flight, what some of us may have taken last night. But you count on that physician. You have to have trust in that physician. I'll give you just a quick experience and not take too long. I have a patient who's been texting me, and Bob knows this case. She's been texting me. She wants to get an appointment. She heard I was quoted a good physician for what that's worth. But I know what her problem is based on her history, and I said, you can come to my office, but you have a different plan, and I want you to be able to get taken care of properly, so I'm going to help you find a doctor. And this patient wants to come in and actually said, it's all about money with you doctors. And the actual thing is, no, I'm trying to do the best for the patient. And when you get money involved and have third parties involved in your office, in your exam room, whether they're there or not personally, government payers, regular payers, it really makes it very difficult. And the doctor-patient relationship has been upset significantly since health insurance and government involved in healthcare. I think everybody pretty much knows that.
Mr. Wolfson.
Thank you for that presentation. I found it very interesting, and it raises a lot of questions for me. One is, how do we separate out the system problems from the physician problems? And I'm getting a lot of conflating viewpoints. Are we talking about the system that we need to fix, or is it the physician we need to fix? So do I want to spend my time fixing the system or getting a code for advocacy, just to be frank? Should I go upstream and try to fix prior authorization and get rid of the need for a physician to advocate and spend his time advocating, her time or his time, advocating for something where the root cause is what I really want to go after? I am not sure, and it's possible that over time, what the system is that the physician is operating in affects the patient-physician trust is not clear to me. Will the patient really distrust the health plan and not the physician? I think over the long run, as physicians become more employed, that blurring of system and physician trust will be blurred. It has not blurred yet, in my estimation, but it's going to be as physicians become more employed. 70% of physicians are employed by institutions now. Private practice, independent practice are going to be a thing of the past quite soon. So those are huge questions about how the system or how the employer will affect the trust of the patient. But so far, that's gone unscathed. When Sloan Kettering's CMO, Chief Medical Officer, gets attacked for conflict of interest, does that diminish Sloan Kettering's reputation or affect the patient's trust in Dr. X? And that's a huge question that that we're all grappling with. But I think conflating system issues and patient-physician issues are quite separate in my mind. And at the foundation, the ABIM Foundation, we're frankly more interested in the system issues than we are in the patient-physician relationship that's been studied quite extensively. And there's good information that those levels of trust are pretty high in spite of a terrible healthcare system that makes it more and more difficult, makes it more transitional and less human-based. Physicians, unfortunately, are asked to be heroes when in the face of bad systems. And you don't want physicians, frankly, to be heroes over a long time. It's not sustainable. They burn out. Their well-being is affected. And being a hero is not a position that we want to put doctors in. Nor, frankly, do I want them to have to advocate on a daily basis to get the proper services they need from the institution or from the health plans. I want them to focus on the patient and not be burdened with medical record systems that don't operate well. I mean, on and on and on. Be involved in a fee-for-service system that makes them produce unnecessary care. All those things, I think, are needed. I think if physicians are going to advocate, they should be advocating for social and structural changes in the healthcare system. Many physicians advocate for a single-payer system, for instance. But advocating on a daily basis for patients is just a heartache. And to get that paid for, this seems counter to professionalism that relies on intrinsic motivation. Sorry, I spoke too long, but you activated a lot of buttons.
Well, I appreciate the comments, I really do. And, you know, is the system flawed? No question. Does the system need to be fixed? Yes. But what we're talking about today is physicians, and you know, how do we get them engaged to get their patients medically necessary care? And there is no question that the prior authorization issue is overwhelming them. If you ask them, what is the major problem causing your so-called burnout, the first thing they'll tell you is the prior authorization issue. 1, it's time consuming. 2, it's expensive. And 3, at the worst part of it, if it's not done, the patient will likely not get their medically necessary care approved. So although I would love to change the system, I'm talking about the here and now, today, when my mother has to go get her medical care, or I do, or your mother does, or anybody else. I've been called off.
Yeah, sorry. We really have time, so how many are there questions from?
Just Fred I shouldn't say just, Fred Hafferty has, I believe, a remark to make.
Okay, let's take, Dr. Hafferty, let's just take you very quickly and then we'll take a break. But again, we can come back, we're gonna have plenty of time for discussion later today and tomorrow, so let us return to that. But Dr. Hafferty? Are you there, Fred? We're not seeing or hearing you. There you are. You're muted. We can't hear you. Now we can.
Can you hear me all right now?
Yeah.
Okay, it's basically a question. Listening, and I'm not a lawyer, from the discussion about medical necessity and the focus on physician judgment, etc. And then going back, Max, to your earlier comment about fidelity. My question is, does the law recognize fidelity?
Great question. I'm going to talk about that later this afternoon. I've got a lot of thoughts and comments and questions in response to Dr. Batanti, but I will hold those. We're running a bit late, so let's take a break and reconvene at 11:15, and we will make up the time somehow. So we'll see you all back at 11:15. Are you at? Yeah, so as long as you get started, we're 5 minutes to run on.
No.
Well, but I mean, the theme of this conference is how to change the systems of ours. So he's right. We are looking at system changes.
I think it's such a dispersal.
And you're suggesting system changes.
System.
Don't shoot the messenger, man.
Thank you.
See the more.
Yes, exactly. Exactly. That's the precedent. For that.
Yeah. So I think this is very interesting.
Thank you.
Talk to you about Youngstown later.
Okay.
And I should tell you that this very hand, one short whiteboard.
That's great. 61 of you was there.
No, actually, it wasn't in 61. It was before then.
I'm a ditto for you, yeah, so.
I don't know. I would say I don't know where it is.
Left hand.
Right.
Be a southpaw, but he shook my right hand, and I was a kid.
That's a thrill. That's great. You're a Yankee fan too.
I was. I lived in Brooklyn. I was a Yankee fan, the only kid in Brooklyn.
Love coming back home.
It's just nice to add announcements. I think we need to sort of
Live up to everything.
Washington, D.C.
Yeah, lived up there. So for me to come back and do that kind of thing in front of them is a big thrill.
I don't, I mean, Boston's pretty scary. I have
What would you like me to do?
Just so I can, just put closer to the.
Yeah. Absolutely, no problem.
No, well, actually, there's some IROs that are also humans. Yes, that's.
Is something about it. Nah,
Or was it an exchange of words so that we never got like?
No, I'm just thinking.
Yeah.
It's really good.
Doesn't make sense.
But how do you,
But I don't know any scholarship.
getting rid of all these people who are inserting themselves between the document pages?
I guess it's in our course scheduling. So,
Well, you saw what I did with Batanti. I mean, easier if I were sitting.
Who are you with?
From upstate New York, I grew up, went to school
Problem is that I need to sit in
at school, and then I served with the Marines for a while.
Let's just keep going the way you actually were.
Two large medical. Under a fee-for-service model. Some tax.
That would make it all.
Like you're all doing it virtually. See, that's the thing. You can reset virtually.
Reset.
I get out of that. So, but as long as, you know, as long as
Check. Board director.
Because I think there, as you said, there are lots and lots of people.
Blood products performed in a walk pass. But a water bath is slow, this does it really fast. I don't know.
Right.
Company is in the right spot for a lot of stuff we used to do. My kids are at college now.
well, no, actually, that's the way I tried to.
But she just said this year. She's on the so I told her to do whatever you want.
source of
So, but if there's discussion, then that's great. So. Let's see.
I went through two parents with the same thing. But, you know, 5 years of their lives. 5 for my dad. But, you know, she was pretty old.
So blessed.
Fortunately, I had some assets, you know, people disabled, so they had to raise that. For that, because they were concerned about his. I mean, I had to juggle a lot of things in the middle of all of it.
Patty, are you watching from somewhere?
I'm watching from outside, and now I'm watching from my phone.
Okay.
My dad was a VA vet. Also tell people.
Are you a host or are you just on the webinar? I'm a host. I can't see any chat questions or anyone who's indicating to the camera, but that's acceptable. I don't know. Oh, maybe. Maybe it doesn't retroactively happen.
I can navigate the system. I mean, I have energy.
Now I'm on, so I can see an answer to.
Fortunately, there's some
Sounds like
veterans
maybe
groups.
I can't see the chat.
So I guess if I want, I have to do like not a lot, but you know, I'm sure that's certain people. I'm sure you can't do that.
You don't have the assets to pay $7,000
No.
or $10,000.
I just hear a computer.
Yes.
I just want to see the chat.
It's right there, and I can't.
just logged on as a host, so no, I can't see retroactively.
Oh.
So I just wanted to make sure I didn't miss something.
Oh, yes.
Stack
Sorry.
of
Thank you.
paperwork is like this. That was a job. Yeah, that was a job.
Elders who are unfriended. They're gonna have to spend down all that they've worked their entire life to build up this nice little nest egg, and it's just not enough. And so the pain of saying,
You study, or is there somebody in the school that studies? I take so many patients under my wing. I haven't
I'm moving San Diego.
Yeah, I mean, so I don't know how older folks, if you don't have a family member looking out for you, Sure, you probably, what insurance to get, how you do bills, right?
Spend down Medicare.
How is somebody able to diminish the faculties as you get your
For
years?
Yeah, you can see that. That's why.
Yeah.
Wilson is the guy who says this isn't a problem.
Is he an attorney? Is he an attorney?
Yeah, I'm gonna be responding.
It's very easy, but not very.
Okay, we're gonna reconvene.
It's very good too. It's just need it slow.
Our next presenter is Dr. Sher, and she will introduce herself and give her remarks. Thank you.
Thank you so much. I'd like to begin with the disclosure. No planner, faculty, or staff of this educational program has any relevant financial relationship with ineligible companies. My name is Sher. I'm the Chief Executive Officer of the Cooperative of American Physicians. We represent 14,000 physicians throughout the state of California. It really is a pleasure and an honor to be here with all of you today. And I want to specifically thank Case Western Reserve University for inviting me, and also the Californians Allied for Patient Protection, specifically Lisa Moss for her assistance with the slides today. I invite any questions throughout the presentation, and I look forward to a healthy discussion at the conclusion. There were several questions that were posed in earlier presentations. Is this a system issue or is this a physician issue? Professor Mellon asked, can law save medicine? And Dr. Batanti spoke about physician availability and accessibility. And I think this is the perfect time to now talk about MICRA and the micro protections that are afforded to patients and physicians in the state of California. And to talk about MICRA, I want to begin in 1975 when MICRA was actually created. And I've taken a few snippets here from news articles that are relevant to the situation from a medicine experience. The San Jose Mercury News in February of 1975 indicates premiums have reached the point that some physicians are leaving California or retiring from active practice, and some other physicians in high-risk categories are unable to obtain malpractice insurance. The San Francisco Chronicle, January 31st, 1975. A major healthcare crisis loomed yesterday with the cancellation of malpractice coverage effective May 1st for most of the doctors in 8 Northern California counties. Insurance Commissioner Payne, in his letter to Governor Brown, said, "Whatever the cost of malpractice coverage, it is passed on to the patient. A surgeon may add $100 to $200 to the surgical fee, so the consumer finally pays the premiums." The Los Angeles Times, February 22nd, 1975. 8,000 physicians in 7 Southern California counties faced the loss of their malpractice coverage. The 7 counties are Los Angeles, Orange, San Bernardino, Ventura, Santa Barbara, Kern, and San Luis Obispo. The 8,000 doctors make up the bulk of medical practitioners in those counties. And then, of course, the New York Times. The 24-day-old strike to protest the soaring cost of malpractice coverage has brought hospitals through Northern California to a virtual standstill. Last week, more than 60 hospitals in Southern California began, for the first time, to be affected by the crisis, as doctors there joined in the stoppage. So this perfect storm, if you will, in 1975, created the opportunity for a bipartisan agreement, which we know as MICRA, the Medical Injury Compensation Reform Act. And let's talk a little bit about what MICRA means for Californians. This is the nuts and bolts, and most folks recognize MICRA as being a cap on non-economic damages. And that's true. Non-economic damages are capped at $250,000. But what's also true is that MICRA recognizes unlimited economic damages. On the left side of the screen here, MICRA, unlimited economic damages for any and all past and future medical costs. Unlimited economic damages for loss of wages and lifetime earning potential. And punitive damages are even recognized for malicious or willful conduct. But again, a cap on non-economic damages, pain and suffering. Interestingly enough, MICRA also limits the amount of money that a lawyer can make as payment for his or her services in representing a patient. In fact, it goes so far as to indicate a fee schedule. For the first $50,000 recovered, a lawyer can take or charge up to 40% of that, and the next $50,000, 33 1/3. For the next $500,000 beyond that first 100, a lawyer can charge up to 25%. And anything above $600,000, a lawyer can charge 15%. Now, under MICRA, each party is obviously responsible for paying their own attorney's fees, and the plaintiff's attorney's fees come out of what's recovered on behalf of the patient. Now, California's had the luxury of being protected under MICRA since 1975. There's been a number of different constitutional assessments as well as Supreme Court analyses. But I want to take a moment to take a look at the states, specifically California as compared to states without protections like MICRA, and how that impacts physician care, physician actually costs within those states. And I wanted to just digress slightly because I spent the first 20 years of my medical professional liability career in the state of Illinois. And I spent the last 7 in California. And so I have personal experience with both Illinois and California, not only as a clinician, but also as a patient. And what we've done here, I love this slide, we've taken specific specialties and looked at the costs of those specialties from a medical professional liability perspective. And as you can see, California for an OBGYN, on average, that OBGYN is going to pay $65,000 in medical professional liability expenses on an annual basis. Compare that to a state that does not have MICRA protections. And you see a state like Illinois, $179,000 on an annual basis for a physician to provide care to his or her patients. And New York is even more extreme at $202,000 on an annual basis. General surgery, kind of the same story. You see the incremental increase when there are not MICRA protections afforded to physicians and to patients. California, $49,000, Illinois, $120,000, and New York, $153,000. Internal medicine, very similar story, $13,000 in California under the MICRA protections, Illinois at $41,000, and New York, $41,000 as well. Now, having practiced in Illinois, I've spent quite a lot of time talking with OBGYNs who say, I don't make $179,000 a year. How can I continue to practice when my medical professional liability expenses are more than what I'm making? Okay? So it's a very, very challenging environment in Illinois and New York. And what we've seen in Illinois is that many physicians travel north to Wisconsin or east to Indiana, leaving the state in somewhat of a dire situation as it relates to access to care. Physicians are leaving the state and patients not having the availability of that particular specialty in their state. So what are the consequences of a micro change or a change or alteration amendment to the protections afforded to Californians with MICRA? Certainly we'd see a higher liability rate, as we saw in the previous slide, to consumers who are ultimately paying those higher healthcare costs. Remember what the San Francisco Chronicle said in 1975. We may see doctors leaving the state of California. Clinics and hospitals may close. Remember what the San Jose Mercury News said in 1975. Now, Mark Twain says history may not repeat itself, but it certainly rhymes. So we want to be mindful of what we learned in 1975 and maintain the protections provided to physicians as well as patients in the state of California. An interesting statistic here at the bottom of this slide, quadrupling the cap on non-economic damages would increase healthcare costs by approximately $11.4 billion annually, costing a family of four more than $1,100 a year. So ultimately, patients suffer, not only due to increased costs, but also due to less access to individual healthcare providers. And as I mentioned before, there have been previous challenges to MICRA. I'd like to unpack those here today. The first one we'd like to address is 2014. The initiative to challenge MICRA on that particular calendar year was primarily focused on physicians and physician behavior. And a diverse coalition, the Californians Allied for Patient Protection, actually came together and defeated that proposition 2-1 in every California county. So huge success in preserving MICRA in 2014. But again, I can't stress enough that that particular initiative was focused on physicians, and specifically physician drug testing, in addition to increasing the cap on non-economic damages. The primary focus, in fact, the first several bullet points are really focused on physician drug testing, alcohol testing, and the very last bullet point, and I'll read it for you because it's a little difficult to read on this slide, increases the $250,000 cap on pain and suffering damages in medical negligence cases to account for inflation. And that proposal was over $1 million. Again, recall from the previous slide that would have been an $11.4 billion impact to the healthcare delivery system. And here again, summary of the legislative analyst's estimate on net state and local government fiscal impact of the bill. Increased state and local government healthcare costs from raising the cap on medical malpractice damages, likely ranging from the tens of millions of dollars to several $100 million annually. Now, Prop 46 in 2014 primarily focused on physicians here on the left side of the screen. And then now we have what we're calling FIPA, the Fairness for Injured Patients Act, which is again challenging the protections that are afforded by MICRA. FIPA was originally brought in 2020, but because of the pandemic, it was punted to 2022. So we are facing this initiative this fall. Again, Prop 46, focus really is on physicians, required drug testing, use of the Cures database, and would have quadrupled the state's non-economic damages to well over $1 million. Now FIPA, the current initiative, only focuses on MICRA. There's not the physician drug testing, there's not the physician alcohol testing, there's not the focus on the Cures database. It is about the MICRA protections that are afforded to physicians and patients in California. And FIPA essentially makes a new law in that there are no caps on non-economic damages or attorney's fees when a patient claims catastrophic injuries, which is a new cause of action under FIPA. It eliminates periodic payments or annuity payments and allows for double recovery by not recognizing collateral source. It also extends the time frame for lawsuits or the statute of limitations. And it impedes judicial oversight of trial attorneys. And I'm going to go through each of these in a little bit more detail. As I mentioned, there is a new cause of action under FIPPA, and that is catastrophic injury. And I've spent a little bit more time on this particular nuance of the law, because again, there's no cap on non-economic damages or attorney's fees when a patient claims or asserts catastrophic injuries. Catastrophic injury, though, has a very unique definition, and it's defined in FIPPA as any level of permanent physical impairment, disfigurement, disability, or loss of consortium. So a very broad definition. In fact, personally, in looking at that definition, you could argue that a scar could potentially meet the definition of catastrophic injuries. And again, most, if not all injury, in my opinion, would qualify as catastrophic based on that definition. Now, it says when there is catastrophic damage or injury that has been determined, the non-economic damages cap does not apply. And micro-attorney's fee structure also does not apply. And the court is required to make an award of reasonable attorney's fees to any successful plaintiff. It also requires the jury to be told about the power to make a finding of catastrophic damages and elimination of the caps on non-economic damages. So significant change, new law, entitled catastrophic injuries. Now, FIPPA still recognizes non-catastrophic injuries as the existing cause of action. However, under non-catastrophic injuries, FIPPA proposes an increase in non-economic damages from the $250,000 where it is now, and it proposes an increase in inflation since 1975, which would bring that cap well over 1.2, probably likely $1.3 million on each and every non-catastrophic injury case. The amount will also adjust for increase, not any decrease in inflation annually thereafter. And a sliding scale, which we've outlined here, for a limit on attorney's fees. So very, very challenging environment to potentially deal with should the initiative be successful. In addition to addressing the new category, catastrophic damages, the existing damages, FIPPA also goes on to address periodic payments, double recovery, and statute of limitations. FIPPA proposes to eliminate periodic payments or the opportunity for annuity payments to be set up in the benefit of the patient, and requires full payment at the time of any verdict or settlement. It permits double recovery by eliminating the collateral source rule, and basically allows for double recovery by excluding the evidence that plaintiff's bills were otherwise covered through insurance or other vehicles. And it certainly changes the statute of limitations, extending that statute of limitations from 1 to 2 years, and then for a minor, extending that statute of limitations from 3 to 4 years. And then last but not least, FIPPA includes what's called a certificate of merit. And it's an initiative basically imposing requirements on all actions where a case is brought, so that the attorney it can satisfy the certificate of merit, proving that their case has merit and should be heard before the court. One interesting aspect of the certificate of merit as it's currently structured in FIPPA is that the attorney can satisfy the certificate of merit requirement by declaring that he or she was unable to obtain the consultation required because they made 3 separate good faith attempts with 3 separate healthcare providers, and none of those individuals returned their phone call. Okay, so realistically, an individual attorney who's suing Dr. A of company A, B, C, D could contact Dr. B, C, and D in order to obtain a certificate of merit against their partner, Dr. A, and receive no phone call, and thereby avoid the certificate of merit need. It's also interesting that under FIPPA, if the court determines that an action is meritless, it shall order the plaintiff's attorney to pay reasonable expenses, including attorney's fees incurred by the defendant. However, meritless means wholly without merit and for the sole purpose of harassing an opposing party. So a very limited exception as far as when something could be determined meritless. And again, the action shall not be determined meritless if the attorney has filed a certificate of merit and there's no verification process to that. So the consequences of passing FIPA in the state of California, certainly increased state and local government healthcare costs, likely ranging from the low tens of millions of dollars to the high hundreds of millions of dollars annually. Remember, that was what was put in the 2014 initiative, also focused on from a financial aspect from the 2020 and now the 2022 initiative called FIPA. But remember, it was also recognized as having financial implications in the San Francisco Chronicle in 1975. This measure ultimately will result in more frivolous lawsuits, and every lawsuit will start at a minimum of $1.3 million, the new non-economic damages cap. The measure hurts access to health care, and certainly costs, including medical malpractice coverage costs, will go up for everyone. Dr. Melman mentioned, can law save medicine? Dr. Batanti mentioned, every time, on time, the appropriate party to assure availability of patients. And looking at the numbers and the disparity in costs between Illinois and New York, and the conservative costs that Californians are able to ensure access to care by their medical providers. Thank you.
Thank you very much. Questions, comments?
I hope I don't speak out of turn, but I don't know that Sarah has described the Cooperative of American Physicians. Would that be out of turn so that people have an understanding what the organization is?
Please.
Sure, thank you so much, Dr. Koros. We are a California-based medical professional liability carrier. We provide medical liability coverage to 14,000 physicians within the state of California.
Dr. Letterman.
Thanks. So who is driving this initiative, this FIPA initiative? Who's behind it? What organizations are supporting it? What organizations are saying it's a terrible idea?
Right now, the organization that is behind it is primarily an individual. His name is Nicholas Rowley. He is an out-of-state plaintiff's attorney. He began his career in Ohio and now currently resides in Colorado. And the coalition, Californians Alive for Patient Protection, is the coalition of individuals who came together in 2014 and again in 2020 and 2022 to support MICRA and defend MICRA.
I'm sorry, go ahead.
Yeah, I was curious about one of the early slides talked about an $11 billion estimated cost. Just if you curious, just as a somebody who reads the literature on estimating the cost of these things, what that's based on, or who did the estimate.
I'm not certain who did the estimate, but it was done in response to the 2014 initiative as well as the 2020 initiative.
But would that be direct costs in terms of malpractice premiums or indirect in terms of, say, defensive medicine?
It's definitely indirect. It includes obviously direct costs, but it also includes things like defensive medicine, increased wait times, and things like that.
Dr. Kurtz?
It is interesting in California that nearly 1/3 of the residents are on government-sponsored health plans, including Medicare and Medicaid. So many of these people will not be paying it. So the actual cost to individual families, I suspect, will be much higher because there's only certain people paying the freight. So I would expect to see my premiums and my costs when I see a hospital to go up significantly.
Anybody else? Comments? Questions? Do you have a sense, when is it on the ballot? In November?
It's on the ballot this November.
And what are polls showing? Do we have any on that?
We don't have any current polls. We're in the process of getting them now. We are also doing focus groups as we speak.
If there isn't somebody else, I've always been curious about the $250,000 thing, and that amount of money, obviously in the 70s, is quite a bit different now. And so, just to sort of, have a little academic debate or something. Are any other states, are there caps anywhere close to that, or what's the lowest other cap in the country?
You know, there are caps in different states. Each state obviously is different, but California is very, very prized as far as providing health care delivery because of the $250,000 cap. You know, the discussion around fairness and whether 250 is too low. The question of fairness is, well, either but if in fact you increase the cap on non-economic damages, as Dr. Kouros indicated, you're going to be looking at costs that are spread across all of California. You're going to look at rates, medical professional liability rates that increase substantially and decrease to access. So fairness is a very challenging topic, but again, we firmly believe that in order to maintain appropriate access to care, right patient, right time, right service, that the caps are appropriate and need to be preserved. And the slide with the Excel spreadsheet really referencing the difference between what California physicians are charged versus Illinois and New York, very, very telling.
Let me just say something. Many states have followed California in MICRA, including Ohio, which has a $250,000 cap on pain and suffering, except for certain what California would call catastrophic damages, where it can go up to $500,000.
Oh, I didn't realize that. I thought.
And in fact,
California stood out.
No, I don't think so. And in fact, there's been repeated efforts in Congress to somehow impose a federal cap of $250,000. So far, unsuccessful, unclear what the constitutional rationale for that would be in terms of telling states, how to run their tort system. But that's another. Dr. Kouros, did you have a?
I was just going to say you see that each of these initiatives usually try to go a winding way to get around the cap, and now they're actually going full bore, obviously making this a trial attorney-led initiative, and it's really no longer about patients, right? It's about how much money the legal profession can make. There is no cap on anything related to economic damages. There's no cap on assisting patients with their future needs. This is just purely a play to crank up the cash. And, everybody in California knows it. It's just a matter of who's going to do a better job selling it on the TV screens and computers around the state when the vote comes.
Anybody else? Any other questions? Anybody in the remote audience? Yes.
Dr. Fred Cafferty.
Oh, Dr. Cafferty.
Just a curiosity, how has the medical malpractice industry changed over the past 20 years? If I'm a practicing physician, how many choices for malpractice coverage companies can I select from?
There are a large number of medical professional liability carriers, not only in California, but also nationwide. There's also self-insurance, captive insurance. There's a number of different opportunities for physicians to select their medical liability carrier. We actually just had a case that went to the California Supreme Court, and the Supreme Court underscored the importance of predictability under MICRA from a medical malpractice perspective. And I think that's one of the reasons that California has options as far as medical liability carriers that physicians can avail themselves to.
If I may follow up with that question, what about captive insurance provided by the growing employment of physicians? In other words, to what extent are physicians still having to buy malpractice insurance for themselves rather than getting it from, say, a hospital system that they're employed by?
Certainly, great question. Physicians that are individual physicians could or can be offered coverage through a captive insurance company if it's in fact owned or operated by the hospital or healthcare system. But they can also procure their own individual medical professional liability coverage from a third party if they so desire.
Do you have a sense of about how many what percentage of foundation physicians still get their own? Do you have it?
We see physicians who work full-time with the foundation and then also have work on the side, and so they need both types of coverage. It's just really depending upon their unique set of circumstances. We have seen, as readily available in the literature, more and more physicians moving towards the employment model. But we also recognize that there is a large contingent, particularly in California, of physicians who are solo and small practice and wish to remain independent.
Yes, Dr. Khan.
I think that we have to recognize in medicine that we have a little bit of a unique system. If the components of a car parts become more expensive, then the car manufacturer just raises the price of the car, and that's how it goes. All products more expensive. We saw with oil, gasoline goes up. I think it has to be recognized that if physicians' insurance goes up and they charge a payor more money, they're not going to get paid more money. There's no way to raise the cost of the product. So it's going to get squeezed by the physicians, and there's no way that a marginal physician is going to be able to cover that. And that would be in particular in the inner city, rural, less lucrative areas of practice.
Anybody else? If not, we are back on time, and so we will segue to Professor Mark Hall.
I should say the aforementioned Professor Hall. So it's a great honor to be here, and certainly in a group where, as I was joking with Dr. Batanti, he's read more of my articles than my mother and my wife put together. So, as the PowerPoint's coming up, I'll say that it's previously been disclosed that I'm among the faculty of this program that has no relevant financial conflicts of interest. So. All righty. So I'm going to report on a project that I've gotten involved with through the Brookings Institution in collaboration with University of Southern California, looking at the rise of private equity investment in health services delivery. And this is just to point out that, let's see, do I advance this way? I'm the least of this group. It's a really great group of collaborators who have led the thinking on this. Especially Professor Erin Fuse-Brown, who's at Georgia State, who would have liked to have been here as well, but her schedule prevented it. But this is a white paper that we released back in October, and it describes the phenomenon of increasing private equity investment, and then outlines a series of legal regulatory measures that might address some of the concerns. And so the concerns this raises, I think, are really at the heart and center of what this conference is about. And so I'm very pleased to be able to present this work and talk through and take credit for all these excellent ideas that my colleagues had. So this issue of private equity investment, which I'll describe in just a minute, but it's getting a lot of attention. Here's another white paper that came out earlier in the year, even more with a harder hitting headline than ours. Congressional hearings have been looking into it. And the reason for concern is that there's been quite an upsurge in this phenomenon that, again, I'll describe in a minute what it is exactly, but just this is a trend line, and I can't remember all, I can't see now, but all the little bars represent, but it's up and up at quite a rapid pace. And of significance, we're seeing more and more of this phenomenon in the simply in the arena of physician practices. So private equity investors buying up physician practices. It used to be we saw this more with hospitals or nursing homes or maybe durable medical equipment or whatever, something else, but really at the heart and the core of medical service delivery. And what we're seeing also differs from what we saw in the 90s. In the 90s, there was a big upsurge of investment in physician practice management companies, which physician offices obviously contract with. But that was a different kind of investment than this private equity investment. It kind of was a I don't want to say flash in the pan, but it ran a fairly, over the course of 10 years, sort of a rapid course of escalation and then de-escalation that made us wonder if this was going to happen again with regard to private equity. But I think it's distinctive in the following ways. There's a difference between venture capital and private equity. So venture capital is typically at the early stage of an enterprise, and this is more common, obviously, with drug and device development and the like. And it's looking to get in at the beginning stage and build up the business, which many fail because it is not previously established enterprise. And typically, venture capitalists put in a minority stake of their own money. So they're, I don't want to say passive investors, but they don't come in to sort of take over and run things. They are helping, each of the investors, and they're looking for very large returns, obviously, because, again, it's unproven, unestablished sorts of things. Private equity is investing in existing enterprises, looking at mature businesses where and this is speaking generally, not just in healthcare, but where the feeling is that there's more value to be gained from this existing enterprise. But it looks to gain that value, either increasing revenues or reducing costs or both, so that profits go up in a fairly short period of time, with the goal of then flipping, if you will, but reselling and making a large profit in terms of capital gains. And typically looks to buy the business and run the business, and not so much with the investor's own money, but through heavily debt financed and in a form that's known as a leveraged buyout, where the capital for the purchase is the security for the purchase is the business itself. So basically, they put up a small stake, maybe only 2% or something, and use that to leverage a very large loan, which is secured by the business enterprise itself, otherwise known as junk bonds. And so this, came into being in prior decades, and has been refined, and so has moved from various sectors of the economy. And I'm no expert on such things, but the point is that this sort of method of investment has now found its way to physician services. And that's different than what we saw in the days of physician practice management companies, where that was back at the beginning of managed care, and a lot of physician practices were still sort of cottage industries that sort of ran themselves and didn't have professional management. And the startup enterprises there were not the practices themselves, but the management the companies that managed physician practices, and so that turned out to be, well, oftentimes the physicians still own their own practices, and the management company was just a contract. But here you have the management function, combined with actually an ownership stake in the very profits of the enterprise. And so the notion of our title, private equity investment as a divining rod, is that perhaps it's a good thing that this is occurring, because basically these investors are savvy, and they're finding places where there are these extraordinary opportunities for profits that result either from some form of market failure or imperfection, or some sort of wrinkle in the billing rules and so we should just follow them around and find these problems in our billing rules or in our market structures and fix them. And so we were talking about structural fixes versus other things. If we just see where the private equity is going, we know where there's a problem that needs to be fixed, because otherwise they wouldn't be putting their money in it if there wasn't huge rewards to be made. And usually if there's huge rewards to be made, it's exploiting some type of opportunity. So that's a little bit of tongue-in-cheek in terms of, well, thank you for pointing this out to us, but the idea is just reduced to its essence. If we're seeing this investment, there's probably something not too far below the surface that we're at least uncomfortable with, but that definitely needs more attention. And so one indication of this is the particular specialties in which we're seeing this private equity investment. And there's a fair number of these that are not hospital-based, that are community-based specialists, but a fair number that are hospital-based. And you'll see among hospital-based practices this sort of concentration, and don't worry about the numbers, but just kind of, the darker, the bigger numbers have darker coloring to show you that we have this concentration in anesthesiology, radiology, emergency medicine, and internal medicine's hospitalists. People sitting right in front of me probably have some appreciation for why that might be, but I don't know who else online. But the point is that these are all hospital-based specialists that are not typically the patient's primary point of contact. These are not the surgeons and the community physicians and whatnot, but these are the ones that when you show up to the hospital to get assigned to your case, and that without the patient having much say over that. And so this is where we've seen this concentration of what we call surprise billing. And so what essentially this shows you is that private equity had sort of sought out this surprise billing notion or opportunity and exploited it to a considerable extent, which now Congress has fixed. And so I'm not going to give you a bunch of slides on surprise billing, but I'll just sort of quickly remind you that bills are very complicated, like this one, and usually once you get to the bottom line, this is your reaction, and oftentimes it's because what's happened is you thought the patient thinks that they've stayed in network, they've worked with a doctor they know, they're going to a hospital that they know, but lo and behold, the ancillary hospital-based physicians have remained out of network. And at a time that might have been just sort of occasional here or there. At my university, for a while, the physician practice, the medical school, was separate from the hospital, and they each had their own contract with Blue Cross. And there came a time when, I forget which was which, but one half kept their Blue Cross contract and the other canceled. And so it was like, wait, are we covered by the state's major insurer or are we not? And that, those sorts of things can occur. But to actually, and this quickly got fixed, but to adopt as a business strategy the staying out of network, because the feeling is, of course, you can't do a surgery without an anesthesiologist, et cetera, and you can't run an emergency room without emergency physicians, that they can simply say, I'm not going to agree to a contract, or I'm not going to agree to a contract at the rates that Blue Cross is asking. And so there's a lot of finger pointing, and these specialists saying that that the insurance company, whoever it is demanding excessive discounts, and the insurance company saying you're demanding many multiple times more than let's say Medicare rates, obviously, but the average physician wants 25 or 50% more than Medicare to be in the network, but you're asking for 3, 4, or 5 times Medicare, or maybe even 10 times, and so basically end up with big gaps in the insurance network. And so at some hospitals where one of these private equity backed firms acquires all the emergency physicians or all the anesthesiologists, there's basically no one in network with the major plans. So the patient's left holding the bag, and so Congress finally came in and said, we've got to fix this problem. So as of January 1st this year, if you go to a network hospital or an emergency room, the patient has to be treated as if they were in network, and then the billing dispute gets resolved by independent review process that I'm not going to go into, but the idea is that a lot of the private equity money was coming in and generating their sort of super returns by adopting this aggressive contracting and billing practice. And so that is one example, and there are others to be found if we look at some of the other specialists. I should have shown another slide, but in the report, in terms of the community-based specialists, big leaders in private equity are dermatology and ophthalmology, and the report explains well the reason is because those are specialists, number one, that aren't referring to hospitals for admissions quite as much as, say, internal medicine or whatever, or cardiology, so they haven't been bought up by the hospitals already. And secondly, it turns out, well, they have certain procedures and billing codes and such that can be used to generate handsome returns. And so whether it's the way of, removing, moles on your skin, or treating eye problems, or some type of pharmacy billing rule under Part B or whatnot. I don't know the details, but each of these cases, people in those fields can say, oh yeah, the reason they're doing it is bang, you have this opportunity to generate a lot more revenues. So this all brings to mind some of the thinking that Professor Melman and Dr. Batanti were discussing, which is there was a time, back in the eras that they're referring to, where we said, well, there's a reason that we have strong professional ethics and that we don't try to run medical markets under sort of standard economic principles, because of the trust, because of the disparity in power and knowledge, and the whole notion of being sick and turning yourself over to care, that we simply can't have normal sort of financial investment running the basic structure and functioning in medical markets. And a number of us were brought up in an era where, and when I make this point, I often say it's sort of back from the era of Norman Rockwell medicine. So I'm glad I didn't realize that Max is actually from Stockton and what have you. But I do that by way of saying it has this sort of feeling of an old-fashioned idea that it's the kind of thinking that's been criticized. And so I'm sorry, this slide refers to Kenneth Arrow, the Nobel Prize-winning economist, who one of his classic papers sort of makes this point in terms of what's called welfare economics. It doesn't mean welfare like Medicaid, but the sort of branch of economics that talks about whether people, basically consumers, get good value for their money, and whether goods and services are properly priced. That's what he means. But what we now call value-based pricing. But in any event, for the longest time, I always sort of put this body of thinking in sort of the old-fashioned, sort of style of thinking that led to excess physician paternalism. The doctor knows best. Ask no questions. Treat first. Insurance company reviews afterwards. It happens to be an insurance company that was founded by the medical profession, i.e. Blue Shield and such. And so this hands-off, no questions asked, blank check sort of style of medicine is something I spent a lot of my career criticizing. It's saying this type of thinking has sort of gotten in the way of what I and others view as valuable innovations in terms of payment methods, capitation rather than fee-for-service, or value-based, payments based on episodes of care and that sort of thing. Well, now I'm realizing, Kenneth Arrow had something to his thoughts, because the point is, if you sort of bring in decision makers who are completely unconstrained by notions of professionalism or duties to the patient and fiduciary and what have you, boy, I mean, there is a lot of either market power or billing opportunities to be exploited. And if you just sort of say no holds barred, I mean, you start to see things that everybody agrees shouldn't be happening. And the surprise billing is a good example, because that was a bipartisan reaction that it's so rare to have anything bipartisan these days, that it's so obviously wrong that just about everybody got behind it. So the point is, there's can go into more detail about the extent of concerns and the nature of concerns, but I think this audience doesn't need that convincing. The question is what to do about it. And so I'm trying to remember, what's my target time?
11:55.
Okay, I've got plenty of room then. Okay, great. So solutions. So our group came up with sort of two buckets of approaches. One are legal regulatory measures that are specific to private equity investment, and others that are more general, that say, look at what's the broader problem, the system problem, and go after that, versus is there something specific about private equity? The problem about targeting private equity is that, it's a difference of degree rather than kind. It's not like, a certain amount of debt and a certain, degree of, that suddenly tips the balance from one to the other. It's kind of the extreme of a sort of a general phenomenon, and it's hard to sort of isolate that particular category and say get special treatment. But there's a couple of possibilities. One simply is transparency. Who's running the show? Who owns the practice? What percentage and what are they doing other than just running the billing and contracting? Are they doing other things like participating in the profits and such like that? So just good data, because getting the numbers I showed you are sort of hard to come by, and they don't really penetrate much below the surface of an investor has put some money in, and a management company now runs things. So some type of, a lot of stuff gets reported in Medicare cost reports and that sort of thing. So similar in terms of ownership of physician practices, just sort of a Sunshine Act type of approach. The other is going back to the good old corporate practice of medicine doctor. I'm sure we'll talk about this more, but again, I was one of the ones that sort of criticized the excessive use of this to sort of stamp out any form of influence of physician decision-making that might have the slightest whiff of economic motivation, which I always sort of caricatured as well. No one can have economic motivation other than doctors, right? Because they don't work for free, they don't work for a salary. But the problem with the classic form of corporate practice is it took such a... So this is the doctrine that says only licensed professionals can run a professional practice, and non-licensed, non-professionals can't have any role in its ownership or control. To take and in particular, physicians can't be employees. And so to a large extent, the doctrine is understood by its exceptions, because of course, as we've just heard, 70% are, but they are because of exceptions. And so we've sort of body of law saying, thou may not unless, and then we just get a series of unlesses. But going back to the thou may not, I think I've been convinced needs some revisiting, and perhaps there are ways to target and activate the corporate practice prohibition in a way that I don't think is that isn't quite so sweeping and overbroad, that would say, what are the elements of control? What are the elements of divvying up the proceeds? And do they sort of violate sort of basic standards of professionalism in ways that don't sort of call into question, sort of the standard arrangements that we've sort of come to accept. So are there sort of principled ways of making these judgments, and who should make them? And so I think that's a meatier topic that we can spend some more time on later in the proceedings. But I'll move ahead to the other ideas quickly. Broader-based measures would say, what are these more system-based things that seem to attract private equity, but maybe having attracted it, we can do something to fix the bigger problems. And so I've sorted this into primary and secondary fixes. So the primary fixes, one would be simply market defects. So we have had a fair amount of antitrust scrutiny of hospital mergers, but much less so of physician mergers. So one of the strategies here is to buy up all the specialists in the area, and so that you've got them all in one large group, and then demand super high reimbursement rates. There might be a need to look at how the antitrust rules apply to market concentration in physician practices as well as in hospital care. And so that's one area. There are also billing practices that might need to be visited. And so we mentioned surprise billing as one, as a general sort of billing practice out of network care, but maybe there's specialty-specific things that would need attention. Another sort of secondary thing would be tax rules. So one of the strategies in terms of the contracting leveraged buyouts is, and this is so far beyond my field of competence that I hope I don't mess up what my colleagues said, but essentially the strategy is, as we all know, ordinary income's taxed at a considerably higher rate than capital gains. And so in any business deal, you're better off reporting your proceeds as capital gains than ordinary income. And there's ways of doing that on both sides of the transaction so that the acquiring company, the investors who run the show can basically charge a very low rate for the management services because that's ordinary income, but then end up taking a very large share of the profits when it's sold, and basically sort of bankrolled a lot of their management fees as future capital gains, so that maybe they put in 2% of the investment and end up with 20% of the profits. Maybe they take only a management fee of 2% rather than whatever's more typical, multiples higher than that. And so that's just sort of a general tax rule thing. It also affects when you purchase the physician practice, paying a handsome capital payout to the physician, anticipating that perhaps their income in future years will be reduced. But that again can this is perfectly legal, but the point is it being abused? But that's a much broader question that affects many other areas of business, and I would think it would be quite an undertaking to try to tackle that in this one context. And so I don't know that that's the most promising route. Maybe more to the point in ways that could be targeted more to the healthcare arena would be certain terms of the employment agreement. First being restrictive covenants. So if the private equity investors come in and pay a big capital purchase price to buy the practice, they want to make sure that the physicians, stay on board, and so they're very tight, non-compete agreements. Oftentimes, because one of the strategies is to buy out a marquee group that has a lot of brand recognition, and then essentially take that branding and apply it to a lot of other groups that don't have that brand recognition, and sort of, I hate to mention some famous brand as an example, so I won't. Mayo Clinic or something like that, and starts going in, and if private equity would buy up Mayo, and they would just go to every little town and spread Mayo everywhere. I guess I like that one. You're basically, but having done that, you don't want your marquee physicians to walk on you. So that's one thing. So there's a lot of law about the how restrictive these covenants could be, and how much freedom physicians retain to leave the enterprise if they don't like how it's being run, and that's partly the problem. You sell out, and then you see, gosh, I really don't like how they're doing things, and so I think I'll leave, but you're stuck. And so that's an area I think that could get more attention. It's kind of the who's the scholar, Exit, Voice, and Loyalty, that famous academic in the room that our business school representative, they love that fellow. Starts with an H. Well, I'll come back to me later, but they're ways of asserting a sort of control and influence, having a voice, but the other is being able to leave if things aren't going well, so preserving that exit option. The other is are gag clauses, and these came into discussion during the anti-managed care kickback era, where HMOs felt that doctors were disparaging them by talking to their patients about how awful the HMOs or the managed care plans were treating them, and so then began to stick in these anti-disparagement clauses, and there's this huge backlash against that, the idea that you would constrain the doctor's ability to express their opinion on what is acceptable, decision making about prior authorization and such. And so we had these on the books for in the managed care context, but what about in the private equity context? If doctors start to speak out and say, I left because you wouldn't believe what they're trying to get away with, but suddenly bound by non-disclosure agreements and things like that, that would keep them from speaking out. And so I think that's an area that merits attention, and some, I think, fairly targeted measures could be adopted. So there's a list, I think, for us to to dive in on when we get to the what do we do next stage of the discussion. And with that, I think I'll just stop. Thank you for your attention and take questions in our remaining time. Thank you. I'm just going to stay here in case, or never mind.
Yeah, stay there.
Yeah.
Professor Hall, you don't know how applicable this is in California today. I'm going to guess that most people don't even know this is happening in medicine. Would that be correct?
People in medicine know it, but I think outside. Yes,
nobody
no,
knows what's going on.
They do not. That's right.
I just wanted to point out that the outpatient specialties that are heavily involved are involved for one major reason. I'm an ophthalmologist, by the way, so
okay.
I know.
I
have been solicited multiple times to sell my practice to private equity. Also dermatology. The reason they're very interested in our practices is we have a lot of cash component to our business, and that's where they won't want. It's not billing, it's not drugs, except maybe in the retina sphere. Some of these specialties are involved in very high-cost drugs, and there's an arbitrage involved in a markup. And if you start doing really high volumes, you're talking about millions of dollars spread among many practices. But specifically in ophthalmology and dermatology, it relates to cash businesses, doing extras, and that sort of thing. The other one that's very big now is oncology. Oncology is massive because, again, they're involved in chemo drugs, and the arbitrage of 125% of the actual cost can lead to basically millions of dollars. And I can share some other stories regarding shady business practices of these sorts.
Yeah, and that was my experience when I gave this talk at Harvard, and a group of researchers who worked in a lot of different fields, and we had a longer list, and they wanted to talk about each specialty, and I was like, you'd hear about this little wrinkle and that little, whatever. And so it sounds like, yes, that I learned a lot just hearing macular degeneration. Something about that.
The drugs are $2,500 a pop, could basically bankrupt Medicare. But the last point I wanted to make is the corporate bar. Wherever there's a corporate bar, there's a way around it, and the attorneys, as you know, are very brilliant about getting around it.
Yeah.
It's very, very difficult to do. In California, we've had the corporate bar forever, but they've worked around this in so many different ways. And as far as private equity, they always find a physician CEO, and then they always get around this sort of thing. But
I had a different slide on the corporate structure, but I didn't want to glaze people over. But you're right. I mean, crafty lawyers, and so that's part of the problem. When it applies, I think it tends to be too sweeping, at least that's my view, but then it's too technical so that it's too easy to get around. And so it doesn't sort of get to the substance of what's going on, and maybe some creative minds could think about how to do that. And I think there is some legislation pending in California that would say, that speaks, and do you know about that? That speaks directly to.
I know I actually have the law here in the computer. I'll call it up in a little bit. But what they're looking to do is control the marketplace and not allow private equity to make an easy entry into marketplaces where there perhaps be no competition. So they're looking at the anti-competitive.
Thank you. But I thought there's something else about the control element of physician involvement but we can chat about it more in the other discussion.
We have a question from a remote member.
I don't know that it's a question, but Daniel Wolfson makes the comment that corporate practice of medicine was used to bar group practice HMOs and was not effective, thank goodness.
Right. So that's my school of thought, that it had been used in anti-competitive ways to keep out alternative financing arrangements. And the reason that it didn't serve as a bar is because basically federal law came in and said that states have to back away if it's a legitimate HMO, and similarly to federal law talking about ACOs now in terms of Dr. Batanti. I want to know how can they do this, and they're allowed to do it because federal law says if you're an ACO, you can do it. Otherwise, you can't. But whether that makes sense and what justifies it is a further conversation. But I think here it would be harder to say what is it that constitutes an illicit kind of investment without saying no investment whatsoever. That's a tricky thing to define. But I think maybe the element of control that and how profits are sort of distributed and things like that are more concrete things for which you could develop indicia that would say this is okay, this is bad, this is a gray zone in the middle that we have to think about more.
Dr. Hall, I'm just curious. I thought the presentation was fabulous. I'm curious about the private equity and the venture capitalists that went into the hospital-based space and then were potentially surprised by Congress's position or change in position, and how that impacted their ROI, and potentially are they divesting of those investments now, or what is their strategy as of January 1st?
Yeah. So in terms of these hospital-based practices, yes, they lobbied hard against the Surprise Billing Act because, I mean, their feeling was we put our money on the line, and based on the assumption that we could do business this way, and now our legitimate investment expectations are being defeated or disappointed. That's not what they said to Congress, though. But what they said is because, I mean, that's a legitimate reaction if you're an investor. They said other things, but that ultimately weren't convincing, and then they ended up sort of producing a compromise in terms of how the billing gets settled, and that's all in court, by the way. So the big nobody. Ultimately, they couldn't defend the position that patients should be subjected to this treatment. They defended the position that physicians should get paid what they're worth, and we want a respectable way of determining what that is when we haven't contracted, and we don't want the law essentially to force us to contract for rates that we think are substandard. So it's all down to this dispute resolution process, and the agencies took a pretty aggressive approach to writing the rules, and they're pushing back with lawsuits, and so we'll see where that all fleshes out. But if the agencies approach, if they don't win in the lawsuits, I would expect there to be some divestments. Yeah.
So how have other countries that have had better outcomes, cheaper care, and greater levels of patient satisfaction dealt with these issues?
Well, that's a good question. I mean, my sense is it would be a rare country that would even contemplate this possibility. I don't, you sort of, it just sort of would never even come up. And whether it's prohibited or whether it just, it wouldn't be discussed, that people wouldn't return the phone calls or whatever. These are also countries where physicians earn considerably less, where the fee schedules are sort of rigidly enforced, and other aspects, and so it just the whole financial environment it doesn't lend itself to these kind of strategies.
Dr. Frizoff.
Being on the far left of the people in the room, my question goes back to your title, which is Private Equity as a divining rod for market failure, and particularly in relationship to the comparisons that my colleague here on the left just raised, why don't we say a divining rod for social failure?
Good point, yeah. Regulatory, market, social, and professional, I don't want to say professional failure, but a sense in which perhaps principles of professionalism don't speak as directly as they could. And one reason they don't is because the main voice of professionalism has been organized medicine, and for antitrust reasons, they've been told that they can't speak as directly. And so another idea I'm sort of noodling over, although I can't get a lot of enthusiasm from my antitrust scholars, is should we create kind of an antitrust safe zone for folks like Daniel Wolfson and what have you to get together and talk about revived professionalism. Now, I didn't mean to point the finger to him. He works for a foundation and not for directly for organized medicine. If he's still online, he can speak for himself. But the point is, again, sort of rethinking some of my old sort of standard Chicago school, and I did go to the University of Chicago training. Finding a way to, without threatening antitrust, anti-competitive behavior, reinvigorating sort of voices of professionalism from within the profession.
If I might offer a brief correction to Dr. Frisoff's excellent point, although I may be sitting to his left right now, I do not reside on the political left of Dr. Frisoff.
So I have a question. Going back to one of the fixes was greater transparency, right? For who would the transparent information be aimed at?
Well, I don't think it's realistic to say to the patient. I mean, you could imagine the patient says, but, it's just, there's only so much the patient can process. It could just be kind of one article I wrote a while back with Bob Berenson, who people know, we call it the red face test. If you can live with this, then okay, fine, good for you. But the point is just to sort of shine a light on this, so that you've got to sort of face up to your colleagues and what have you in your own conscience. I don't know. I'd like to do more sort of in-depth interview work to talk to doctors who've been through this and say, well, is there a sense of not being responsible for this, refusing to negotiate, or no, I shouldn't say refusing to negotiate, refusing to join an insurance network at the prices being offered. Do you just sort of say, well, that's not my decision and the front office handles that, or do you have a sense that this is really part of what you own as a professional? So I think that kind of self-reflection could come from the transparency. It could also be something that regulators could use to kind of begin to fine-tune some measures. So
the point I was getting at is, I'll be talking around this later this afternoon, but one solution to the problem of conflicts of interest that physicians may face for any variety of interests and reasons with their patients is disclosure. Right? Just tell the patient, by the way, I hope you know that your HMO gives me $5 to do this, and after that, candy spread.
I don't believe
just thought you'd like to know. Is not a satisfactory solution, given that patients often don't have choices.
But on the conflicts, the payments from drug companies and such does go into this big reporting thing somewhere, and nobody ever looks at it until some reporter wants to do a story, and then they can look at it just like that and ban that doctor's name is in the press and received X amount of money, and it just looks bad, and so I think you're sort of more subject to that kind of thing.
So there are many sides regarding the surprise billing issue, and I can speak specifically because I know much about this. We had a big fight in California over this. But as a private practitioner, almost all of the private insurance companies offer a contract that pays less than Medicare.
Less?
And it's take it or leave it. This is very common through the state of California. It's becoming more common across the country. And so now you might understand why a lot of doctors will not take what's being offered. And that's what's happened is the insurance companies made front groups, patient groups and things, and went to the legislator and said, oh, this is a huge problem. Look what's happening to us. And they sang the sob story. But the sob story from the physicians being paid less than the government rate never got out there.
I hadn't heard that either.
And so there's a lot of stuff to this story, and the insurance companies and the large capitated medical groups, and I take capitation, don't get me wrong, have figured out the way to do it, and they took it right up to Congress and won. The story was not told, and the bugaboo with these private equity people, but there's the small doctor who's caught in the middle. And there are colleagues who get paid $350 in the middle of the night to do an appendectomy. And that, to me, I think everybody realizes that $350 is probably being way underpaid in these days. But that's how they do it, and so the only way these physicians can get paid is to be out of network. And so there's a lot more to the story than is in the news and is in the Congress. It's different when you're in the hospital and you have the concession for emergency medicine or pathology or anesthesiology. But even those professionals are offered contracts oftentimes below Medicare. And so the only response to that is to be out of network. So it's a very complicated picture, and I hope we have some time to look into that.
Well, let me be clear. The law doesn't say it's bad to be out of network. It just says if you are, protect the patient and then resolve the payment through this dispute resolution.
And there were other ways of doing it, but that was the most favorable to the insurance companies because they know physicians cannot take the time to do anything like that. By the time you start doing that, you're losing money.
All right, with that, let's thank all of the speakers this morning and those who contributed questions and comments. We'll take a break till 12:30. For those of you who are here in person, lunch is provided outside. You can eat at any where, and we will reconvene at 12:30 with Dr. Busson.
And I knew Max would go here and then. I've been wrong, he's been right all along.
I can't remember. I'll let you have one for the,
No, just, we've had our, whatever, man, whatever.
You serious?
Yeah, you're serious.
Oh, okay. Are you serious?
No, I'm being
Yes, they're not piecework the way.
No, there are some.
So are you?
this educational program has any relevant financial relationships with ineligible companies. Well, we're talking about collective bargaining and physician unionization, and I wear my International Brotherhood of Laborers hat of 45 years ago, 50 years ago, Local 125 out of Youngstown. And I'm grateful for them for their collective bargaining because they allowed me to get through school with no debt. And so I appreciate what they did for me. Dr. Bussey is going to talk about physician unionization and why that's relevant now. We've heard already that 70% of physicians now are employed. When you're employed, what do you do? What's your job? You are to do what the boss tells you to do. And when patient care is the issue, are you going to do anything that is against the patient interest? And the answer is, well, you have an obligation to your boss or you're going to be insubordinate. So you're in quite a compromise. Unionization of physicians is one way to handle it. And I'm going to talk about after you've unionized, what is the benefit of unionization? And it's actually only two things. One, collective bargaining, and two, concerted activity. So we're going to start now. Well, I told you I'm from Youngstown, and I told you I was a Manila Maris fan. I also had one idol as a youngster from Ohio, and that was Hopalong Cassidy. But as time goes by and you enter the adult world, and especially one of labor, organized physicians, you end up studying other individuals that have been successful in the same kind of endeavor. I have turned into a big fan of Jimmy Hoffa. Yes, he had problems, and yes, he paid heavily for them. But one thing is undeniable about Hoffa. He formed the biggest union in America, and he was incredibly successful in raising the standard of living for his members. It's undeniable. He was so popular, he could have got elected president from prison. But if we're going to talk, let me make one more comment about Jimmy Hoffa. One of the favorite interviews I ever saw of Hoffa was they said, Jimmy, well, what exactly do you do? He said, I only do two things. I negotiate contracts and I enforce them. That to me is clarity of purpose, and I appreciated it, and I've tried to bring some of that to the physicians union, that's what we do. Let's not get distracted. But we're from Northeast Ohio. Can't talk about unions in Ohio without talking about the Steelworkers Union. Abel was the third president of the United Steelworkers from 65 to 77. And to his credit, by the end of the 70s, the United States Steelworker was the highest industrial paid worker in the world. Not only did he represent steelworkers, and the steelworkers today represent the aluminum workers, the atomic workers, the upholstery workers, brick and glass workers, pharmacists, school administrators, so they do more than steel workers. We're going to talk about his very famous ENA contract that he negotiated in '73, might be termed the greatest contract ever, and also too successful a contract. Well, what is collective bargaining? The term was originated in Britain, and the Samuel Gompers developed it in the US, but it's collective bargaining really is defined as the continuous relationship, not sporadic, continuous relationship between an employer and a designated labor organization representative of a specific unit of employees for the purpose of negotiating written terms of employment. Why the continuous part? Continuous part is that it's there to enforce the terms of the contract. And in addition, in a well-done contract, there's the ability of labor and management to come together anytime to see if they can solve common problems and increase productivity, which makes everybody's ability to bargain much easier. Is collective bargaining relevant to physicians? Well, it's only relevant if you decide it's relevant. If you want to go it alone, you think you can go it alone, that's great. But the Union of American Physicians and Dentists organized the LA County, all LA County physicians, employed physicians, which is 1,000 strong. And here was Dr. Weinman when he announced the Union of American Physicians representing them. Collective bargaining, there's some misconceptions about collective bargaining. Two sides are coming together. It's usually portrayed as the labor saying screw the boss, and management believing to keep the union in its place. Strikes, pickets get the headlines, but strikes really peaked right after World War II when everybody was trying to get a piece of the action. And the reality of it is only 2% of all AFL-CIO contracts have ended up in strikes. Well, how do you get to collective bargaining? How do you get to the place where you're in a position to collective bargain? Well, first, a bunch of, let's say this case, employed doctors have to organize. They have to pick who they want to be their representative. Everybody thinks the only people that can represent you is a union. That's not true. It can be anybody you pick as a representative. One of the most powerful representative bodies is the Teachers Association. They're not a union. I mean, I think they are a union now, but they started out as an association, and so anybody you pick can represent you. You have to go through the petition process. You have to have a ballot. And then finally, your representative is certified as your sole representative, and then you begin contract bargaining. What are the laws that protect this activity? Well, in the private industry, National Labor Relations Act of 1935 really establishes this. And there's a couple sections that are critical to understanding labor, unions, and its rights. Section 7 is a critical section. It states, all employees have the right to self-organize, form, join, assist labor organizations, to bargain collectively through representatives of their own choosing. That's the law. Second thing, and to engage in other concerted activities for the purpose of collective bargaining of mutual aid or protection. What's that mean? That means you can get together with your colleagues legally and take some action to force the employer to see maybe the wrongs of their ways or the rights of your ways. Now, a lot of strike activity that happened in the 30s are unlawful now, but still informational pickets are lawful. Dissemination of information is lawful. And so concerted activity is a critical right. So 2 things out of Section 7. Organize. Number 2, concerted activity. What about Section 8? Well, what's the limits of the demand. Let me see, I think I might have missed one here. I think I did miss one. Oops, I went the wrong way. Here we go. Section 8. We talked about Section 7, Section 8. It's an unfair labor practice for an employer to interfere with your organizing, number one. Number two, it's illegal to refuse to collectively bargain with a representative of the employees. Mandatory. You've organized, you've picked a representative, the employer must collectively bargain with that group. What about Section 9? They're your exclusive representatives. This prohibits different factions from getting different representatives. Once you've elected your representative, you speak with one voice. What are the parameters that you're allowed to discuss? Should be exclusive representatives for the issue of pay, wages, hours of employment, and working conditions. That's private employers. What about the government employees? They require special statutes to allow union representation or representation. In California, we have the Dills Act of '78 that allowed bargaining for state employees, including state-employed physicians, which there are quite a few. And Meyer-Milius-Brown Act in '68, collective bargaining for municipal, county, district employees, covers all government employees. Oops. What happened here? How did I mess this up? Okay. Okay, we're in good shape now. Well, after you've picked your representative, what's the next thing? You have to establish a bargaining unit. These are the people that you're going to represent in your negotiations. This is a very important part of the negotiating process because employers will want to get a huge designate a huge bargaining unit so that you cannot get them to all agree to be unionized. And it's better to have a small bargaining unit for the sake of establishing your rights to bargain, but then you've excluded people from your bargaining unit. So who makes up the bargaining unit? Really at the bottom, it talks about how you pick the bargaining unit. They have to share a community of interest, similarity of jobs. When we're doing physician bargaining, it's physicians of all types in one institution or state doctors, no matter where they work, prison, outpatient clinics, we get all the doctors. And the doctrine says they have to have a similarity of job functions, skills required, and a high amount of contact in between themselves. Then you have to have a bargaining team. The lead negotiator is critical. You can't have an inexperienced person doing the lead on bargaining. The other side is going to come well done, and they're the ones that have to say yes. Their reflex position is no. That's it. No, 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 and no. So you have to be able to counter that with some arguments that will carry the day. And bring in the bargaining team. You have to bring a team with different agendas. Everybody represented. The prison. When we do the state doctors, we bring the prison doctors, the community doctors, the hospital doctors, because they all know the inside problems. Now, what are the limits of the demands that you're going to try to make when you're bargaining for physicians? Well, you have to be prepared. You can't go in there and just look at each other and see who's going to blink first, because you're not getting anywhere. You're just staring each other down. So you have to do your research. You're allowed to ask for any information from the other side that you want, because when you ask for wage demands, what's the first thing they're going to tell you? We can't afford it. How are you going to argue with that if you are not entitled to their financials? They have to come in with their financials and show you exactly what it is that they're making. So you can ask for any bit of information. If you don't ask, you're not going to get it. Ultimately, the bargaining is influenced by the relative bargaining power. Simply, there's one rule that you have to know. If it costs more to disagree than to agree, the party will agree. For example, if the other side needs so much work to be done, you ask them for a certain amount of remuneration. If they don't get the work done, it's going to cost them more to say no. So they're going to say yes. We have to have this work done. Now, I've done a lot of contract work for individual physicians, and I always, I used to, go through it, look at it. Now I do go about it a different way. I ask them first, have you signed this yet? And the answer usually is, yeah, I signed it. Well, then what are we talking about? You already signed your contract, individual contracts. And the only thing they ever do, they go right to compensation and they look at it and okay. They don't know who they're working for, how frequently they're going to get paid, if there's any compensation for productivity. No scrutiny to any restrictive covenants that Professor Hall was talking about earlier. And so it's really foolish behavior by physicians when they're doing their own contracts. But when you're doing it as a union, you're looking wages, benefits, working conditions, mandatory terms of a contract. So how do you fix the wages in physician contracts for a union? Well, you have to come in with something. You just can't come in, you want this. You go to surveys, you go to government reports. The government has a report on every industry, how much they make, specialists, and so it's hard to argue that is the going rate. Now, if you want more than the going rate, what are you going to say? How are you going to get more than the going rate? Well, if there's a particularly bad, rough, tough, unpleasant jobs, such as the prisons in California, you ask for their vacancy rate. What's your vacancy rate in the positions that you have to fill? And when you see a 70% vacancy rate, the argument is that we're not walking into a hospital with crisp white coats with embroidery on it, walking through the halls, hi, Dr. Smith, hi, Dr. Jones, salutation, how was your weekend? Oh, it was wonderful, thank you. No, you're walking into a prison where the prisoners are spitting on you. That's not the same job. That requires substantially more money to get somebody to do that. It just makes sense, but if you don't illuminate it, then you're not going to get it. One of the things that employed physicians, we're going to start to go through some of the things that we negotiate for employed physicians that you would not think the private doctor or small employed physician would not think are even possible to negotiate. But we've negotiated all of these issues. Pensions, that's fairly straightforward. But leaves, how many type of leaves do you think you could negotiate for? How about holidays? How many? How about allowances? What about merit salary, business expenses, merit awards, parking incentives, housing rentals, license renewal, continuing medical education? Every one of these is a bargaining point. Let's go through the leaves that we've negotiated for physicians. Vacation leave. Some of these I didn't even know existed before I started to do this. Vacation leave, sick leave, bereavement leave, military leave, jury duty, training leave, catastrophic leave, annual leave, disability leave, parental leave, adoption leave, catastrophic natural disaster leaves, personal leave, mentoring leave, work and family participation leave, organ and bone marrow donation leave, and a day off to go get your annual physical. How about health and welfare benefits? You got health, dental, and vision benefits we negotiate regularly. Long-term insurance, industrial death and disability leave benefits. How about working conditions? We negotiate meal periods, rest areas, callback assignments. And when it comes to physicians and their superiors, which are many times non-physicians, and may ask you to do things that you know are not in the patient's best interest, we started to get into discipline, and we negotiate adverse actions, progressive discipline, appraisals, performance appraisal, malpractice suits. Very interesting. When I first started to do contract negotiations for employed physicians, the state says, yeah, well, we will defend you. Well, defending me and allowing me the choice whether I agree to your settlement or not is something that most great carriers, such as Ms. Sher's company, will give you the option. You want to settle, or do you want to go take it to the distance? You work for most employers will tell you, we decide what we're going to do with your case. The other thing is that I have never seen them yet cover fees to represent you in front of the medical board after they report you to the medical board for a malpractice action, which private carriers such as Mrs. Sher's does cover. But the number one reason physicians come to the union to be represented is this final issue. They have been pushed around and told about making professional judgments. This is the number one reason physicians want to organize and be represented. This is a contract. We will not sign any physician agreement that does not have this in it. The parties agree shall not practice, nor shall they be required to practice in any manner which places their professional license in jeopardy. Well, you say, well, what kind of behavior would that be? Sometimes the administrators want you to use a cheap medicine instead of a more current medicine. Sometimes they have equal benefits, but one has much more adverse reactions. So their argument is, oh, it works the same, and not quite, but that's the argument. Then there's discharges, there's all a manner of things where administrators who do not have a professional license, do not have a professional obligation, will try to push physicians around. And let's face it, if you're employed and you don't have physician representation, you don't have the benefit of a working contract, what are your options? Let's be frank. If you're employed and your employer tells you to do something, what are you going to do? You better have a ton of money already before you tell the guy to go pack it. Your other options are to do it and to just acquiesce. So this is what the number one reason physicians organize, to protect their professional judgment, their integrity, and I think their pride. Thank you.
I don't believe we have Dr. Bussey yet. Rob, do you have any presence of him?
Stepped out, but Patty says that they are resending him the Zoom link.
No, we already did that a long time ago.
So we don't have.
All right, well then, I'm gonna have Patty ask him if he can come back and give his talk after the let's see, after the medical student. Okay, so we have about 5 or 6 minutes before we are scheduled for Professor Markovic. So let's just type for a few minutes, because I think he's going to join us shortly if he hasn't already. He's helping Stuart.
You heard from Bussey at all?
Me? No.
I didn't. We're all just like this. Yeah, I'm asking Patty. So I think we're just gonna start again at 1:10.
He's just finished. No slides.
Wait, what did you say? Well, also they can do like things now too. Really like, there's in case we have. There was something really sitting we were talking about, and just like collaborate as a group. You can just state your concern in the letters and just do it.
So we we're trying to reconnect the Zoom links with Professor Markovic, who will speak next, and then I don't know if Dr. Bussey can stay and or return at 3:25 and give his talk then. That's what we're trying to organize. Bear with us. It's interference with the internet. I think it's the Russians.
SB 642 is the one you're talking about. It's on sales.
Yeah, somebody said that to me before.
That's the downside of technology.
I was gonna say, I just like the combination and like access to like the market side. I was like, I don't know, like it's weird. Like there's this weird disconnect between you know what I mean? Yeah, that would be a problem. I can't like understand it truly. These are always like specialty pharmacies that would patients would have access to the medication, especially like those super frequent, like the infusion treatments or stuff like that.
If worse abscess becomes to worse and there's some major Zoom breakdown, can you go next?
We're missing a couple people, but, well, I think it's just Anna, right? Yeah, she's here. We might have everybody. Wait, no, we're missing Melissa. We're still missing Melissa. Okay. Anna's here. I was like, Anna can come sit over here. I'm not here. Tell her. Yeah. That's the only place that she might have a pretty good season with the that's good. She's so like that. She's not work. She was like, what piano are you doing?
It's a character.
Oh, you sent a Google. I saw that. I didn't fill it out. Yeah, in a way too.
Doesn't even have a name. Yeah, it's from
yeah, it's cold and all that. How did you make bad decisions?
I didn't get it.
Oh, no, I just changed.
Gone? That's what I meant. He's the one that belonged there. She was terrible. Yeah, nice car.
Gotcha. I changed it to a phrase like
Up a B. Does it have over there?
I knew the difference between his mother-in-law and the horse. There's instead of 131.
There was another article, and they said it was survey, but I could not find the survey.
Survival. Yeah.
But do you think I should still say like,
If you want to get it somewhere.
That's not what I was finding out, because I was reading about survey. Yeah.
They need a written like this. I can go coming. Don't you coming or not?
Oh my gosh.
Sorry. Just keeping up everything.
You still run the center, don't you? Yes. Start at the top. Would you like to take this? No. I just.
Are we standing?
Oh, okay. Whenever. Yes, okay. I didn't know if that
I like your green too. Sure. Are we gonna like rotate around the person or should we stand?
Is there enough spots?
I prefer stands.
Do you want to stand at the front then?
The whole time while everyone else speaks.
So I can walk around and
Or else my favorite professor she does it really nicely. She comes stand like you're gonna ask the question. And she's so cute.
put it upside down
somewhere else.
Yeah.
I can't.
Yeah, we need
napkin is a very stingy. We need rice.
I can't see it. Just right upstairs. Not with privacy, but I've done that to my laptop many times. Oh, thank you. Big fan. Really cute.
The basic issue is.
Sorry, you are taking your time. Upside down for a while, but upside down, don't move it, and you need to turn it off. No, wait, what? You need to turn it off. There's two. It's fine. No, turn it off. I'm telling you. Just keep it upside down on like a paper towel, on like a nest of paper towels. Don't use it. Like all the way down, like
That really defines.
no, I would leave it like this. But I would put the paper towels like this, like that. She's saying she puts it like this, like rest on a table on a bed of paper towels, and then have it like sitting. Okay, I'm really not like that's why it's important to keep it off. Because
We have Stuart on. Is that the best we can do? That's what we can do right now, Max.
Okay, how about Mylan? Because he was supposed to be slotted for this slot.
You're working on Mylan.
The question is, if Stuart goes now, I mean, the whole schedule gets moved around, but can Mylan stay on and come back?
I'm working on getting Mylan.
Okay. All right, folks. Well, bear with us another minute. Crazy stuff. Medical students, can you? Oops. That.
Hey,
Stuart, can you just hang tight for a few minutes, please?
Medical students, can you, are you locked into your time slot, or can you talk at a different time?
I mean, we can.
Assuming everybody's here.
We're missing one person
We
still.
won't do it earlier.
Oh.
We may do it later.
Yeah, I think I'm staying all day. What about Melissa? I mean, she's not here yet, so.
All right, well, hang on, we're still trying to get these people.
Oh, right. Till 6, though.
Great question.
That's right.
Blame it on the right.
Switch to Chinese.
You said what happens?
If he does it by phone, he can't get on
My kids are at college now.
He can share his.
I don't know about that.
You said, can I show who slides? I don't know if I have this. Okay. Because it says that he's remote. I can check and see if Patty gave it to me by any chance.
Stuart, can you hear me? Do you have slides?
Yeah, I sent them over to Patty.
Okay, all right, then we'll find them, and if worse comes to worse, and I truly apologize for this, if you give your talk via your phone and just tell us when to go to the next slide, we'll do that.
I can do that.
Oh, you can do that. Oh, that's even better. Okay.
I mean, no, I can't do it, but I'll tell you when the next slide is.
Okay.
I think it's pretty easy, 20 slides.
We're looking at something. Is that you? Legal Foundations for Physician Unionization? We see it.
Yeah.
Are you doing that, or are we doing that?
I think you're doing that.
Oh.
Is it on a default?
I don't know. Is Rob back there?
He's doing it.
Oh.
He's behind the screen.
So, we're jiggling the schedule around. We're very sorry that we can't see Dr. Bussey, but he is going to talk with us. I think we can all hear him, and we have his slides, and so we will let you share your slides with us and go from there. All right, Dr. Bussey.
Okay, so thank you. I apologize for the time snafu and the technology snafu. I guess it goes with the whole, theme of industrialization. What happened to medicine? It used to be right on, simple issues of professionalism. So I'll try to get this done in 20 minutes. The first slide shows up in the upper left a group of white-coated doctors, and on the right side, blue collar. Is that the first slide? You see that?
Yes.
Yep.
You guys see that slide? First slide?
Yes.
Okay, good. Well, that's what we're going to have to do. So the question is, where is the profession going? Are we white coats with blue collars, or where's medical professionalism? The second slide, please. You see the second slide on what is professionalism?
Yep.
Yes?
Yes.
Yes?
Yes. Yes.
Okay, well, good. All right. Well, this is different. Anyway, Abraham Flexner in the 1900s was a medical educator, and he elucidated 7 criteria for professionalism, which through the years, some aspects of medicine have, most of them, some don't. Intellectual activity, obviously, for individuals, by individuals, can be a psychiatrist to a patient, a lawyer to a client, electrician explaining something to
to a homeowner, that's a professional. You could argue it's a trade, but a profession also includes special knowledge and research to an acceptable end of helping people with training techniques, CME, CLEs, all that stuff that we do to keep our profession up to date. And the other three criteria are a little interesting: moral community, which you say medicine has been that way since Hippocrates, ethics of legal ethics, and altruism. Okay, so the next slide, please, which is medical timeline. Do you see that? Yes?
Yep.
Okay, well, the timelines of medical professionalism start way at the left side with craftsmen in before 500 to 1000 BC, Greece and Rome, giving potions and trying to help people with humors and non-scientific ways to help people. So it doesn't really, meet all the criteria of professionalism. They didn't have any training, they didn't have any organization. But when Hippocrates came in 460 BC, things changed. Hippocrates and the Hippocratic Oath described the moral purpose. One of his quotes is, "Sometimes you give your service for nothing." And so we take the Hippocratic Oath as doctors to help people and become altruistic and moral, not just professional and share knowledge. In the Dark Ages, that didn't exist, so there were really nobody helping anyone in the world of medicine. That's why it's dark. In the Middle Ages, though, the religious monks were also herbalists, so they practiced a profession where they had knowledge of herbs and they were altruistic. There was no organization, of course, but they were moral. In the Renaissance, you had sort of a bifurcation where the hospitals would take care of the poor. There was organized into a hospital, but rich people could get contracts. University doctors would take care of them. It wasn't until the 17 and 1800s the American Medical Association, 1847, published its Code of Ethics, and then it was truly a profession. Continued on into the 1900s, where hospitals, administrators, doctors told the administrators what they want, and it was truly a profession where it was self-regulating, according to Flexner's criteria. It was the golden age. I'm so old, I don't want to tell you how old I am, but I was actually, enjoyed that until the 70s, when things started changing with managed care and all the technology and all the third-party payers that pressured doctors to, limit formularies of medicines and limit the amount of time people were in the hospitals, and it's basically telling doctors what their protocols were. Now we have mostly employed physicians in the last several years who really remind us of industrialization. Can you do the next slide, please? Next slide shows the agriculture and first industrial revolution. I do that because I want to infuse what has happened in medicine and professionalism, and that is industry. And what is industry? It's just mass production and layers of bureaucracy, people telling other people how to finish the product and manufacture it. In this case, medicine. But back in the 1760s, people would leave their farms and go to the factories in the cities and mass produce cotton, textiles, food, and that was really the Industrial Revolution. People were coming over from Europe. Labor was cheap. The cotton mills, cotton gins, and the thresher machines were there to dictate how long you were in the factory, and child labor was done for 12 hours. There's a kid up there. And finally, there's so much resistance and exhaustion and abuse that trade unions came upon Philadelphia and New York in the 1790s. Next slide, please. And that slide shows the second industrial revolution, which was in the late 1800s. And that was sort of the perfection of middle management. Frederick Taylor, as you see on the right, was a blue-blooded Philadelphian. He went to Bethlehem Steel one summer and watched all the workers on the floor create products, and he thought to himself, well, I don't have to get my hands dirty, but I can sort of dissect and describe what the task is, building a car or making iron into steel. get paid for it. And he detailed the instructions and then, you know, produced protocols for the workers. That's the middle manager. And that changed America in the late 1800s. He went on to work for the Ford Motor Company as the middle manager. So the next slide, please. The title of this paper was Legal Foundations of Physician Unionization. So the first, this is about labor. So the AFL, you might know, the American Federation of Labor was craftsmen in the beginning. In the late 1800s, your plumbers, carpenters, musicians, shoemakers were in a federation of 100 craft unions, and that was what labor was in the United States. However, as the Industrial Revolution in the early 1900s produced cars and steel, there was a competing organization called the Congress or Committee of Industrial Organization that said that industry was labor, not craftsmen were labor. So they had sort of disagreements until 1955. After the Taft-Hartley Act, which was anti-labor, they merged into the AFL-CIO. The Sherman Antitrust Act was started by John Sherman of Ohio, and this was during the age of 1890 when people were, you know, the wages in America were great with all the assembly lines. People would come over from Europe, and Rockefeller would do mergers, acquisitions, and monopolies. So the United States did not like that. Department of Justice, or FTC it was back then, produced Section 1 of the Sherman Antitrust Act, which is to prohibit anti-competitive practice. And there was no price fixing. That was a big deal. No price fixing. And no exclusive, they couldn't exclude competition or limit output like Saudi Arabia does with the oil right now. You couldn't manipulate how much you put out. That would be an anti-competitive practice in a cartel. Section 2 prohibited monopolies and mergers. So that's lasted until the present time. We use the Sherman Antitrust Act to go after monopolies. We have Facebook and Amazon being threatened every few years with monopolistic practice. The Clayton Act of 1914, the major part of this act is that they stated that labor was not part of the Sherman Act. Labor was not an economic commodity, so it could merge, it could acquire, and it wasn't constrained by the Sherman Act. It wasn't a monopoly. It wasn't anti-competitive. That was a big deal because labor needed to increase, and so the United States government favored labor. It upheld peaceful strikes, picketing, boycotting, and it was a big deal for labor unions. In 1912, we had the Department of Labor sort of broker all these abuses of the industry. If you ever read the Jungle by Upton Sinclair, you know the horrible conditions, unsafe conditions in the meatpacking industry and the sweatshops. Department of Labor lasted to this day, of course, brokering labor disputes, but what really is the most important of this page is the Wagner Labor Relations Act of 1935. It was created during the Depression when there were violent strikes between employers and employees and the police, and it was done to protect employee rights and to encourage collective bargaining and to stop bad management practice such as spying on employees, questioning them, blacklisting them, and firing them. It was a big deal. There are two parts that you should know. I don't know if you're all law students or med students here, but Section 7, of course, is already is about protected activities. That means you have the right to form unions, join unions, organize unions, strike, picket, and slow down work. Section 8 talks about the unfair labor practices of the employer, which is anything that interferes with what I just said, any protected activity. You cannot interfere with organizing in an unfair way or a picket in an unfair way. So it's a big deal. It prohibited discrimination and refusal to bargain in good faith. And that refusal to bargain in good faith are many of the reasons why we have strikes in the United States. They used Section 8 of the Wagner Act to justify this. In 1947, the Taft-Hartley Act was a reaction. The war had ended, the Depression had ended. People were, industry was going full blast. Employers were rebelling. The conservative part of the government went against unions, so they, this sort of retrenchment. They narrowed the definition of ULPs. They prohibited union activity in certain picketing instances, and they did not allow closed or closed shop. Closed shop is when members are, after they do a collective bargaining agreement, are forced to join the union as a condition of employment. You must be in the union to enjoy the agreement that you just bargained for. So that's called the Union Security Agreement. It still exists in certain instances. Agency shop, but they allowed an agency shop where you didn't have to join the union, but you had to pay a fair share. You didn't have to pay full dues, but you had to pay your fair share in an agency shop. So the other part of it, down at the bottom of the page, is the right to work law that started in Texas in 1940. Now 27 of the 50 states state that you don't have to join a union at all. If you are in a union environment, you don't have to join the union. You don't have to pay an agency fee. You don't have to do anything. You can enjoy the contract and you don't have to pay a dime. And that's in 27 states, that is the law. And we had a recent public union law called the Janus Act. I didn't put it in, but that's 3 years old. And that means any government unions, you don't have to join them either. Now, our union has many government jobs, and we have free riders. And by free riders, I mean people who enjoy the contract without paying any money at all. So that's the sort of the milestones they have. And the next page, please. The next page is the industrialization of healthcare. And of course, with all the demand in the late 1900s and since the ACA, the increasing aged population, the superior, software that can transmit medical records from one doctor to another, you have a lot of people going to have medical care, and it's become an industry where it's very difficult to run a business with all the demands of the patient. So now you have large medical corporations, Humana, Sutter, Kaiser, are managing this care and employing the doctors. When you have the Taylorism, which I say was middle management, and you have all the student debt. I don't know if you have med students there, but the average debt's about $300,000 when you graduate medical school. You're just happy to take the job. People don't know what they're signing. And they sign contracts, and our union has been very well aware of these contracts, sometimes contract adhesion. We have third-party rules from insurers, government regulations. We have competing professions like nurse practitioners and nurse physician's assistant that weaken the professional identity. Can you turn to the next page, please? Okay, next page is a fun slide. It's really very good because from 1970 to 2009, you had a 3,300% increase of that top graph that you see shows an increase of administrators of 3,300%, while the bottom darker line is how many providers were increased, which is 150%. So there's a wild number of administrators jumping on the healthcare wagon. Turn to the next slide, please. And there's the healthcare wagon, $3.3 trillion, 19% of our gross national product in healthcare. And much of that is wasted administrative drug fees, pharmaceutical overcharges, and the horses, as you might guess, of doctors and the providers who pull this wagon and are burned out. So what am I saying all this for? The next page means as the doctors become employed, they have many masters. They have the patients they must listen to, hospitals and insurers, groups and attorneys. And number one is their employer who pays their check. They must listen to the protocol if they want to keep their job. And they have like a triangle, right? It's not a triangle, it's a rectangle there. But the employer, patient listens to the employer for what he's entitled to, or he or she is entitled to, tries to talk to the provider has to talk to the employer. It's not the doctor-patient relationship anymore. It is becoming an industry. So, next slide, please. Since 1900, we had Germany and the United Kingdom form unions for physicians. Our union is now 50 years old next month, the Union of American Physicians and Dentists in California. And this occurred when the third-party payers and managed care came in the 60s. There's only 2 or 3 doctor unions left now, Doctors Council and ourselves. Now, why is it special? Because the AMA, the CMA, all the other groups cannot collectively bargain under the Wagner and National Labor Relations Act. They're not legally able. The AMA tried to do that in 2000. They did an experiment, but they did not know how to do it. This is a very tricky way. You have to follow the rules of collective bargaining, and you have to, you have to be skilled at it. So that's what we do for our patient, our members who are doctors. And of course, like nurses and other successful healthcare unions get more money by being in unions. Many studies show 3 to 5% more in salaries and benefits. Next slide, please. So it's easy to say this sounds great, but herding cats is easier than organizing doctors. I found this slide was amusing, but it's true. I've been president for 15 years, and it's easy to get the doctor on the line complaining, but there's a lot of fear factor in there. If they join the union, they're going to get retaliated on. They are protected from retaliation, but it's difficult. Can you do the next slide, please? The next slide shows who's eligible, okay? If you're an intern or resident on the upper left, you can go straight to the union because you are a worker, an employee. The 1999 Boston City Hospital case adjudicated that interns and residents were not students, they were employees and should be unionized. If you're a salaried employee, as long as you're not a manager, you can go and become a union person. If you are a manager or supervisor, you're not eligible under the National Labor Relations Act. So that's how it. The next slide, please. Okay, so I know Dr. Batanti, I'm sorry about this, but I didn't hear what he said, but I assume that he went over collective bargaining. Just as a real quickie, on the left side, you want to go back and forth with your opening proposals and get information and come to a tentative and final agreement. On the right side, though, Dr. Batanti hopefully talked about the employer saying no, getting the last best and final offer, and then impassing and imposing a contract. We don't want that. We don't usually get to that point, but if it happens, you can go to mediation. And sometimes it works, sometimes it doesn't. Next slide, please. And this slide shows all the contract articles that we usually go over in our physician contracts. We have stewards and recognitions, hours of work, salary, safety issues. I put in bold those 5 things. Professional judgment, that we guarantee that we don't have to be forced to do any sort of treatment that the employer wants if it impacts or endangers our license. And that's a very big issue. We've used professional judgment over the years to say no to employer practices that we don't agree with as professionals. Physicians' rights refer to all the other clauses of working hours and safety issues, contracting out, telehealth. Employer rights is the rights, stated in the contract to operationally do what they want as an operator, and that's a big statement. We sometimes come to issue with what is the correct way to run a business, but they have the right to run their business as long as it's safe and good for the patient. Next page, please. We have just cause and grievances up there. Grievances are contract violations, and the union has a duty to fairly represent a member who feels like somebody has violated their contract rights, told them that they can't have a vacation, or they have to work overtime, or they have to work certain places beyond their scope, and they want them to do things they're not trained to do. So we have the duty to fairly represent them. Step 1 grievance, step 2, step 3. It's usually a time limit of 30 days per step. If If this grievance is denied, we can arbitrate it if we think it's a winner. We will arbitrate or has any decent chance of victory. We will go for it, pay for it. But if it is a bad case, we don't have any chance. We only arbitration, and the member can pay for it. He or she can pay for it. Just cause is when you are disciplined or fired, and the just cause is a very important point of the union. Capricious firing, we don't need it, so you need a notice of a reasonable rule. It needs to be fairly investigated with proof. You've got to be treated equally with other people who have been accused of this, and the crime must fit the punishment. If you were, we had people, fired for telling off-color jokes. Sometimes it's, appropriate, often it isn't. So we have progressive discipline for those cases. If you've never had a disciplinary problem, we have progressive discipline in our contracts. Last thing I want to mention here is Weingart rights. In the 70s, a woman worked at Weingart department store in New Jersey. She's a union member, brought into an office for some discrepancies on her invoice, and admitted something without a representative there and incriminated herself, the Fifth Amendment. So it went to the Supreme Court, and she was found to be right, that she needed a rep to witness this conversation. So all our union members have the right to have a representative in the room with them when they are grilled and they have a reasonable perception of discipline. If someone says, come in, Dr. Bussey, I want to talk to you for something, it's no big deal. If you think it's a big deal, then you get a rep. You need somebody to witness it. So those are some of the rights. The next slide, please. I told you about the unfair labor practices. Usually for a contract, it's failure to negotiate in good faith. In that case, if you're out of contract, you have no strike, if there's no strike clause and your contract is expired, you have the right to picket, you have the right to strike. Practically speaking, you have to give the employer or the hospital notice at least 10 days so they can get other people to cover for you, other out-of-state doctors and nurses. And that's fair, and we don't restrict emergency services. We don't harm the public. Next slide, please. And we've had 3 strikes in 50 years. The first strike was in 1975 when the malpractice premiums went sky high. Jerry Brown did that. Lawyers lobby tried to do it, but the anesthesiologists, 2,000 doctors in California, picketed and slowed their paperwork down, and in 1 month, Jerry Brown withdrew a micro. Next slide, please, is the doctor strike we had in 2015, University of California. 10 student health centers did not negotiate in good faith over a year and a half, and we picketed on that, and we had a 1-day and a 4-day strike. You see this lady here, this is one of our stewards, but the old version in the 1800s of strikers having violence. This is the opposite. Ironical. She's helping someone, not breaking their kneecap. She's helping someone with a broken knee, so I thought that was kind of ironical. So we help people. Next page, see that strike in UCLA. We want it to end, but when the employer is not fairly negotiated, this is what we resort to. This is 3 strikes in 50 years. Last slide, please. Last slide. Also, we help other people in labor. This is me up in the nursing. Yours truly up in Seattle helping the nurses picketing. Sorry, this is it. So I'm done with the presentation. I apologize for this technological snafu, but I hope everyone heard this.
Yes.
But that's the legal foundation.
Yes, thank you very much. Sorry. Yes, thank you very much. We can have a applause. Yeah, we apologize for the snafu as well, but you came across fine and your slides were great. We have a few minutes for questions, comments. Anybody remote? I mean, the sort of obvious question is there, how do you respond to the, concern that, unions are associated with, workers as opposed to professionals? does it? Is there a problem with it? In, sort of undercutting the professional nature of the practice of medicine by physicians?
Yeah, well, you're right. That's the question. When people call up, they're tearing their hair out because they've been told what to do. They're exhausted with work. And that's why I put these slides in the beginning of the Industrial Revolution, that little kid who had worked 10 hours a day, child labor. People come in and are abused and told one thing on their contract, that they're going to work 8 hours here, but then they're surprised later, and a bait and switch occurs when they are told, no, you're going to do more than that. You're going to expand your scope of practice and see psychiatric patients. Well, I'm an internal medicine. So people get pushed, and they feel like workers. So the people who call us, they're well-meaning people. I mean, I've been a doctor 35 years, I'm still in private practice, but you don't have self-regulation anymore. You're told to do by someone who hasn't been in a room with a patient, and you do feel constructively, I don't know the legal word, like a worker. So, I mean, I always thought that we had a white coat but a blue collar. I always wanted to sort of have that as our new logo. I think you can be both. You can be a profession, you can be a plumber, which is kind of a profession, and you help people and you do that. You have a blue collar. So I don't see much difference anymore. I think you're being used for profit by organizations that care about the bottom line, and you're a pawn. And certain people recognize it, and they call me up and try to organize, and certain people don't. Eventually, I just don't know where the homeostasis will be in 10 or 20 years, whether it'll be fair for doctors or they will be working themselves to death. Don't know that, but I do feel myself that we are working for somebody else.
Dr. Curris.
Hi, Stu. Mike Curris here. Thanks for that great talk. Just a couple of quick questions for you. What is your experience in organizing outside of the municipal and state workers, like large integrated health systems or academic medical centers? So what's been the experience in California and elsewhere? And where else have you organized?
Yeah, Mike. So we're just, as you know, we're going up to Washington about 6 years ago. And we have, I'll just tell you, we're in Multicare, which is a conglomerate up there. They, quote, nonprofit, but they are, they're acting like a cartel. They dominating the market. They have urgent cares all over the place, and we have urgent care doctors. Our experience is they're more afraid to do it than government people are. As you know, there's 850,000 doctors. There's only 2 or 3% are unionized, most of them government, but we're getting more and more phone calls from private doctors who feel like there's nowhere else to turn. We're going up to Spokane next week. We're in New Mexico now. And it's the same principle. You just join with your colleagues and you just organize a bargaining unit. Now, private doctors, you're a private doctor. They don't have any antitrust protection. They probably never will. And, they're different animals. They're different animals. They are not used to working together, and they're not allowed to collectively bargain. So I say that the intermediary is the conglomerate, the physicians who work for these, Humana's and Aurora Health Systems out there in the Midwest. I know what's in Cleveland. What's in Cleveland? What's the biggest one in Cleveland? Is Kaiser in Cleveland?
No.
I think they are. Anyway, so they're the ones that we're going after now, and it's a little bit harder because they're more afraid. There's less protection for them. And the employer is more emboldened. They don't have due process in the back of their head. They're just, they're wheelers and dealers, and they're not afraid of the law. That's the other thing. They'll fire somebody and they'll accept a lawsuit settlement just to teach people a lesson. So they're a lot more vicious than the governments are. I don't know if that answered your question.
It did. What would you tell some of the med students here who are gathered in terms of when they finally hit the street and have to get a job and pay those loans?
I'm going to address the tuition issue.
I'd say learn contract law backwards and forwards. Is it med students or law students that I'm addressing?
Med students.
Oh, it is med students. Oh, okay, I thought it was. Okay, so all you med students, you know, I'm from Loyola. I went to Loyola. I gave a talk at Loyola a little while ago. Law schools, I don't know, or med schools are kind of part of the problem. They're very innocent. You know, they teach you the Krebs cycle and all this stuff that I never used. But they also give you, $300,000 in debt, and they make you grab the first job you can get. Get some contract law under your belt so you can negotiate your contract, or get your friends, or get a lawyer or Mike Courts or somebody that knows contracts, and show that person what this company is offering you, and negotiate, because they need you more than you need them. They need you more than you need them. And you should counter what you get. You should negotiate that contract. You should learn contract law, read a book on it, take a course on it, or get a friend who knows the law, and fight for your contract. Because if you sign something, they're going to take advantage of you. Sorry to be that way, but or you may think I'm a little too cynical, but many people in Kaiser are just so exhausted with these emails they have to do every night. They work till 8 o'clock doing emails at night. After 10 hours of work, they go home and talk to their patients. They don't have to do that because they don't have to agree to it on the clause.
Thank you, Stuart. So I have applications to law school for any of the medical students who would like to learn contract law. Let's see. Sorry? Yeah. Fred, you have a question or comment?
Actually, two questions to either one of the two speakers, and I thank them both for educating me. The first is a question about, on the basis of one of the hallmarks of the 20th century medicine has been the rise of specialties and specialty boards and subspecialties. And your opinions on whether within this environment there's been any impact on a phrase that you've all taught me, and that is a substantial mutuality of interest. In other words, has the rise of subspecialty medicine impacted on a shared sense of community and mutual interest? And the second question is bargaining for professional judgment issues different from bargaining for other types of things?
No, let me answer the second question. No, it's no different. We have professional judgment clauses in every contract we do, and they're expecting it now. We have in the prison system in California a drug program, and you know what Suboxone is, right? P-Procreate, that you give to addicts.
Yes.
To detoxify them. Well, this prison system, I'll just tell you, in California, they made it ginormous. John said that our primary care doctors should do. There's 100,000 inmates. They said, let's go for it. Let's detoxify these prisoners. These people are overwhelmed, and they felt that it was not in their professional judgment and against their license to just write prescriptions in the type of program that the prison system created, which was harebrained, stupid, and dangerous, without any cognitive backup or anything. You said, write the prescriptions they needed. So we've had a year and a half fighting over a professional judgment issue that is a big issue, and it goes for anything that the employer could theoretically tell you to do, or kick a person out from normal delivery, for a drive-by delivery or C-section or something that doesn't make any sense to you. It's really important to do that. That's like one of the three things that's most important. Preserve your autonomy, your thoughtfulness, your voice, and instead of being a pawn, And so it's easy to do that in the contract, and then the fighting begins. But you have to have that. I don't know what the first. Bob, you wanted the first question, which is subspecialties?
Yeah, I think that the question was, can we represent specialists, subspecialists, and general practitioners all in one contract? And the answer is yes, we do it all the time, recognizing that each one of those groups maybe has a higher market value, and we'll negotiate separately for different classifications of physicians. So yes, we can do that and do that.
We have a question from Professor Silvers. Professor, just a second. Professor Markovic, if you can hear us, yes, nod. Okay. Are you okay if we come to you in just a minute or so? Are you still okay?
Take your time.
Oh, thank you so much. Okay, Professor Silvers.
A quick question, you might have touched on it before, but non-competes. Do you guys are even negotiating on non-competes now? Because it seems to me that's one of the major issues in terms of the economics of the business that damages the ability of physicians to have any autonomy.
Up in Seattle, when our indigo doctors get burned out and they want to leave indigo urgent care, we have 130 of them. They had a 30-mile non-compete, and so we knocked it down to 5. In fact, they said you can't, and the satellite clinic is 30 to 50 miles outside of the main hub of Seattle. And so we took, we mitigated it by saying 5 miles from your clinic itself. But the way it was previously written, they had to almost go to Idaho to do it. So yes, we negotiate non-competes, sort of mitigated. A lot of them you can fight, and you're illegal, or you'll win the fight if you want to do it. But we sort of mitigated in the contract, not destroy it, but make it more reasonable instead of going, miles away from the furthest satellite clinic. You can just put up your own shop or get another job from your local clinic. So that's what we've done so far, as an example. What do you think? Do you think they're illegal, or do you think individual doctors should fight it? I don't know whether it is in Ohio, California. You put up a fight, you usually win it.
Not a legal expert, but it seems like restraint of trade to me, that there should be some restrictions.
Oh, yeah. And the 13th Amendment, right to travel and do work. You got to put some money up, though, and you got to find an organization that wants to make an example of you. They don't want you escaping and all your friends say, hey, he opened up a practice, let me do it. So it's a big deal for the employer to win that case.
Other questions or comments? Yes, can we have a microphone over to one of our... Thank you.
Hello, thank you for the presentation. I learned a lot. So this question might come off as a little naive, but forgive me because I'm a medical student, not a law student, so I don't really understand all the, technicalities of things. But I was wondering about, I guess, your opinion on the collective power of physicians to unionize and ask for things beyond what's in their professional contracts, like advocating for patients in that way, or like maybe even, bargaining against like insurance companies and how they dictate prices for medications and treatments and stuff like that, if that is something that you think is possible or would be useful. Just what's your opinion on that?
I think with vaccination issues here, with all the things about the abortion issues and micro, like I told you, we have strike in 1975, we reversed it. And politics, here's what I have to say to you. This is a political profession. 19% of the money in this country goes to medicine and providers. If that's not the definition of politics, I don't know what is. A lot of people are employed in healthcare, and doctors are the tip of the spear. They should have a voice in any issue, including insurance reform, smoking, gun control, vaccinations, abortion. And we don't have a big enough voice because other people grab the microphone who don't know what they're talking about and dominate it in legislation. We have several of our doctors in the legislatures in California, and I suggest if you want change, run for an office. Because as a doctor, you'd be loved by people. This place has too many lawyers in legislatures. And, the doctors have been successful out here in California, and they could be in, I don't know how many, think there's 30 doctors in the United States Congress total, and usually pretty well received. So I guess to answer your question, it's collective power through politics, through initiatives, petitions, anything you go. Like there's power in collective action. Yes, and even in med schools. So I mean, let me ask you this: is there something in the med school that you guys think is just totally wrong? Or would you have to answer?
Can we turn off the recording, please?
Huh?
I said, can we turn off the recording? That was a joke, though.
Yeah, I know, that's heresy what I'm saying, but, med school is unwittingly part of this problem when they indebt people $300,000. It sort of sets a cascade effect, like I said, the industrial thing, that people who work hard, exhausted, burned out, and broke.
Stay tuned.
Stay
tuned. No, just stay tuned, because our students will shortly be addressing precisely that issue. Yeah. I think we need to move on. Professor Markovic, are you still with us? You were. Can we show him again, please?
I am here.
Great. So sorry for the technical problem, but so glad that you could stay with us, stay and present to us. So please proceed. Is there anything we need to do at our end to facilitate your talk?
No, not at all. Just I want to apologize again for my untimely arrival. It's been that kind of week. I unfortunately was planning to attend in person to see you all, but I received the bad news that after 2 years I had caught COVID, and it hasn't been as mild as I hoped. I'm feeling fine, but please bear with me if I have the occasional coughing fit here while I'm safe at home. Just a little bit of background about me. My name is Milan Markovic. I'm a professor of law at Texas A&M University School of Law, which is actually located in Fort Worth, Texas, not in College Station, Texas, which is great for me because I'm more used to big cities. I'm originally from Toronto, although I was educated entirely in the United States. I also am the convener of the Law and Social Science program at Texas A&M University. So my topic today is going to be beyond morals of the marketplace, lawyers as fiduciaries. So I'm a legal ethics scholar. I will not pretend to be an expert on medical ethics, which are obviously very different than legal ethics. But I hope I can offer some lessons that we've learned as lawyers and what it means to be clients' fiduciaries. And hopefully this experience will be helpful to the medical profession, recognizing, of course, that there are specific reasons that that profession has evolved the way that it has. So if you'll indulge me, I'll begin with a personal anecdote to illustrate, I think, the importance of this debate about fiduciary duties. So like many people, I assume, I put off dental care during the pandemic for fear of getting COVID. So in January, when it seemed safe to kind of embark, I found a new dentist and I scheduled a basic checkup and cleaning. By the way, notice I'm focusing on dentists and not doctors. I figured it's a safer space. So I ended up at the dentist for nearly 2 hours. And at my first visit, only 20 minutes that time was spent on this actual teeth cleaning. The dentist told me various things. I needed to have my old fillings replaced, I think a number of them. He claimed I had periodontal disease that we should treat with a series of deep cleanings which involved lasers. The dentist also told me that I should meet with his sleep apnea specialist, although I have no problem sleeping and don't snore. So I was a little bit perplexed by all this, but nevertheless I went ahead with the deep cleaning. I care about my gums. And this treatment consisted of 2 separate appointments with the dental hygienist. I was told that my insurance didn't cover the procedure as detailed in my treatment plan. So I ended up with a bill of $1,600, roughly $800 per hour of hygienist time. The cost would have been even higher, but I declined to have the last quadrant done because I was a little bit mystified by the costs here. So I didn't think about these trips to the dentist and hygienist again until I received a statement from my insurer, which is required in Texas, indicated that I had an agreement with the provider to charge $150 for the basic cleaning. In other words, that's all they could charge me was $150 for the basic deep cleaning. So I'm a lawyer, but I'm not that bad at math. 1,800 is a lot larger number than $150. So I confronted the dentist with this information. Why am I being charged? Why was I charged $1,800? And we spent the next few weeks going back and forth over what had been disclosed to me and the reasonableness of the charge. My basic position was simple. I am not a dentist. I was relying on the dentist to present to me various treatment options, including options that would be covered by my insurance. Their basic view was, you agreed to the treatment plan. You're an adult. Heck, you're a lawyer. It's not our fault if the insurance doesn't cover the deep cleaning that you agreed to. Looking back on it now, and connecting this episode with that theme of the conference, I think what our dispute was really about was competing conceptions about the relationship between dentist and patient. And if we want to extrapolate, professionals generally and their clients and patients. My view was that the dentist should prioritize my autonomy and put my interests first. And part of that would be providing me with all the information I needed to make an informed decision. His financial interests really should have played little role. His conception was much more in line with the view of for-profit businesses generally. We operate in a free market. Clients / consumers / patients can either take it or leave it. So I'm not saying that any route is necessarily right or wrong, but I will say this. Dental services, medical services, legal services, they can't be evaluated the way you can evaluate the food at a restaurant, for example, or the service at a restaurant. The ordinary patient doesn't know what services he needs or doesn't need, and if they have been provided competently after the fact. In economic terms, we often call these types of services credence goods. And because legal services are so hard to evaluate, the legal profession has historically treated lawyers as fiduciaries to check the power that the profession has over their clients. But what does it mean for a lawyer to be a fiduciary? Well, I have to bring you back to a case coming out of New York in 1928. It was decided by Benjamin Cardozo, who would eventually sit on the U.S. Supreme Court. The decision had nothing to do with the regulation of lawyers. In fact, it involved a case between business partners. One gentleman, his name was Salmon, received a 20-year lease on a property in Midtown Manhattan. To improve the property, he turned to another gentleman, Meinhardt, for funds. Salmon managed the property day to day. Meinhardt financed the project for 40% and eventually 50% of the profits. Prior to the conclusion of the lease, Salmon received the opportunity to redevelop the site as part of a much larger project. He did not inform Meinhardt, even though they had flourished in their venture together. Cardozo ultimately held that Meinhardt was entitled to 50% of Salmon's interest in the new venture. So Salmon versus Meinhardt is one of the most famous cases in American jurisprudence. Cardozo's only comment on the case is something he wrote to another justice, Fields Frankfurter. Meinhardt versus Simon is one of the cases in which some of my colleagues think that my poetry is better than my law. I think its law is better than its poetry. So the key question in that case, and I think the key question when it comes to what does it mean to be a fiduciary, is why did Salmon have to share the opportunity with Meinhardt? Why did he owe him anything at all? According to Cardozo, Salmon had put himself in a position in which thought of self was to be renounced, however hard the abnegation. Many forms of conduct permissible in a workaday world for those acting at arm's length are forbidden in those bound by fiduciary ties. A trustee is held to something stricter than the morals of a marketplace. Not honesty alone, but the punctilio of an honor the most sensitive is the standard of behavior. As to this, there is developed a tradition that is unbending and inveterate. So, setting aside the very beautiful prose there from Cardozo, The legal profession is largely internalized as a formal matter this ethos of finest loyalty, honor the most sensitive, as opposed to the arm's length morals of the marketplace. And the reason for that is largely historical. It had no choice. Unlike the medical profession, the American legal profession has not been held in high regard for most of its history. In fact, most would say it's still not held in high regard. Nevertheless, there's been advancements. Pre-revolution, the American legal profession was completely disorganized. Anyone could claim to be a lawyer, and there was no formal means of becoming one. Professional discipline was ad hoc and controlled by individual judges. Exploitation and fraud were common. People were reluctant to even use lawyers. Conditions improved after the revolution, but most lawyers still had a little form of legal education. To become a lawyer, one only had to apprentice for a member of the profession. Many lawyers didn't attend high school, let alone college or some kind of formal legal program. So by its own admission, the legal profession was envious of the medical profession and sought to enhance its prestige in various ways. So we basically copied what doctors were doing in many ways. We introduced licensing exams. We required attendance in law schools, just like obviously attendance was required in medical schools. We also drove out many of the quote-unquote less reputable law schools. Last but not least, the profession began to develop ethical codes that sought to counteract the perception of lawyers as self-interested swindlers. Fast forward, and one can now become a lawyer without completing 7 years of higher education and passing a bar exam as well as a separate ethics exam. And the concept of lawyers as fiduciary endures and is found in our ethics codes. So I'll just spend the rest of my time setting out some ways that the ethics codes recognize lawyers as fiduciaries. First, think about fees. Lawyers can only charge reasonable fees. So it doesn't matter that a client is happy to pay. What this means in practice is that a client could be very happy to pay a very, very high rate, but the lawyer could still be disciplined for an unreasonable fee. If, for example, that fee is out of bounds compared to what other lawyers are charging in the jurisdiction. There have been cases where clients have obtained fantastic outcomes because of almost unprecedented work by their attorneys. This happened in the tobacco litigation, for example. And where attorneys were still held to have charged unreasonable fees because the fees were viewed as just so large that they could not possibly be reasonable. Conflicts of interest are also highly regulated by the profession because they're viewed as completely antithetical to the notion of lawyer as fiduciary. So lawyers can't take on representations that are adverse to their clients, even if they have nothing to do with the business that they provide to their clients. So think about lawyer Joe. If he represents Sally in negotiating an employment agreement for her, neither he nor anyone in his firm can take any representation against her, even if the representation involves something like a family matter that has nothing to do with the employment agreement. So what this means is lawyers are often forced to decline business that they would probably prefer to take, but they can't because of this notion that we have this loyalty to our clients, and this duty of loyalty persists regardless of our financial interests. Even in terms of entering into a business deal with a client, a lawyer cannot enter into a business deal with a client unless essentially that business deal is approved by another attorney, another separate attorney. And the terms have to be quote unquote objectively fair. So what we tell our students is never invest in your client's business, never lend your clients money. It's just simply not worth the risk and hassle. It's almost as though we expect lawyers to pretend that they're not business people in many of their interactions with their clients. So this persistence of this fiduciary duty ethos, which admittedly is often breached, but it has been useful in forestalling some of the changes that we've seen in other professions. So for example, the American legal profession has thus far resisted the corporate delivery of legal services. Non-lawyers cannot own or operate law firms with a few narrow exceptions in a few states. Arizona, Utah, thus far the main ones. The fear has been that non-lawyers do not understand the profession's ethics and the duties that they owe to their clients and would encroach on our independence and relationships with our clients. So many in my field, and I would say I'm very much a minority in this, many in my field kind of dismiss these concerns as rooted in economic self-protectionism, and there's probably an element of that. But I also think that there's inherent tension between maximizing profits, as corporations are legally bound to do, and I teach corporations as well as legal ethics. And there's a tension between this corporate profit maximization and safeguarding clients' interests, and indeed, putting the client's interests ahead of our own financial interests. So think about a lucrative case, not frivolous by any means, not a complete loser, but a likely loser. A lawyer who's working for, let's say, a firm controlled by a private equity fund, is he going to drop that case, advise the client to drop that likely loser, even though it's lucrative for the firm, knowing that the private equity firm is looking for a certain kind of return? I'd like to think in our current state of affairs, the lawyer has a great deal of autonomy to do so. So going forward, I think we're likely to see a lot of the changes in the legal profession that you've already seen in the medical profession. But regardless of the level of changes that occur, regardless of the involvement of non-medical professionals and non-legal professionals in our various markets, I think we should always seek to operate beyond the morals of the marketplace, to bring us back to Justice Cardozo's words. Because the services we provide, legal services, medical services, were never intended to be bargained for and traded in the traditional free market, nor can they really be valued in the traditional free market or evaluated in the traditional free market. And the role of regulators, in my view, should be to ensure that professionals retain enough autonomy to be able to put their clients' and patients' needs first. And so they should ensure that that autonomy is protected on a going forward basis. So thank you so much. I hope I've offered some interesting lessons from the legal profession and some explanation as to why it evolved the way it has. And I look forward to any questions or comments you may have. Thank you.
Thank you very much. Questions or comments? Okay. Do you have one? Wait, we got to get you the mic.
Where do you think it would be more pure for a physician to be a fiduciary, as an employed physician or one in private practice?
So, employed, could you describe what you mean by employed physician?
Work for a hospital system.
Okay, oh, that's what I thought. Okay, so I'm not going to get to the differences of the kinds of hospital systems and whatnot, not-for-profit, what have you, but I would actually probably say the private practice model in many respects. Again, assuming it's particularly if there aren't any stakeholders beyond those who are immediately servicing patients, I think it is easier in those kind of smaller environments to fulfill fiduciary duties. I would also say that in larger systems, fiduciary duties have largely been supplanted by rules and regulations, which are not necessarily the same thing, right? I think sometimes we have replaced broad-based duties and notions with very specific and targeted regulations. And while they're undoubtedly well-intentioned, because you want to address a wide variety of scenarios and perhaps ensure that, or try to ensure that folks are not using their discretion in a negative manner, we're also, I think, undermining the core of the fiduciary duty standard, right? Which is a standard for a reason. It's supposed to be flexible. It's supposed to be guided by the patient or client's needs. So I think the private practitioner probably has a little bit more room, particularly if he's not part of a larger system.
Let me make one comment, though, just to make it a clarification. Lots of lawyers are employed by companies, but their client is their employer. It's not like they have a separate client, the equivalent of the patient, as in a conflict with that employer. So that kind of professional employment is okay. It's because it's not conflicted.
So yes, so I study the legal market. The vast majority of lawyers are private practitioners, they service private clients. But something like, I would say, 15 to 20% of attorneys work at what we call in-house. They work in-house for corporations, and exactly as noted, they service the one corporate client. Their duties are to the corporate client, and that's where their fiduciary duties lie. And that's important because sometimes lawyers can get confused between their duties to the corporate client versus their duties to particular individuals within the organization.
I just wanted to say, I'm pretty sure you look darn healthy, and I hope you recover real quick. And I don't think anyone could think you're sick. Last point is, I'm a surgeon, so I'm always wondering, as a fiduciary, of course, I do better financially if I do surgery on somebody, but the employed physician is going to be paid whether or not he or she does surgery. So I always wonder where the concept of fiduciary comes in, and to what extent the self-interest of the physician doing a procedure versus not doing a procedure. We always try and do the right thing for each patient, but sometimes the perception can be different than the reality.
No, that's an excellent point. And here's what I try to tell my students about this. And it's the same thing regardless of practice setting. The question is just, and obviously practice settings just vary greatly. I'm sure that there are some hospital systems that are far more deferential to physicians than others. Just like there are some firms that are far more deferential to individual attorneys than others. I think where the fiduciary duty really comes into me is this. It's a useful check against motivated reasoning, right? So it's one thing to say, oh, I always want to do the best for my patients, right? Just like lawyers will always say, I always want to provide zealous advocacy for my clients. But I think it's helpful to take a step back and say, okay, but am I potentially engaging in motivated reasoning here, right? And I'm saying that this surgery is in the best interest of my patient, but it is also in my financial interest. Is it possible that that's kind of affecting my assessment of this? Because if my financial interest is even clouding my judgment just a little bit, right, isn't that a problem, right? Do I need to maybe take a step back and consider, maybe I need to consult with someone, who I trust, maybe a fresh perspective. So that's kind of where I think the fiduciary duty framework comes in. It's not so much the specific requirements as the idea of the undivided loyalty, right? Just renouncing the sense of self, right? And I think even those of us who are incredibly moral, I think we can't help sometimes, have motivated reasoning. So I always tell my students, whenever you feel like this is the absolute right thing to do, no question, just take a step back and say, okay, but is there some reason that you might be so inclined to think this way, besides the love of your patient or client, right?
And I, with all due respect, Dr. Kuris, I mean, your premise was if you did surgery or didn't do surgery, the financial effect on you would be the same. I mean, so no Christmas bonuses. Think, National Lampoon's Christmas Vacation. No profit, no profit sharing, no incentives. And even, on a non-financial basis, if you're not doing a lot of lucrative things for your employer, bad things can happen to you, and they may not be much, you may not understand it as connected or not. So, I think it's more complex than that. But other comments or questions? Anybody else? Yes, Dr. Krizoff.
I was really struck by your use of the concept of legal relationships. As a physician, now a retired physician, I've been struck that in our field, long-standing relationships and really knowing the person as opposed to knowing the individual disease that they have really withered. And I'm curious to what extent that currently exists in the legal field and what suggestions you have to actually strengthen long-term relationships in the medical field.
No, that's a fantastic question, and I have very much the same concern in the legal field. So currently, I would say that in most lines of legal practice, not all, but most lines of legal practice, the most important, I think, element of success is your relationship with your clients. Whether we're talking about big firms, small firms, medium-sized firms, you have to have a good relationship with your clients. at the end of the day, law is still a reputation business. And it's your ability to leverage your personal network and what sociologists call social capital that often determines your success as an attorney. So if you don't have those personal relationships, you're not going to be as successful in the legal profession. That being said, I think there is a concerted effort, somewhat well-meaning, to kind of replace that relational model with a more kind of commoditized delivery of legal services. Namely, why do we need, then I had hosted a conference years ago on this, and there was a great debate between Professor Luban at Georgetown, was the leading philosopher and law professor, and Sam Eichstreicher, who was a labor and constitutional law professor at NYU. And anyway, the Crib Notes version was, Professor Luban gave this great story about how we went to talk about a will. He and his wife went to talk about a will with their lawyer. And the lawyer brought up all these things they never thought about, right? Disability and the children's disability, things along those lines. And it was very moving to them. And it really kind of made them think about, their passing in a completely different way and what they wanted to see happen afterwards. And Professor Eichstreicher's view was like, yeah, that's all nice. I love to have new friends and them to learn all about me, but at the end of the day, I just need a job, right? And I think we're kind of moving that direction. You see that with automated providers of legal services like LegalZoom, which some of you may have heard of, that advertises quite a bit. So I think there's kind of a push. Do we really need a lawyer who's got a relationship when at the end of the day, all someone wants is a legal document? And I think the hope is the document is, if you don't have the lawyer with the relationship, it'll be cheaper, more people will get help. So they kind of focus on the bright points, but they forget about you're losing the human element. A lot of things might fall through the crack without the human element. And not to mention that lawyer can also maybe connect them to other services they need. So I fear that we're kind of moving the same way in the law. Do I have any suggestions how to forestall it? My only hope, and I don't know if this is a hope or maybe this is dystopian, is that maybe we become disillusioned with technology, and with some of the kind of, shall we say, automation that we've seen in general, that we kind of start to question whether what we've lost, right? So that's kind of my only hope, because otherwise I fear that we become so disconnected from each other that it's going to be very hard for the professions to hold on to the historical ties they've had with their clients and patients. So sorry to leave it on a kind of a sad note there, but I'm not optimistic.
Let me tell a little story of my own experience. I started practicing law in 1975 at a major law firm in Washington, D.C., Arnold & Porter. And when I started practicing, clients would never question a bill. They would never leave the firm to go somewhere else. As far as they were concerned, they were so grateful that the firm had agreed to represent them. By the time I left practice 9 years later, that had changed. And so, for example, we began to, well, certainly they questioned their bills. If we flew, we had to give them our frequent flyer, the client our frequent flyer miles. And most pernicious, they would shop for lawyers. And so they would go around and sit in your conference room, and you would have to tell them how you would handle their case and what you would charge them. But the trick was not to give so much away that they could then take what you had told them to a cheaper firm. And it was a complete transformation and among other things, senior partners who used to be paid on just an equity basis for showing up at the drinks, at the cocktail hour, were now being paid only based on billable hours as well as the junior associates. So I don't know, what's happened since 1984, but my sense is it certainly hasn't gotten any better in the sense of long-term, that sense of long-term loyalty. Dr. Frizoff, do you have a question? You have a microphone.
I think the other part that's fascinating to me, I remember when they started advertising lawyers with billboards. I just came back from New Mexico, and about 50% of billboard ads on the highways were for accident lawyers. I think that marketing, we talked earlier in this meeting about the $30 billion spent per year in institutional marketing, drug company marketing. I think that marketing in a certain way makes us into consumers rather than having serious relationships. And I think that's something that we really have to address.
I have a question for you, Mylan, and that is the enforcement of the lawyer's fiduciary duty, the policing and the sanctioning. You mentioned that it's done by, you know, it's so one of the questions that I have had about medicine is why haven't the state medical boards done a better job of enforcing this duty of fidelity? And in fact, some years ago, I did a study of all of the disciplinary actions brought against physicians by state medical boards. And the first thing was it was almost impossible to tell whether a disciplinary action was related to a breach of fiduciary duty or you know, professional standards. The primary reason was sort of poor medical record keeping or substance abuse. And I just and for those that were associated, there were just very, very few that I could identify that you could say the state medical boards were enforcing this duty of fidelity. How come does law do a better job, do you think? And if so, how come? And if so, in 25 words or less, are there any lessons for medicine to learn from that aspect of the picture?
Yes, so I would say that in general, disciplinary bodies, but medical, legal, what have you, they look for the low-hanging fruit. So if there's a cut and dry thing that you can get someone on, you're going to want to focus on that versus applying standards, which can be open to interpretation. What I think is the kind of the ingeniousness of the approach of the rules that we use in the legal profession, and because we're lawyers, right? We take these standards and we kind of made specific rules out of the standards, right? So you see fiduciary duty kind of principles throughout our ethical rules, even though not specifically defined as fiduciary rules. So I mentioned the unreasonable fee thing, right? So when you have a principle like do not charge an unreasonable fee, you're incorporating a standard, but you're allowing something for like a comparison, right? Well, what are other folks charging? So I think that was kind of maybe the ingeniousness of our approach that maybe allows for a little bit more enforcement of these duties. So I'm not sure if that is possible in the medical profession, but I do think some specificity where you can incorporate principles as part of some of the obligations can be helpful, and it makes it easier for regulators to actually apply these principles.
Professor Silvers, and I think that we should take a break after this. So
try to make it fast then.
No.
The title of the session, I like the alliteration. It works very nicely. The morals of the marketplace, and I get what you're driving at. But most of the time, morals are an individual thing. So part of what we're talking about with lawyers is, are they being moral and following their fiduciary interests and all that? When we do the translation to the health field, I think there's, at least in my mind, there's a difference. When we think about quality, and we've had discussions about malpractice, for instance, on this, the illusion that it's one person that's screwed up is clearly wrong. It's a system that's screwed up. You know, multiple people had to fail for somebody to get killed in most situations. So it's an organizational question in healthcare, I think, more than in the legal profession that we're worried about. So the question I had was, do we need to be thinking about this, the morals of the organization rather than the morals of the individual or the morals of the marketplace? We can have a morally sound organization doing the right thing for the patient by designing that system better, by rewarding people, by not pressing too much for volume, getting paid for RVUs and independent or whatever. Isn't that the place really where the translation is really important to think about the differences between the two?
No, I think that's a very important point, and I think also holds true for the legal profession. A lot of the problem is at the organizational level, right? I mean, most attorneys do work in firms of some size. You often see breakdowns in firms that lead to, for example, unethical conduct. But the reason I kind of like the morals of the marketplace principle, and I think is not necessarily consistent with what you're saying, isn't the problem that organizations think of themselves as, and let's say hospitals or what have you, that is to just think of themselves as any other kind of providers of services operating in a marketplace, right? So yes, we offer medical services, and other organizations offer different types of services, and yes, we may be nominally a not-for-profit, and they might have for-profit structures or what have you. But at the end of the day, we're a business, we're run like a business, and we operate in a marketplace, right? And if that's the ethos that an organization has, I would submit to you maybe that's the original sin, right? So if you operate as a principle, well, we're in a marketplace, we're in a position that operates in a marketplace by the morals of the marketplace. I think it's kind of hard for the individual doctor to really do much about that, right? It's the organization has to think of itself as not part of a marketplace, but part of a community, right? Where it is not just servicing people, but it is essentially has the lives of individuals in their hands who are really at their mercy, right? And I just think that's a very different way of thinking that medical professionals and legal professionals need to have. And then organizations with which they're affiliated, they need to have.
All right, I think on that note, let's thank Professor Markovich. Thank you so much. Really appreciate you bearing with us on the technical side, and again, I think all of us wish you best of health.
Thank you, everyone. I really enjoyed this, and I hope to see you again in future years.
Thank you. And I'm going to be talking later today about the fiduciary duty of physicians, so if you can possibly, listen in, I think it might be fun. All right, let's take a break. We're running a little over, but let's take a break until just about 5 minutes to 3, and then we'll have our medical student perspective, and then we will have a couple of other things after that. Okay? Thank you very much.
My bride said she's going to give away so when would you like to vote? Let me find out right now. Just let me know and I'll send her a bottle of wine.
Just all sit.
Oh, you were the eternal socialist, aren't you?
Yeah, I'm not that concerned. I don't think it got into it.
The thing about it is, today's world, we can't have honest debate. We hear that.
To a lesser extent. Yeah.
You can't have a good discussion.
And Anna, did you figure out the sharing of it?
And so all the knowledge.
I never would have guessed.
showed that the cost of attendance was the primary barrier for Black, Hispanic, and Native American students from applying to medical school who were apparently qualified in their education. Additionally, the number of medical students whose families come from the lowest 40% of household incomes has been steadily declining from about 27% of medical students 50 years ago to only 10% in 2004. So how did we get here? As you can see on the next slide, there have been climbing amounts of debt. The average medical student indebtedness has increased over time at a rate higher than that of the Consumer Price Index and at a rate higher than the rate of increase of average physician salaries. So by 1984, financing medical education had already become loan dependent, with over 86% of students graduating in debt. We're going to take a look at the forces that led to this shift towards high levels of loan debt, which have continued to rise rapidly over time. So currently, the current mechanisms for student educational financing may not be able to withstand the debt levels once a certain ceiling has been reached, which Gabby has already mentioned as with the trends increasing. So currently, nearly 25% of graduates owe over $200,000 and nearly 10% owe over $250,000. So that exceeds federal borrowing caps. So in terms of the primary forces that have caused this increase, one study proposed, once looking at the history of medical student debt, that there are two expanded missions of the medical college that caused this increase. The first is the research university model. A research university is an institution which integrates teaching and research, establishing academic inquiry as a primary mission. That mission often requires state-of-the-art research facilities, and in essence, these federal initiatives helped academic medicine to expand its role and capacity, but it didn't enable long-term financial solutions. And so as medical education becomes more complex, more expensive, more technological, a lot of that cost burden has been falling onto the student. So in addition to the research university mission, another expanded mission of the medical school is the clinical mission of academic medical centers. As clinical education became more of a part of the medical school education, that increased the budget of medical schools. So currently there are no standards for cost of medical school attendance, and these can vary dramatically between schools in the same locality, and they also vary dramatically between region of the US. There's no consensus on what the true cost of educating a medical student is, so that limits the accountability to students in society for these costs. So what we're basically saying with this historical lens is that if medical school education, the cost of it continues to be tightly linked to the research and clinical missions of academic medical centers, then you're going to continue to see this explosive rise in the cost of medical tuition, and it's unclear whether those cost burdens should fall to the student.
All right, so now that we have some background on the debt statistics and how we got here, I'm going to talk a little bit about the burden of debt on medical students and early career physicians. So first off, the burden of debt is not evenly distributed, and there is a gap in the debt burden across races and ethnicities, with 91% of Black medical students graduating with debt, 84% of Hispanic medical students, 75% of white medical students, and 61% of Asian medical students. So clearly there is a gap in the amount of debt that different students are taking on after medicine or during medical school. Next slide, please. We can also see how debt is associated with academic performance and perhaps influences specialty choice. So in academic performance, there were systematic reviews that noted there was a systematic review that noted a negative relationship between debt and academic performance. And additionally, there was a study that found scores on an internal medicine training exam decreased as debt increased. Additionally, in regard to specialty choice, there was a longitudinal study that took place looking at 5,000 US medical students from 1992 to 2012, and they found that anticipated debt influenced specialty choice according to projected income. Additionally, there was a survey administered to about 800 students at 6 institutions, and they found that the percentage of students that indicated that projected income influenced specialty choice increased while comparing first and second year students to third and fourth year students. Furthermore, the burden of debt is also associated with various components of mental health, physician burnout, and quality of life. In terms of mental health, higher debts are associated with higher levels of self-reported stress. One study found that greater than $50,000 in debt for medical graduates is associated with increased risk for alcohol abuse and dependence. And that was also a study looking at medical students. And another study found that higher debt burden was associated with emotional exhaustion and depersonalization. Looking at quality of life, one study found that greater debt was associated with lower quality of life scores. And regarding physician burnout, a study found that residents with more than $200,000 in debt were associated with higher degrees of burnout compared to students without debt.
So the impacts of debt go beyond like the individuals that have it and also reflect on professionalism in medicine in general. So just briefly before we talk about that, we want to talk about how we think about professionalism in medicine. So we think about that as the ability to advocate for patients and our peers, the ability to think about the community that one lives in and understand that this learning is like a lifelong process. It's promoting diversity in medicine, it's putting people over profits, it's upholding ethical values, it's upholding a commitment to patient care, it's having this fulfillment in life and career, and it's fostering medical education. So by having all of these high debts, there is this detraction from professionalism. The first way that we see this is that less people might choose primary care and a specialty that they want because of these high debt burdens. Second, we can also see a diverse physician workplace in all workforce in all specialties, especially if certain people have higher debt burdens and that affects the sort of specialty that they choose. There's also the impacts of lack of diversity in medical education. So in general, medical educators make less money in general. So like people who want to go into that profession and go into teaching might not be able to do so if they have high debt burden. And then as a result, there's also less time spent mentoring, teaching, staying updated on research, and performing the sort of advocacy work that we expect from physicians as a profession.
So another important way to contextualize this burden of financial debt has to do with the reason why many of us entered the field to begin with, and that is the ability to treat patients and their outcomes. And so some of the effects of physician burnout specifically, which Ellen talked about, have to do with increased rates of physician and staff turnover, and that especially has burdens patient populations that are underserved. It leads to an increased rates of medical error and malpractice, which affects 250,000 patients that die because of medical error in the United States per year. It leads to increased rates of depersonalization, which Ellen has also mentioned, and just to clarify, that's the feeling of treating patients as problems that need solutions or conditions that need treatments, as opposed to putting them as people first. And then suboptimal physician-patient communication, which includes things like decreased rapport building and a decrease in skills such as providing patients with a full understanding of their condition and available treatments. And so this is really important just because we want to be able to enable physicians, future ones like ourselves too, to best treat their patients. And so understanding the impact that this has on patient outcomes is really important to solving financial debt.
Okay, wonderful. So we didn't just come here to give you a problem. We, like many of you, have been brainstorming solutions to this potential problem as well. So in thinking about where we can go from here, these are some of the solutions that we've talked about as a group and some that we think are maybe some of the best ones that we talked about among many. So the first is that of need-based reduced tuition. So the objective of this would be to increase accessibility to medical school and furthermore ensure that debt is not a barrier to any person in pursuing medical school. This is also a way to target those that are in need in a really focused way. So it's going to go to that population, one, that maybe doesn't go to medical school because of the impact that debt might have on them, or conversely, the population that does go to medical school and is faced with more debt than maybe the average student is during this current time. The second solution we talked about is that of a uniform tuition cap. So this would address the continually rising cost of medical education. We think this is far more beneficial than tuition freezes, which some of you might be familiar with as the current practice at a lot of schools, where when you enter medical school, the school freezes the tuition, so you pay the same amount as a first-year student that you would pay as a fourth-year student. The problem with that is that it still allows medical schools to continually increase this climb in tuition over time. It doesn't keep them at that maximum level of what is, effective to charge for medical education. Our third proposed solution, which might sound a little bit far-reaching, is that of reduced third and fourth year tuition. We talked about this as a means of compensation for medical students who are providing a lot of value in clinical settings as third and fourth year medical students. Certainly they're still there in a lot of contexts to learn, but they are also contributing to patient care and are a part of the care team from that first day they step foot in the hospital or other clinical setting. And then the final solution that we've talked about some that actually is the starting point for this presentation, because we initially said, oh, well, let's just go in there and tell them that medical tuition should be free. And then we started to walk that back and realize that there are a lot of barriers in the way for that. We think it could be something that's feasible one day to potentially make medical school tuition free. Just an interesting statistic for you, making medical school free for all students would only be about 1,000th of what our country spends annually on medical school, or on medicine and healthcare in general. So certainly something worth considering down the line, but we think there are probably a couple of steps between here and there.
Okay, so now that we have our proposal, we did want to address some of our anticipated, I guess, counter arguments or considerations. So the first thing that we anticipated being a question in response to this proposal is, now that we've reduced or capped tuition, how are we going to supplement that lost funding? We have a couple options for this. The first option, and this is a little bit difficult because, as we mentioned earlier, there isn't full transparency about what exactly, how exactly med schools are using tuition. So I think research would be needed to, I guess, solidify whether this would be a possibility. But in general, if we reduce tuition by 10-20% for students, would it be possible for med schools to operate without supplementing that funding or supplementing that lost tuition? Unsure, but that was one of our options. Option number two, potentially the most obvious, would be public funding. And we thought of this from a national, federal level, but also potentially more of a local level, such as the city of Cleveland contributing to Case Med School. A third option, and this one I think relates mostly to our third and fourth year reduced tuition idea, because they are involved in clinical rotations at local hospitals generally, that the nonprofit hospital systems or institutions could contribute to the school, the med school, in order for them to be able to reduce tuition for third and fourth year students. And that could be seen as a part of the nonprofit's community involvement per se. So that was a third option. Our next consideration we had was that debt forgiveness programs already exist, so why can't, concerned med students just take advantage of one of those, because there are quite a few. And this is true, but I guess from our research we had concerns about how effective these programs actually are at mitigating the concerns we presented earlier regarding the burden of debt on med students and young physicians. So I went into some research on this, and before I talk about it specifically, I wanted to note, similar to what we talked about earlier, there was, I guess, a lack of especially in the federal programs, I was surprised not to be able to find specific effectiveness studies on, I guess, how much debt is being reduced by these programs. But there were some, I guess, more focused studies that I found that sort of get to this point. So the first one, I want to talk about state programs first. The Pathman study looked at several state financial support for service programs. And I think from this, there were two big takeaways. The first was that these state programs generally are meant to entice graduates to train in rural or community-based settings. So they're trying to get med students and residents to need-based areas. And this study evaluated many different types of programs, but by far the loan repayment and the direct financial incentive programs were much more popular and effective than a scholarship model, because the scholarship models tended to be more obligatory, and the participants in those programs had to decide much early on, and they were, I guess, more committed with potential penalties to leaving that program, whereas the loan repayment programs and the direct financial incentives provided outs, so the people might lose their loan repayment process, but they were able to, if they weren't satisfied in their practice at that location, they could leave and practice elsewhere. So in combination with that study,
with the idea that most of these state programs occur in rural settings. The Blanchard study does not necessarily evaluate the debt forgiveness programs, but it looks generally at where med school graduates tend to end up. And the overwhelming majority of graduates actually train in private nonprofit hospital systems. So from this research, it doesn't seem, especially in even in primary care and internal medicine specialties. So just given this data, it seems like there's some sort of deterrent that many graduates are not electing to take advantage of these debt forgiveness programs. And I'll touch on that in a bit. Moving to the federal programs, there's several, but I looked at potentially the largest one, which is the Public Service Loan Forgiveness Program, and that's available to a lot of different graduates, but for med students in particular, it's available to anyone working in a nonprofit organization. So this program just generally the forgiveness only happens after 10 years of payments, which is, to me, a limitation in and of itself. So a med school graduate is still paying their loans for 10 years, which obviously can amount to a lot of money. And then in addition to this, the Friedman study discussed the financial impact that med school graduates would have to take on if the proposed cap on this program were to go through. Luckily, so off of this study, that was another limitation I kind of picked up as well. Federal programs are subject to, for lack of a better word, the administration that's controlling them. So for example, in the Trump administration, there was a proposed cap on this program, and they even proposed eliminating it entirely. Whereas in the Biden administration has been trying to expand it. So for these reasons, I think it's very difficult for med students to rely on a federal program like this. And I don't think that it's necessarily going to minimize those burdens associated with taking on the incurring debt over time. Basically, the takeaway here is that while there's a bunch of programs that exist that can potentially forgive debt, and obviously this presentation isn't addressing all of them, but from our research, it's a little bit unclear how effective these programs are at really addressing like what we've presented here as the main problem. And we think that there seems to be some sort of deterrent to med students entering a lot of these programs, potentially because they're located in rural settings, particularly when there are private organizations offering much higher paying salaries.
So looking at our third proposal on offering reduced tuition for third and fourth year med students, I think there are many arguments for and against this. And I think the main argument against is the fact that, med students have to be trained, and there's an argument that because of that, it creates a lot of inefficiencies and redundancy in patient care. So it's really more training than working. However, I think the opposite can also be argued for why they do provide value in patient care, is that they have more time with patients, so we can be supportive of them. Sometimes we just need to lend an ear. And also we can make them feel more comfortable and at ease and help them open up. And we can perform, because we have more time, we can perform more detailed patient interviews, including on health disparities, help identify them, and even propose solutions. And also we can serve as clinical process extenders, so we can perform more in-depth chart reviews, which I can think would be helpful. And also we can perform delegated tasks from residents and attendings, such as performing more frequent checkups on patients throughout the day. And I think also we can write patient visit notes, which can be co-signed by residents, can be helpful. And we can help educate and counsel patients as well, such as on the disease and treatments and whole clinical process in general. We can translate medical jargon or clarify medical jargon that's been used and help identify gaps in patient knowledge, and also counsel patients with regard to motivational interviewing and using those skills that we learned in med school. Med students can also be utilized, I feel in other ways as too. I think there are more innovative ways, such as being health coaches can be helpful, and performing research on health systems and quality improvement projects. And also reduced tuition can relieve that stress. There's that burden of debt that can be very stressful to us med students. And it can really hinder our ability to focus on our education.
And also, another argument for is in comparison to kind of other terminal degree programs, if you look at like PhD students and JD students, there are really more opportunities for them to get compensated in some ways. For instance, for law students, you know, whether it's through your summers or throughout the school years, if you work for a law firm, you can get a considerable amount of money for that. And PhD students, I think, as well, like if you're a TA. But I feel like those kind of opportunities to kind of offset that tuition are very limited, scant, if any, especially since oftentimes med students only get one summer depending on the school. So in conclusion, really, while our proposal might be too late for all of us, a little bitterness in my voice, we hope to inspire the future generations of physicians to focus more on why we really went to med school in the first place, that idea of patient care, and less on that burden of debt.
Questions, comments from the audience? So Dr. Letterman.
So that was a great presentation, and I just have a couple of things I want to either say or ask. The first is that you underestimate the value of having students on the medical services. It's not just the services that you provide, but it's also the environment that you enrich by being there and offering opportunities for education. And when it comes to the Socratic method, for example, who knows less than you do? I mean, it's fantastic to have students on the service. It really makes a huge difference in terms of the entire atmosphere. So don't underestimate that. My second point is a question, and that is there are now a number, and I don't even know how many there are, of medical schools that are tuition free. And so I imagine getting into those schools is exquisitely competitive for a variety of reasons. So do those schools, are their student bodies representative of the underrepresented in schools? How does that work out?
Yeah, so we did look into maybe possibly doing a case study on one of those schools, but I guess kind of the problems that we were facing is that a lot of them are either too new to like really have a good idea of their impact on medical education as a whole, or for example, at Case we have the Cleveland Clinic Lerner School of Medicine, which does have a good amount of diversity, just anecdotally speaking, but its focus is a little bit different than, you know, some of the arguments that we were bringing up. We are concerned primarily with like the lack of physicians in primary care, things like that. But learners focus primarily on training physician scientists. So the jury is still out.
Can you start? You guys the mic, so go ahead, Dr.
Got the mic so I get to ask questions. Okay. A good presentation. First thing I might point out to you is that it sounds a little self-serving. You're not going to get a whole lot of sympathy for a profession where your chances of winding up in the top 2% of the income distribution are very high. So the front-end cost for something that pays off very handsomely relative to the rest of society is not a real great sales pitch. Okay, the sales pitch that you should be making is getting the right medical resources in the right place. Okay, that's what you want. That's what society wants. They don't want to make you more successful or give you an easier entry into a high-income profession. So I think that's the first sort of pitching of the thing, and I think you need to think about. So the question is, if your goal is to try to get medical resources in the right place, where is that? You mentioned a couple that are obvious: primary care, certain locations, maybe things of that sort. And how do you do that? The targeting of those incentives is obviously part of it. So the rural and the Indian Health Service, the rural facilities, the underserved areas are obviously a place we've done that with some success, but not 100%. If you really want to have more primary care, then you target your incentive towards primary care. So people that go into primary care have quicker forgiveness of their loans, get more subsidies, whatever you want to do, whatever mechanism you want to do. Secondly, because you're talking about a long-term horizon here, you don't immediately get rich right off the bat. You get rich over 10 years or 15 years. Spread the loan out for a long time so that the annual cost is not going to make you live in a hovel. So cut the annual cost down to a much larger thing. That means spreading it out over a long period of time. And maybe making the loan forgiveness not just at the end, but along the way. So that as you do more with primary care in an inner city FQHC, you get loan forgiven right then. So you stop making those payments for the intermediate period. You can do some things like that to do it. Third is payment in kind. One parallel that struck me while you're talking, most of the facilities you see around here, except the ones that have been built in the last 10 years, maybe 20 years, were built by a program called Hill-Burton. Hill-Burton provided loans, but it mostly provided grants to hospitals to rebuild after World War II. And that's where most of our older facilities came from. The proviso was that those hospitals had to provide free care to the population at a specified level for a period of 20 years to, quote, pay off the loan. That's payment in kind. So to the extent that you do a payment in kind, the more that you work in a whatever targeted location or profession, the more that you get more forgiven. You're paying it back to society. And once you've paid off that loan, then you can go off and make lots of money if you like. The last point I make is that don't be naive about medical school financing. It is incredibly complicated, and it is way more complicated than you appreciate at this point. Hospitals already do make substantial payments to medical schools to support them, very large, historically incredibly large numbers, for lots of reasons. It's not surprising that VA facilities are always next to medical schools, because they get payment in kind. Part of the teaching comes from free teaching. I'm on the board of Metro Health. A third of the teaching goes on from Metro Health physicians for free. Metro Health is paying the bill, not the medical school, not the tuition. It's very complicated. And lastly, if you didn't have NIH grants and NIH overhead, the whole medical school establishment would completely fall apart. It's completely dependent on that. Tuition is a small part of the whole thing. So that's why you can get away with cutting tuition down, doing the way that we've set tuition dollars has almost nothing to do with what it really costs. It's a whole set of other finances that are much bigger than this. So don't get caught up with making assumptions about medical school. It being very simple. It's very complicated. And frankly, in my view, it's a house of cards. It's not really well done.
Not a question, obviously. But, any response, by the way? If you have a response, please.
I think thanks to your points, there were many of them, so I think I only have a response to one that stood out to me, which is basically that as like a group with high earning potential, our cost of education should be like less relevant, I guess, publicly, or like it's, I think the biggest point that we took away from this is that we'd like lower people with lower socioeconomic status and groups that are underrepresented in medicine to not face a barrier, and that over time the increase in cost has basically made this problem worse. Like we mentioned, basically like in 1971, 27% of families came from the lowest 2 quintiles, and now it's dropped to 15%, and then 2004 it's only 10%. I'm sure now it's even lower than that. And so our concern is that if debt forgiveness does offer some solace, I guess, psychologically, but it doesn't really help those students for whom, for example, federal loans are not going to add up to the tuition costs as we continue to increase them.
Make it bigger.
And I think basically our concern is just that as we see, the biggest burden is still cost for students that are underrepresented in medicine, and that's why one of our proposals was a need-based program, so that focuses on giving grants to those students for whom cost would be a burden.
Ladies, a wonderful presentation. I'm a graduate 30 years ago of Georgetown, at the time the most expensive medical school in the country. Don't know what it is now, might be Case. I also went to an expensive undergrad school, But upon my graduation from med school, I decided to join the Navy because I didn't want to pay. I knew what was going to happen. That being said, what looks like it's happening in the academic centers, I think what we could ask maybe to do, and when you go into politics, as the attorney among you will say, you have to give to get, right? And I think one thing that you might propose is some of those NIH grants, instead of going to overhead and all the nice new buildings the university is doing, that a higher percentage of it be applied to tuition for students. I think we can all agree on that. One of the other things that I think needs to be done is that we need to expand state medical schools, not private medical schools, but state medical schools. It just needs to be done. The private schools are just going to always have trouble keeping up, but the states need to be convinced to expand the opportunities for students. I think one of the other sad things that's developed is the gap year. I think it's many people just become scribes, and I really don't think that's a useful exercise. I think people need to be pushed into medical school, but the other end is the problem too. There's no GME. How many of your graduates now cannot find a spot after you're done with your medical school? And this, I think, this is where it comes in with the politicians and getting into Washington, D.C. People need to, there needs to be a program to change the federal program to allow people to go right in after medical school and work in the underserved areas and immediately start taking away tuition. We need well-trained people to be in the Indian health clinics, the rural qualified medical clinics, the urban clinics. Those are the things that somebody needs to take, and it's going to be medical students that do it. It's not going to be us doctors. I can tell you after 30 years I'm tired. And this is my hobby, is coming to advocate for physicians. This is what I do. I work 40 hours a week. The other 10 hours I'm advocating and doing different things for physicians. And so it's medical students who need to go to your congressman, find a sympathetic ear, and go to Washington, D.C. It's never going to happen any other way.
Let me throw in a few extra comments. For me, this is more a cultural issue than it is a detailed policy issue. This nation has, especially in the past 50 years, been reluctant to reward service. It thinks of marketplace as everything. The National Health Service Corps was founded in the early 70s when there was still more of a service approach, but for political reasons that I don't really know, it never expanded to the degree that it should have expanded. My son is a lawyer. He graduated law school about 8 years ago. He is in the public service, loan forgiveness. He's working in public service. He understands that the 10 years are very much worth it. The public service always pays less than the private service, and so he's happy with his career decisions, and the 10-year payoff is reasonable. So I think that, and this is complex, and other people know a lot more about the policy details, but I think that ultimately this becomes a cultural issue. I think we have to push service over marketplace mentality, and if we do that and look at it in a longer time schedule, time frame, I think we can move in the direction we need to go to.
Congratulations on a job well done. I was glad to see the lawyers and the doctors working together, because that's what the conference is all about. I don't know whether your proposals will make it or not make it. I don't know if they're good or bad, but at the end of your conference, at this conference, really the question always is, what are you going to do next? And one of the things that you see with good ideas is they stop too soon. You should take your proposals, whatever they are, to both organized medicine and organized law in resolution fashion, and try to get some support for them, and then take them to the state level, and then keep pushing it until you're beaten or you prevail. That's the hard part, is now you got to go to the next step. You have, I don't know, the ideas are good. If they're good, they'll go. If they're no good, you'll get beaten at some point, but you got to take a shot. So go forward and do the next thing.
Thank you. Question, comment? Go ahead.
a comment. I have 43 years experience in working with people with student loans, and I'm aware of the problem. It's the biggest problem we have in the country right now. There's over $1 trillion owed in student loans. And I was around during the Vietnam War protests, and students on campuses, medical students, law students, undergraduate students, put an end to the war because they took steps to do it. And if you guys are really serious about doing something, you have a great presentation, but it needs to be communicated, as the doctor said, to the politicians. It's a political issue, and only the politicians can solve it. You have some great ideas there on what could be done, but you've got to, as Bob says, you've got to act on it. And by acting on it means you have to relay this information to politicians, to lobbying groups that have impact on politicians. For example, the car industry has lobbyists in Congress, and those lobbyists have some power. And if you're going to be paying student loans and you can't buy a car, that affects the car industry. If you can't buy a house, that affects the housing industry. And Congress will act when they become aware that the economy is affected by the quagmire of student loans. And the presentation you have, the information you have, for example, that people, I'm aware of the matching format, that you all are aware that people are going into urology, the other specialties, and not into opening up a general practice because they can't afford it. They've got to go for the highest paying because of their student loans. So the student loan issue impacts a lot of things. And inside your presentation, I thought it was fantastic. There are a lot of items there, but you have to, as Bob says, take some steps if you're serious about it. And not only you, but other schools. I'm sure there's other people, you're up there, and I'm sure there's other people at other universities, at other law schools, and other medical schools that have the same problem. And if you could work in unison, be activists, and that's what I think this conference is about, being an advocate, being an activist, taking action. And I just echo Bob's comments, is don't stop here. Keep going with it, and good luck.
And comment or no? And just to point out, the topic of tomorrow's conversation is where to go from here, how to not just have a conference and say, how do you do? So, keep those ideas in mind for tomorrow. We have a comment from a person remote.
So Fred has a question. I think he's going to come up on the screen. There he goes.
Yeah. Hi, Fred.
Well, in light of the last comment, I wanted to ask the panel, in terms of their proposals, their analysis of the program, what positions, if at all, has AMSA taken?
American Medical Student Association.
We do not know.
Which says something at least about how visible and vocal that position is if they've taken one. But that's a good question. Yeah, and it's one of the things.
For people it was asked in code, in case the others in the audience, AMSA is the American Medical Student Association.
And it's one of the topics that I hope we'll bring up tomorrow, is how do we get these organized groups to carry forward some of the ideas if we agree, or the ones that we think are worth pursuing, and this could certainly be one of those. Where are the power centers? Where are the the forces that can make change?
I did want to make one more comment. Respond. I just want to say I appreciate everyone's feedback. It's been really great to hear all your thoughts. I also wanted to say that I think what Dr. Fisoff mentioned about basically that this is a cultural problem, I think that's one of the big takeaway points that we hope you have from our presentation, which is that the cost of medical school is an underappreciated area of healthcare reform in our country.
All right. Well, thank you very much. So our next, Dr. Batanti is going to return to the podium, so to speak, and present a further proposal. And then I know we had some time for discussion scheduled for this afternoon. We may not end up with very much time for that, but we do have tomorrow morning. And I hope you'll all join us tomorrow to carry on the discussion. But after Dr. Batanti, I will be making some additional remarks. Thank you. You want to talk from here?
Well, thank you. Thanks for hanging around to the bitter end. Not quite. Not quite. Bitter end for me. And I always like talking at the beginning of the show because you can always sell yourself as Jimmy Durante. When you're at the end of the show, you got to be Frank Sinatra. It's a little bit tougher. Anyway, I want to go back and go revisit being on the square, because I think that's what we're really talking about. Are you on the square as a physician to your patients and to your profession? That's really what we've been talking about. Well, to be on the square, you have to deliver on your promise. And we already talked about what your promise is. Your promise is deliver medically necessary care every time. And along with that, we've spoken about you live and die by your professional reputation. And even minor deficiencies on your promise can lead to the allegation that you're a chiseler. Well, I'm going to talk about Youngstown for a minute again because I learned a lot when I lived there, and I think it teaches us a lot now. In Youngstown, there was one individual, Fats Aleo. Now, Fats only weighed 134 pounds, so he obviously got that name as a nickname, which is typical of Italian guys. Everybody got a nickname. I don't know what that was all about, but over the course of four decades, at least 3 decades, they wrote 34 articles about him, all of them citing him as a gambler, bookmaker, blah, blah, blah. And they would had trials and on deposition, right on the record, he said, yeah, I'm a gambler. That's what I do. But they wrote one article about Fats Aleo when they called him a chiseler. And this was the only article that he was upset about because it went to the heart of his character. It was a very, very interesting story when that was told to me about what upset Fats Aleo. Well, there's been plenty of written about a physician's reputation, and one of the best books I ever read really was by Dr. Cathell. It was written in 1903. The book has been derided by some modern authors that said it was really an etiquette book, but it's not. It talks about physician's reputation and what goes to the heart of it. A couple of quotes that I thought were really good. The public opinion is the Supreme Court, and that's the truth. If you have a strong reputation, you'll have a following. If you don't have a strong reputation, you won't. And professional reputation is a physician's chief capital. And the ambition to increase this by all legitimate means is not only fair, but commendable. We talked about it earlier this morning. Everybody's promise is deliver medically necessary care. We talked about what the definition is. Medically necessary care is reasonable and comports with community standard. It's the Sarche is a California Supreme Court case, Hughes an appellate case. I have to thank Dr. Hall once again for illuminating the organizing principle theme, which is if you don't have an organizing principle, you don't know where to start, you don't know where you're going. And mine now, and is going to be in all recommendations I make, that the delivery of medically necessary care should be every time, on time, by the appropriate provider, and adequate reimbursement made to the provider to assure his or her availability to the next patient. We talked about if you don't deliver on your word, you've been gagged. That's a Youngstown term, that you've been duped, you've been cheated. I wasn't going to do it, but I'm going to do it. I'm going to use my mother as a prop. My mother's here. She's 96. She has proven osteoporosis. She has a thoracic compression fracture. She's been on bone-sparing agents for 10 years. 5 years ago, the recommendation was made she get that same agent, and it was denied as medically not necessary. Now, how is that possible? I'm sure if I met that physician reviewer that did that, the first thing I would hear is, I'm Dr. So-and-so, and they'd have a coat on with a lot of embroidery, and I'd get to hear about his or her CV. I went to school here, there. I'm double board certified. I did studies. I lecture. The problem is that you just gagged my mother. If you gag my mother, I'll bet you're gagging other people's mother. And you get away with it because you do it in private. And that's what we're going to talk about fixing. Well, the question, if somebody recommends medically necessary care and there's a opposite opinion, it's not medically necessary, who should decide who's wrong? Somebody's wrong. Should it be an administrative appeal? Should it be an independent review? Should it be civil litigation? Should it be class action litigation? What's it going to be? Professor Hall wrote about this years ago. I've hated to burden him all day with his own literature, but it was really quite good, in that he said the one thing that it shouldn't be done is by civil litigation. And I agree with that completely, but maybe for different reasons. Number one, it only solves one person's problem at a time. The second thing is, for that one person to get that done is going to require an attorney who has an interest in medical necessity cases, and there's not many of them. Then beyond that, it's going to have to not be an ERISA claim, because there's going to be no money in an attorney taking an ERISA claim on a medical necessity allegation. So how are you going to solve this then? You're not going to do civil litigation. You're going to go through the appeals. If you go all the way through an independent medical review, you still have a 50% chance of not getting the recommendation. I think a case that came out in California last year is maybe portends a future resolution about how this determination is going to go, and solve the problem of hiding behind the screen when you make a recommendation. In the case Bradley versus CVS Pharmacy, a physician sues a pharmacy for not filling his prescription. The court said, you know what, we could deal with this, but we're not going to deal with it. We're going to impose primary jurisdiction doctrine and send it to an administrative body that has special expertise in pharmacy and drugs and these kinds of issues, see what they say, and we're here to listen to the answer if you don't like it later on. But we're going to show judicial deference to administrative expertise. They cite Business and Profession Code section 733, and they send this case to the pharmacy board to be looked at. So, what's 733 Business and Profession Code say? It says no license shall obstruct a patient in obtaining a prescription drug or device that has been legally prescribed or ordered for that patient. A violation of this section constitutes unprofessional conduct by the licensor and shall be subject to disciplinary or administrative action by his or her licensing board. Unprofessional conduct. How about on the other side of the coin? Business and Profession Code 725 says repeated acts of clearly excessive prescribing, furnishing, dispensing, administering drugs or treatment, repeated acts of clearly excessive use of diagnostic procedures, repeated acts of use of diagnostic or treatment facilities determined by the standard of the community is unprofessional conduct for a physician and surgeon, dentist, podiatrist, psychologist, therapist, chiropractor, audiologist, speech pathologist. So it's one or the other. You were clearly prescribing more than is necessary by the community standard, or you were obstructing somebody. Either way, it's unprofessional conduct. So there it is. Somebody is going to be found to have committed unprofessional conduct. The medical board has special expertise in the standard of care. They do it all day long. They get referred cases by clients, by patients, by agencies, by insurance companies, by government. Anybody can make a complaint to the medical board. A physician could file a complaint, or the court could refer and could use B&P 725 or 733 to find unprofessional conduct on one of the parties. When there's a finding of unprofessional conduct, it's going to harm a professional's reputation for eternity. There's no hiding. It's going to go on record. It's going to be there forever. There's going to be no CV, no lab coat, no resume, no title to wipe away the tarnish of unprofessional conduct. It can be found to be theoretically on the prescriber, the person denying care, supervisor, any license holder, and it will make all parties consider their decisions. No one is going to walk around their office, hospital, clinic, neighborhood, or country club with the same swag after a finding of unprofessional conduct. So we talked about this. I used Dr. Hall's recommendation to make your mark somewhere in your policy, and here we go again. This was from this morning's slide. And at the end here, in a couple places, we see inadequate reimbursement causing medical necessary care not to be delivered. You can see by the appropriate provider. Somebody in the inner city goes to the hospital, they need a neurosurgeon, they need a thoracic surgeon. They say, well, we can't find one. You get one time. He's a Medi-Cal recipient, Medicaid. They pay the doctor so bad he never wants to go back again. So that provider is lost for the next patient. So we have this, I made a mistake on the slide. It's an unwilling or unavailable provider. Unwilling are usually in the inner city, rural, chronically poor paying plans, including Medicaid. I consider them one of the worst actors in the medical system because of their lousy reimbursement, and on holidays, weekends, and nights. So you have the denial of medically necessary care due to inadequate reimbursement, and the usual fall guy and scapegoat is the greedy doctor. You heard these young professionals. What do you want them to do now? Now you want to make them work for no money too? They're going to leave with a loaded debt. They got a life they want to lead too. Now you want them to work for nickels for what? Now what? What's the next burden you want to put on them? It's not right. It's not their obligation either. So I want to ask, is inadequate reimbursement a denial or delay of medically necessary care? I think it is. Let's face it, in America, you have to pay for talent to perform, period. You have to pay for it. You want LeBron James to play for the Cavaliers? You got to pay. You want him to play for the Lakers? You got to pay. It's the same in every arena. The first time I really saw differential pay in a bargained contract was I was involved with the electricians of San Diego County. And there was one group of electricians that got paid 400 or, I don't know, 300, 400, 500% more than any other electrician. So I was asking some of the other electricians, what's this guy do? What kind of electrician work does he do? He says, oh, those guys work underwater. No kidding. You're going to get some differential pay to be an electrician underwater. So most hourly workers are very familiar with the concept of differential pay. You want the plumber to come to your house on weekends, guess what? You're paying a differential. You have some service that you want done Christmas Eve, guess what? There's a differential. You don't find that a problem, do you? No, of course not. It's just differential pay. And so far, the usual rhetoric about fixing the unavailable physician to work in urban areas, poorly paying areas, is let's go and get some students from an underserved community and bring him into school, and then he's going to go back to that community. Now, that sounds really nice, but you think that's really going to work? You're going to bring him into school, burden him with $300,000 of debt, and then tell him again, we want you to go back to that community and work for nothing. Come on. You know, that's not solving the problem. That's a fairy tale, and it's got to stop. So, how do we solve the problem of an unavailable physician? We're going to have to pay for it. My recommendation is that all physicians be paid a differential for night, weekend, holiday work until the needs are met. And I say that for all payors, Medicaid, whoever. That's how you make people available to do a job that's necessary. You need them the most in the worst of times, holidays, weekends, nights. And most importantly, a differential pay by zip code until the need is met. It's very easy to delineate a bad neighborhood that has no doctors in it make that zip code lucrative enough to attract people. If you pay enough, you'll get Cedars-Sinai or some other group to go in there and meet the need. And so it's time to do it and pay the piper to get people the care they need when they need it, on time, every time. Thank you.
Questions or comments for Dr. Batanti? Anybody? We will revisit some of these issues, I expect, tomorrow. All right, if not, then let me be the proverbial tail end Charlie. And give a talk I was scheduled to give earlier, but I hope you'll bear with me. Tail end Charlies, by the way, the last plane in the formation, the ones that got shot down more than others, so be kind. I'll wait for my slides to come up. I've got a few slides. Okay, so what can the law do to strengthen the ability of physicians to fulfill their expectation of fidelity to their patients? So let's go back to that meeting in 1847 in Philadelphia. It was 1 year later, in 1848, that a court anywhere in the world first declared that physicians were fiduciaries for their patients. And it was as a direct result of the efforts that began at that meeting 1 year earlier. And originally, fiduciaries in the law were, that status was reserved for trustees of trusts. That goes back to the Middle Ages, actually, lawyers, members of the clergy. And now, for the first time, a court said physicians are, as far as the law is concerned, fiduciaries for their patients. So one way you might think to encourage physicians to act to fulfill their fidelity obligation to patients is to allow patients to sue them if they breach that duty. Hold them accountable, because this is not only now a professional duty, an ethical duty, but it's now a duty recognized in law. But the law has let patients down in this regard. There's an important Supreme Court case in 2000, Pegram versus Herdrich. Let me tell you briefly what happened. This was a case about an ERISA health plan. ERISA means an employer-provided plan. It was owned by physicians, this plan, and they received a bonus at the end of the year if the plan was profitable. And one way to improve the bottom line of the plan was to provide medical care only at facilities, hospitals, clinics, and so forth that were affiliated with the plan, because they didn't have to pay extra costs to others. Now, one of the plan's owners was a Dr. Pegram, and he examined a patient named Herdrich and discovered a large inflamed mass in Herdrich's abdomen. But Dr. Pegram did not order an ultrasound diagnostic procedure at a local hospital, which they could have gotten right away, but instead decided that Herdrich would have to get it at a planned facility hospital, and that there was an 8-day delay to wait to get it there. And it was more than 50 miles away, by the way, from where the patient was. And before the 8 days were over, Herdrich's appendix ruptured and he contracted peritonitis. So he and his wife actually sued Dr. Pegram and others, alleging that they committed medical malpractice by not giving him this diagnostic test in time, but most importantly, that they breached their fiduciary duty under ERISA, because ERISA makes certain people affiliated with an ERISA health plan fiduciaries under that plan. And the complaint that Herdrich's lawyer was making was that, according to the attorney, the bonus feature created an incentive, quote, to make decisions in the physician's self-interest rather than the exclusive interests of plan participants. So what happened is a little complicated, but basically the Supreme Court opinion held that that the plan doctors weren't fiduciaries under some technical interpretation of the ERISA law. But the interesting thing about this case is something that the court added, and it's dicta, which means that it doesn't have precedential value for those of you lawyers. This is what they said. The defense of any HMO, health plan, to a charge of breach of fiduciary duty would be that its physician did not act out of financial interest, but for good medical reasons. The plausibility of which would require reference to standards of reasonable and customary medical practice in like circumstances. Thus, for all practical purposes, every claim of fiduciary breach by an HMO physician would boil down to a malpractice claim. In other words, patients cannot complain about breaches of fiduciary duty stemming from a failure to provide medically necessary care, but only medical malpractice. And this dicta, in this case, was followed by a number of other courts denying patients the ability to hold physicians accountable for breaches of fiduciary duty in similar kinds of situations. Well, unfortunately, the Supreme Court is wrong, dead wrong. The law of medical malpractice, as law students may know, comes from the so-called common law, okay? The breach of fiduciary duty comes from a completely different realm of law, equity, handled traditionally by a completely different judicial system than the common law system that we're more familiar with now, which handles medical malpractice cases. The burden of proof in a breach of fiduciary duty case is completely different than the burden of proof in a malpractice case. In a malpractice case, the plaintiff, i.e. patient, has the burden to prove that the physician failed to provide reasonable care. In a breach of fiduciary duty case, the plaintiff has the burden of showing that the doctor had a conflict of interest. Once they show that, the burden shifts to the doctor to prove that whatever harm the patient suffered was not due to that conflict of interest. And if the physician can't meet that shifted burden, then the physician becomes liable for breach of fiduciary duty. And furthermore, the remedies are completely different. For medical malpractice, we heard before from Sarah about the kinds of compensation that you can get for medical malpractice, a successful claim. For breach of fiduciary duty, the remedy is completely different. It's a constructive trust, which means in the PGRAM case, and this is what the plaintiff in PGRAM asked for, was that the plan beneficiaries, which were the employees of the company that had the ERISA plan, should have been given all of the profit that the plan had made, and the doctors, in other words, had made, because when they were, that could be attributed to actions based on that conflict of interest, the plan bonus features. And so that, to say that fiduciary breaches are the same as medical malpractice is just dead wrong. And interestingly, this was a unanimous decision by the Supreme Court of the United States. All those people came to the absolutely wrong result as a matter of law. Why did they do that? How could they get it so wrong? How many of you have heard of the case Moore versus the Regents of California? This is a seminal California case. Very, very briefly, a fellow, he happened to be from the state of Washington, had a cancer of the spleen. He went to UCLA Medical Center. They diagnosed him correctly. They said, we have to remove your cancerous spleen, which they did. And then they proceeded, the doctors that is, proceeded without telling him or asking him to commercialize the cells that they had removed from him, which in the old days were called surgical waste, and the patient had no concern about it. But here what they did was they commercialized it into an immortalized research cell line, which was worth, millions and millions, hundreds of millions of dollars. And the patient had to come back a couple times from Seattle to UCLA, ostensibly to follow up on his treatment, but actually it was also, or instead to make some, do some things that were necessary for the commercialization of the cell line. And he found out about it when he was walking down the hall at UCLA one day, and he saw a bunch of boxes that had his name on it, big container crates, and he wondered what the heck is that. And to make a long story short, he found out that they were, had taken his cells and were doing this. So he went to a friend of his who was a law student, who then went to a lawyer, who then went to a colleague of mine who had been a visiting professor here, Laurie Andrews, a famous health law professor at Chicago ITT Kent. And together they sued. They put together a lawsuit against the University of California and the Regents, UCLA. And what they sued for was conversion. Okay, that's the fancy legal term for theft. They stole his cells. Okay. So somebody steals your car, okay, and if you, seek redress from them for stealing your car, what do? You get your car back, right? So, and if the thief has put in, a very fancy stereo system, they don't have to give that back to you. They just give you back what they stole from you. So, congratulations, successful plaintiff, or you get your cancerous spleen cells back. Have a nice day. When that case was, shortly after that case was decided, we had a colleague here at the law school named Peter Younger. He was a rather eccentric fellow. He had, before the law school moved into this building, it was over across the street, and you could hear him at the end of the day wandering around because you could bring your pets to school in those days, and he had 2 cats. One of them was good, one of them was evil. So you would hear him walking down the hall saying, good, evil. Anyway, when the Moore case was decided, he burst into my office. And he was spluttering in rage and incomprehension. And he said, why would they sue for conversion? Why would they sue for conversion? They should have sued for a constructive trust. And I said, what's that? Because I had never heard of it. I had no idea. And I went to Yale Law School. Okay? The problem was that I had not taken a course called Remedies. And I didn't know about that was the proper remedy, that he should have sued for breach of fiduciary duty, which, by the way, the court of California corrected and said, don't sue for conversion, sue for breach of fiduciary duty for not getting his informed consent to the commercialization of his cell line, and sent the case back, and it was eventually settled, and that was that. When I heard this from Professor Younger, I called my esteemed colleague, Laurie Andrews, and I said to her, why didn't you sue for constructive trust? And guess what she said? What's that? So the Supreme Court of the United States didn't take Remedies, and they didn't get it right. They didn't understand what should have been going on as a matter of law. We got this sort of principle, albeit a dicta, that you can't sue for breach of fiduciary duty, you can only sue for medical malpractice. And this wasn't the only case that got it wrong, because there is no reported case anywhere in the United States in which a patient has successfully sued a physician for breach of fiduciary duty in the clinical context. Not one. There are a handful of cases where patients have sued successfully for breach of fiduciary duty for inappropriate sexual relations. There are a handful of cases where they've sued for truly outrageous taking advantage of patients financially. For example, physicians who say, I'll treat you if you make me the beneficiary of your estate. But other than that, cases where, like, this P-gram case, where the patient shows, makes a colorable proffer of evidence that they were shortchanged because of the financial self-interest of the physician. None of them have resulted in payment to the patient, okay? Not by the judicial decision. So one, sort of suggestion to make, and how do we encourage physician professionalism, is put the fear of God into them. Get the courts to go back and take, make people take remedies classes and make it more possible for patients to sue their physicians for breach of fiduciary duty. And that was kind of the approach that I took for many years, as Mark Hall knows, that was kind of, we needed to do that. But then I began to think, wouldn't it be better if we didn't think of physicians and patients as adversaries, as at odds, but rather thought that physicians really want to do the right thing by their patients, but there are systemic barriers to doing so. So how can we encourage and protect physicians when they are trying to do the right thing for patients? Okay? But that assumes that we know what the right thing to do for patients is in a specific case. So what about the Moore case? that I just described, right? This immortalized cell line. The Supreme Court of California, it was the Supreme Court, said you should have, the doctors, what they failed to do, fulfill as a legal duty was getting the patient's informed consent to doing this with his cells, and that was a breach of fiduciary duty. So if the doctor had to get the patient's informed consent, think of the conversation, right? I'm going to take your cell lines and I'm going to try to immortalize them. Is that okay? Here's the risks to you, hardly any. Well, presumably the patient would want a piece of the action, right? Well, did the physicians, if the patient doesn't sort of volunteer that, do the physicians have to say, by the way, you should ask for a piece of the action? Is that what they have to do to fulfill their fiduciary duty? Would the physician have to tell the patient, and here's how much you should ask me for? Right? I mean, if you're acting in the patient's best interest, not your own, you might have to do that. If they didn't do that, would the physician didn't do that, would the patient have the ability to, the knowledge and the wherewithal to bargain successfully? Unlikely. Would the physician have to then advise the patient, oh, and by the way, you should consult an expert? And then what about, seriously ill patients, arguably competent to give their informed consent, but not in a particularly good position to engage in a bargaining process, or not able to afford to hire an expert, and so on. So what does the fiduciary obligation, this fidelity obligation, require in that kind of situation? We talked about the Wickline case a couple times today, right? The patient who was discharged after only 4 days. The doctors wanted her to stay in 8 days, but when the California Medicaid program said, no, we're only going to authorize 4, they discharged her after 4 days, and her leg was eventually amputated as a result. As I think Dr. Batanti mentioned, that was a malpractice case where against Medical for denying medically necessary care, and all of the experts, including the patient's own experts, said, it would have been better had she stayed the extra 4 days in the hospital, but that wasn't medically necessary. It was within the reasonable standard of care to release her after only 4 days. So there was no suit against them for medical malpractice, and that was pretty much the end of the case. But the court went on, and by the way, there was no claim of breach of fiduciary duty in that case against the doctors or the health plan. But in famous dicta, the court went on to say, this is, by the way, that case, the court went on to say the physician who complies without protest with the limitations imposed by a third-party payer when his medical judgment dictates otherwise can't avoid his ultimate responsibility, can't point to the healthcare payer as the liability scapegoat when the consequences are his own determination. The payer in this case, as I said, was California Medicaid. So unlikely that if the doctor had protested, had said, wait a minute, you can't, you can't say you're only going to pay for 4 days. The patient needs more, and badgered it or did whatever he could. It's unlikely Medical would have cut him off. I mean, refused to pay him for future care. Medicaid unlikely to retaliate against him. But what if it would have been a private health plan that wanted that patient out in 4 days, and the doctor then makes a concerted effort to fulfill his fiduciary duty, his duty of fidelity? Could the doctor suffer retaliation? Sure, right? Possibly even termination from the plan, right? No, you're no longer in the plan network because you've been such a pest as advocating for your patient. And if the plan has a substantial share of the market, of the relevant patient market, being excluded from the plan could be harmful, if not fatal, to the physician's practice. So how do we protect physicians in these kinds of situations where they want to do the right thing, but they're afraid of being retaliated against by hospital employers, by health plans that they want to remain in the network of, have to remain in the network of? Well, one option that the law has come up with is to limit the financial incentives that are given to doctors to deny medically necessary care. The federal government has a limit on Medicare for Medicare Advantage Part C plans. The plan cannot be qualified under Medicare if it has to make no specific payment, directly or indirectly, for a physician to a physician or physician group as an inducement to reduce or limit medically necessary services. That's a federal law, so that's a step in the right direction. Many states have similar laws. So here's the law from Hawaii. A health carrier shall not offer an inducement to a provider that would encourage or otherwise motivate the provider not to provide medically necessary services. The red states all voted for Trump. No, they all have this law, but you can see there are a lot of gray states that don't. So one of the things we need to do is to get all states to pass this law, this kind of law, so that these incentives, these just conflicting incentives aren't placed on doctors unreasonably. Another thing, every doctor's contract with, I think, a hospital employer and with a health plan has in it, their agreement has in it a provision that their relationship can be terminated without cause, without giving a reason, without having any recourse, without certainly having recourse to judicial review. Termination without cause. They can be terminated for cause, but they can also be terminated without cause. 60 or 90 days notice, pack up your clinic, you're out of here. Interestingly, do you know who insisted on having termination without cause provisions in all of these? It was physicians. When managed care first came upon us, physicians were concerned that they could find themselves stuck in a managed care plan and not be able to get out when the plan was making them do the wrong things. So they insisted on this, but it can come back to bite them because I'm advocating for my patient and I'm being, I'm causing all kinds of grief to the health plan. Guess what, doctor? You're out of the network. And again, may not be able to practice, or certainly not practice successfully. So there are 3 jurisdictions by judicial decision. One of them, the leader, is New Hampshire in the Harper case, that said, if a physician has been terminated without cause and maintains, reasonably convincingly that no, the real reason was that she was an advocate for her patients, the physician has the right to judicial review, and that termination will be reversed as a matter of public policy. Okay? These are the states that have done this by both by decision. In New Hampshire, you see Harper versus HealthSource, and also in a few states by law. Before terminating a contract, the health maintenance organization shall provide the physician with a written explanation of the reasons. That's not quite far enough because they also the physician needs to contest that termination in appropriate circumstances. So we need all jurisdictions to adopt the principle that if the doctor can show that she was being punished for being an advocate for her patients, she can't be terminated without cause. She can at least seek judicial review of that. And then, of course, more straightforwardly, we need to have the courts or state legislatures pass laws that prohibit health plans or employers from, in any other way, penalizing physicians for advocating for their patients. And there are a number of states that have this. Here's Idaho's code. A managed care organization shall permit a contracting provider to advocate for his patient without being subject to termination or penalty for the sole reason of such advocacy. Okay? So again, we need to have this in all the states, the gray ones as well as the red ones. And how good can these protections be, right? Termination or penalty, what counts as a penalty? My thought is that what we should give doctors is the equivalent of whistleblower protection. And that is that is the highest degree of legal protection to someone in a relationship in which they might be subject to adverse, actions, short of putting them in a witness protection program. And these are the types of behavior by, for example, a health plan or employer that are prohibited for people against people who have whistleblower protection. Whistleblowers, historically, they're people who blow the whistle on somebody to the government. But all doctors should have whistleblower protection when they're advocating for their patients, right? No threats, no intimidation. Don't, close the coffee machine, whatever, okay? And what about enabling patients and their doctors to go further and punish the plan if it starts doing this, or if it is imposing unreasonable incentives on doctors. Shouldn't the victims, or the ones who are kind of caught in the middle, the doctors, be able to sue for aiding and abetting a breach of fiduciary duty? There is such a precedent in the law. There is a cause of action for aiding and abetting a breach of fiduciary duty. There are cases, mostly commercial cases. There's a famous one from Connecticut in 2008, where somebody, successfully, you can sue if some defendant has kind of encouraged a breach of fiduciary duty by someone else against you. The problem with that is, one advantage, if there was that ability, was that doctors being sort of, badgered by an employer or a health plan to do the wrong thing for the patient, could say, wait a minute now, if I did the wrong thing, that patient can sue us for aiding and abetting a breach of fiduciary duty, so I'm protecting you, health plan, you, hospital employer, by doing what's right for the patient. The problem is that in order for the patient to bring that suit, there has to be a breach. And what we want is to protect the doctor when she avoids the breach. So what we really need is a cause of action, and I don't think there is one, attempting to induce a breach of fiduciary duty. And that's something interesting to think about. There was another twist in the Wickline case. Dr. Polonsky, the doctor, testified on his own behalf that had his Wickline, his patient's condition, in his judgment, been critical or in a deteriorating condition when he discharged her, he would have made some effort to keep her in the hospital beyond that day, even if denied authority by Medical, and here's the interesting thing, even if he had to pay her hospital bill himself. Is that what he has to do to fulfill his fiduciary duty? Is that what his fiduciary duty requires? How does he know? How does he know? So it might be useful, and Professor Markovich talked about having, fleshing out this notion of fidelity with some more concrete ethical principles, and the AMA, ethics opinions do so to some extent. For example, talking about how doctors, are in a compromised position when they enroll their own patients in research and get paid $5,000 a head for that. But how about some place that the doctor can go to get advice? I've got this patient, I think she should stay in 8 days. The plan is not approving that. Do I have to pay for her myself? And have some expert body somewhere that could provide some advice. And if the doctor follows that advice, even if bad things happen, then at least she has a sort of a presumptive argument. The burden would then shift to the other side to say, well, you still breached your duty of law. Final case is a case from Nebraska, Murray versus Nebraska Medical Center. This was a patient with acute pulmonary hypertension, which causes heart failure. The doctors wanted to order a drug for her called Flolan that was actually approved by the FDA only for the chronic version of this condition. She had an acute version of it, but it was the only possible drug that could help her. They first sought a prior authorization from the patient's health plan. And by the way, going back to our historical overview, an important change that happened starting with the growth of managed care was a shift from retrospective utilization review to prospective utilization review. So what used to happen is that the doctor would treat the patient, bill the patient, or bill the patient's insurer. The insurer would then decide whether or not the care the patient received was medically necessary or not. And they might deny payment of the claim, but guess what? The patient had gotten the treatment. She's still alive. Prior authorization was the method that increasingly managed care came upon, which is, before the patient gets the care, we're going to have to give our permission, which raises the threat the patient won't get medically necessary care. So the doctors at the Nebraska Health Center asked for prior authorization, and it was important to get it not only to start the drug, but to get some sense that she could continue on it, Because once you're started on Flolan, if it's discontinued, you die. Fatal, just like that. And furthermore, that drug at that time costs $100,000 a year. So patient's not going to be able to pay that. We have to make sure that there's some third-party payment. The doctors sought prior authorization on June 29th, 2006. It's unclear from the case if they ever received it, but in any event, they hadn't started the medication when 11 days later, the patient went to the emergency room and died. The patient's family sued for malpractice for not starting the drug earlier, and the court held that it was within the standard of care to wait for the insurance approval, because if they had started the drug and they didn't get the approval, they would withdraw the drug and the patient would die. Kill your patient by taking. So, Supreme Court of Nebraska got that wrong. But the interesting thing in that case, to me, is that there's no indication that the doctors did anything besides wait to hear back from the plan. They filed a request for prior authorization, they waited, and 11 days later, they hadn't heard, or they didn't, act on it, and the patient died. Should they have done anything more? Could they have done anything more? Sure, they could have pestered the insurer, right? Don't just sit on, just sit back for 8 days, 11 days. Bug them, call them once a day, call them 10 times a day, right? Have you made a decision yet? Have you made a decision yet? They apparently didn't do that. They work for a not-for-profit hospital system. Ask the hospital to cover the care, at least initially, as part of its community benefit obligation under the tax laws. Ask the drug company for a compassionate IND, right? Give it to my patient less expensively or perhaps even free because it's life sustaining. But they didn't do that, okay? And raises the question of not only did they commit malpractice, but in failing to do that, weren't they also breaching their fiduciary duty to the patient? But there's another point I want to make about the Morty case, and that is, as Dr. Frizoff will remember, he invited me to give a talk to a bunch of progressive primary care physicians in Cleveland, a house talk. And I talked about this case, and I went through the same thing I just did now, asking them, what could you have done what could those doctors have done instead of sitting on their hands and letting the patient die? And, there wasn't much answer to that, so I gave my answers, the one I just gave. And one of the members of the audience raised her hand and she said, "You don't understand, Professor Melman. We don't have time to do that. We don't have the ability to do that kind of advocacy for our patients because of the pressures, time pressures. We have to see, 20 patients, whatever, half a day. We don't have the time to do that." So we need to facilitate the ability of physicians to advocate for their patients. One way, perhaps, is Dr. Batanti's billing code. If they get paid for it, maybe they can say to their hospital employer, this is earning money too. You talked about the present, how they have to rely on so much of their staff to help file disputes in medical necessity determinations. I'm curious what kinds of people are doing this process for the doctors. What is their background? What is their training? Are they trained to be advocates for their patients? I doubt it. I think they're more like, office people, billing people, and so on. So it would be good if we had a cadre of health professionals who were trained to be advocates for their patients and could assist the doctors in doing this. And the doctor would provide the medical rationale to this person. Let's call them a medical advocate. And that medical advocate will be trained in how do you fight the insurance company? How do you get an external review? Know the steps and know how to do it and take the responsibility for doing. And you have, medical advocate, a fiduciary duty to that patient as well as the doctor. So I gave a talk about this a number of years ago at Widener in Philadelphia. And afterwards, a bunch of people in the audience came up to me and they said, we graduated from Sarah Lawrence, where we have a master's in patient advocacy. And, this already exists. They're patient advocates. The hospitals have patient advocates. And I said, okay, so you're a patient advocate and you're working at a hospital. You encounter a patient, clearly has been mistreated. Do you feel able to say to that patient, you need to hire a lawyer and sue the hospital? And they said, I can't do that. That's not what I'm talking about. I'm not talking about patient advocates. I'm talking about we actually have a set of professionals. They're independent patient advocates, but they are paid by patients, and not every patient can afford that. They're great at what they do, but we need to have a cadre of health professionals assisting physicians, helping them to do the right thing, who are not paid by the patient, but are paid by who? Health plans, the government, accountable care organizations who have medical teams have to have one of these people as a member of their team, and so forth. So one idea is perhaps a new training program is needed. Maybe the independent medical advocate training programs are adequate. I don't know enough about them. I want to look into them more. And an interesting question is who certifies them. Right now there is an entity called the PAC Board, which certifies independent patient advocates, but they also certify the patient advocate who can't tell the patient to sue the hospital. And I just wonder, how good are they at preparing patient advocates to do the right thing, when push comes to shove. So, a number of ways, I think, in which the law can take a role in helping physicians to be able to be advocates for their patients, rather than thinking about punishing the physicians who don't do the right thing. Let's think about how can we support and encourage physicians to do the right thing. Can law help save medicine? Thank you. So it's kind of late. I'm sure we're all kind of tired. One of the things we had originally saved a chunk of time for here was other ideas, because there are lots of people both participating remotely and listening who probably have all kinds of additional good ways that we can move forward in this direction, assuming, I hope, that we all agree that it's a good direction to move forward in. I think what I'd like to do, though, just unless people have strong objections, is to table that discussion till tomorrow, when we can reconvene, I believe at 9 o'clock. I have to look at my schedule. And talk about, additional good ideas. Yes, 9 o'clock, breakfast from 8 to 8:45 as it was today. Talk about any additional good ideas that anybody would like to throw out. And then, where do we go from here? Very nice having a talk with you. But as we told medical students, don't stop here. So how can we keep going? All right, so with your permission, I will, is anybody outside who, no, okay, so anybody have any comments or thoughts, by the way, on my talk? Oh, yes, Dr. Batanti.
Professor, I love the idea of medical advocacy, but I think it goes back to when that physician at Dr. Freisoff's event, when they told you we don't have the time to do it. I think they probably left off the second half of the statement is we don't have time to do this for free.
We're not getting paid for it. Yeah.
So, whether you have another trained individual to do the advocacy, there still needs a mechanism for that to be paid for, and that's independent from taking care of the patient.
Right. So your billing code would be accessible to the medical advocate as well as the physician. Right? They would be able to bill for that, for those services as well. Just like, as somebody mentioned earlier, doctors, never used to have, rarely had end-of-life decision-making conversations with hospitalized terminal patients because there was no billing code for it. And when Medicare a few years ago instituted for the first time a billing code for that, those conversations began to flourish and were critical to patients and their families. So a great idea. But let's make the medical advocates also able to bill under that, or incident to or some other configuration. Let's have the doctors fulfill their advocacy responsibilities, but let's help them do it. Let's protect them when they do it. Let's give them the resources to do it with as well. All right.
Professor?
Yes.
In California, we have two anti-retaliation statutes. One, Business and Profession Code. The other one, in Health and Safety Code. The problem is that the penalties for violating those are so anemic that they count for nothing. I think the penalty for retaliating against a physician is like $500 or some ridiculous thing like that. And people say, well, how much do you think it should be? I said, well, this is a public safety issue, the same as when a health group, a group of doctors, don't report one of their own that have been settled out for more than the reporting requirements of the medical board, is a $100,000 fine.
Failing to report a colleague for medical malpractice.
Right. So why $500 against somebody for retaliating? The other thing was in the health and safety codes, it's equally as anemic, and I think both of those should have hefty fines as well as statutory attorney fees.
One of the things that our postdoc, Rebecca Smith, helped research for me was looking into what are the penalties for violating those state laws that I described for you. And again, they're very, very weak and very nondescript. All right. Without more than thank you all very much. Those of you who are joining us for dinner, dinner is at 6:30. It's nearby. It's a block from the law school, but more importantly from the Glidden House. So what I'd like to do is I will meet you at the entrance to the Glidden House at about 6:26 and walk you over to the Tinkerville Student Center where the Michelson Worley restaurant is located, where we will be serving for dinner. Okay, so between now and then, enjoy the University Circle area. I hope it's not snowing out there. And dress for dinner, by the way, doesn't have to be formal. I suggested bathing suits, but Patty Harville said no, you probably have to have long trousers. All right, any questions? Well then, thank you very much. Thank you for the people who are participating remotely. Thank you for our remote experts and our present experts. And I'll see you all tomorrow morning.
Ouch. Cars in I can like about 10 minutes away, so the point could be minimal. I'm sure he'd probably just give you the whole presentation.
Well, it's also recorded, so my second option was going to be updating the recordings at the end of it. I might just ask him.
Well,
How are you?
more science aside, there's
Good job.
I know. They want you to quit school and get out of it to the legislature.
It sounds like a lawsuit. I don't care about their tuition.
Good job. Good job.
Thank you. Thank you.
And so what you need is a level requirement, and then the
All right, come on. He's exactly who I thought he was.
yes. Okay.
It's a substantial portfolio.
Yeah. He's a great guy and a great leader.